Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, good morning, everyone. Day 33, and the day that I think we've all been waiting for in the Karen Reed welcome. You know, I'm Linda Kenney Baden, and this is Justice Served TV. Michael Bryant is either on his way there or there. He left very early this morning because obviously no one kind of knew until Wednesday exactly when we were closing. We were hoping that the court would be so kind enough, if you were an attorney in the case, you would want this to start on Monday so that the jury was rested and tired. Although I think the jury did have a day off. And interestingly enough, we started with 18 jurors and we still have 18 jurors. And I think that's because, as you all know, people now want to sit on high-profile cases once they have been chosen. And Massachusetts, it's like New Jersey. New Jersey does not know or does not tell or does not even decide who the alternate jurors are going to be until after the case finishes, unlike California. I think that's the better way to do it. That way, everybody is listening really, really intently. And also, you know, if you're an alternate and you know you're an alternate, maybe there's a reason that you just want to get off the case. Why should I spend weeks of my life just sitting here? But all 18 of these jurors have said, hey, we want to serve. So what will happen today is after we have openings and closings, and the judge has not yet decided on some of the jury charges. Now she may have and emailed them back and forth to the lawyers last night. We won't find out today. There were still some things up in the air. There will be closings. The prosecution will go last on the closings, and the reason for that is that the person who bears or the entity who bears the burden of proof always has the final word. Now, in some states, just like Jersey, like Massachusetts, you close, and the defense goes first, and the prosecution goes last. And in some states, there'll be an opening by the prosecution, an opening closing, I should say. Then the defense goes, and the prosecution gets a rebuttal. So every state is different, and every state has its issues when you're a defense attorney, because if you are going first and the prosecution is following you, you have to anticipate any arguments they will make and then ask the jury to remember what you are saying to them through the prosecution's argument. And then, of course, there'll be a break in between the closings to give the jurors a break. And we've learned how important that is, right? We learned from the interview by Aidan Carney, who, by the way, was found not guilty yesterday of violating the restraining order against Lindsay Gaetano. Basically, it's clear to me the judge found that it was a setup. He didn't say that, but he found that that was a setup, that Aidan had left 19 seconds after she got into the courtroom, that they think that it was a setup for the family to bring her into the courtroom as a, quote, member of the family, because they knew Aidan was covering the case as a journalist. 19 seconds he left. He walked out. He spoke to a cop as to where he's supposed to go. And you know what the Commonwealth's argument was? Well, technically, he wasn't 100 yards away from her when he was in the outer circle, and therefore there was a violation of the order to stay away from her. That was the most ridiculous, horrible thing. And 3 days, 3 full days of the district court's time was taken up. We also heard from his attorney, Tim Bradel, who I think is one of the finest attorneys around dealing with these issues. He's just fabulous. He has co-counsel, Mr. Betterow, but Bredo really did all the heavy lifting. So let us hope, if you are on the Karen Read side, that this is a good omen for Karen Read. All right. But that's a different trial. So we're going to deal with this today. And so then, as I left off, because I got sidetracked with Aiden, but it really wasn't a sidetrack. It was purposeful. The prosecution will close. There'll be a break. The judge said, it was interesting. She said she was going to give generic closing instructions, and then she would give the regular closing instruction. Now, I took that to mean that she was going to tell the jury generically first before closings, the ones, you got to pay attention, reasonable doubt, all that stuff. And then she give the special instructions afterwards. But other reporters who were in the courtroom said that she later said that she's going to give them all together after the closings, right? After both closings occur. And then after that, she then that's when the alternate jurors are chosen. All 18 will be put into like a roving thing, and they'll be picked out one by one. And everyone wants to see the actual tabs this time, not just be told, because there are a lot of people who are suspicious that the 3 women who were knocked off the jury last time, one of which was because of alleged cause, because she had spoken to someone that would be juror number 3 who gave Aiden Carney that interview. And I would tell you that if you have time to listen to that interview, it was very, very insightful in the breaks today. And so the three jurors who were knocked off were 3 not guilty verdicts. So there's a lot of suspicion about the court procedures, which is why they have to be as open to sunshine, and that's the camera, as they should be, and open for all to see. And then, of course, after she does that, which it looks like that'll be because she's going to take lunch. And it was unclear whether she was going to take lunch before she instructed or after and she instructed. I mean, quite frankly, if there is time, she should just let the jury deliberate over lunch. I mean, if they want to go and let them start deliberations. She's going to let them deliberate. She said to 5 or 5:30. Initially, it was reported she was going to go later, but there was all sorts of restrictions in courthouses dealing with security, whether they can be secure after a certain time, dealing with overtime issues and all. So if she lets them go to 5 or 5:30, I think the jury will have a lot to say about that at the time that they're discussing the case. Now, people have said, could this be like the OJ jury, 2 hours and they're out with a not guilty? Could be. And then again, the jury has that it's very complicated verdict sheet or slip sheet, as they call it. It's really made it more complicated than it really should be. But we all know what happened last time, and there were arguments over the slip sheet that she's going to give them. And we haven't seen the final slip opinion. We will see it, and when we get it, we will try to read it and show it to you. There's a question about the prosecution did not want a lesser included charge on the second charge. They don't want a lesser included charge, and that is something that the defense agreed with. But let me tell you, there are cases all over the United States in various jurisdictions, and I'm sure Massachusetts is one, that said it's irrelevant what the parties may want. If the evidence calls for the judge to give a lesser included, the judge must give a lesser included, not respective, not being concerned about what the parties say they have agreed to. So we'll see where she comes down on this issue. And yes, I did save the fact that it is Friday the 13th. This case, as has been pointed out, started on April 1st. That day is what? Come on, I can hear you all. April Fool's Day. And now we are ending on Friday the 13th, maybe. Or maybe we'll be ending Monday, or maybe Tuesday. Last time the jury went out on a Tuesday, and then, as you know, they were finally sent away on Friday after giving one note was for evidence. One note was to say they were hung. Then they were given what is called the dynamite charge. It's mostly called the Allen charge in most states, but it's the dynamite charge. It's modified now from what it used to be 20 years ago, which was like, you must go in and find a verdict. Now they can't say that, but it pushes them to go find a verdict. And then, of course, last time they came back with the second note, and you could not give 2 dynamite charges to a jury. You're only allowed to give 1 dynamite charge to a jury. So with that, I will say to you, we do have some programming notes. At 1 o'clock, the original gangster housewife, the OG from Real Housewives of New York, is going to be on with us, Jill Zarin. She has been following this case and posting a lot of questions on her X account. And let me tell you that we have 3 questions she wants answered. I'm not going to tell you what they are right now, but we're going to discuss it. And good morning, Madeira Beach caregiver. Woo, thank you for that. Boy, Michael's going to be really happy about that, Michael Bryant, especially if he has to go back all next week and stay in a hotel, because we're there today. We'll be there today. We'll be getting some local colors, some local interviews. And then if they do go next week, we'll be there all next week. This will be our, 13th trip? Could that possibly be on Friday the 13th? We're making our 13th trip to Dedham. I think it is. Okay. Good morning, JSTV family. I've been overseeing, let me just put this in perspective before I read it. Madeira Beach caregiver is a hospice nurse, one of the most incredible professions you can be in, one of the most incredible type people that you could have. And as we know, she was just taking care of a judge who had died, and now she is, and I'll read it now. I have been overseeing a brain cancer patient since 2018. Currently, we are in Moscow. Now, I assume that you mean Moscow, Russia, not Moscow, Idaho, right, Madeira Beach caregiver? Not Moscow, where Koberger killed, in my opinion, slaughtered, in my opinion, those 4 young people. But in Moscow, Russia. I've seen little streaming since the 4th, but did see some of the bombshell testimony of Dr. Rentschler, Dr. R. I believe today the not guilty verdict will arrive. And there are many people who believe that, because the defense ended with a non-bang, right? A no bang, no collision, no collision, no collision. And remember, one of the themes to our show was, as we did our thumbnail for today and yesterday, as we recalled, we didn't do the show, but we repeated our mock closing show. Alan Jackson, in his opening, said, "Wait for us." Say that again. Wait for us. And boy, did they bring it over every single roadblock Judge Beverly Cannone tried to have in. So I think we're all with that here on Justice Served TV. We do not think the prosecution proved their case. We don't think they proved their case at the end of their case, okay? We don't think they proved their case at the end of their case, okay? So what I believe, in my opinion, this should be a not guilty. But that doesn't mean this jury is going to find her guilty. You've seen so many people, especially internet trolls, like who. Oh, and it is a worrisome that somebody on the jury could think that, hey, look, he's dead. She was the last one to see him, and she was drunk. And she just didn't mean to do it, but she accidentally backed into him and killed him. That's what somebody could think that. I don't think they've proven that beyond a reasonable doubt. I don't think they've proven any collision at all. And if you don't have a collision, you can't prove that. But a Madeira Beach caregiver, that is the worry. But let's see. If a jury comes in today, there's no doubt with the way that a slip opinion, that verdict slip is being done, it would have to be a non-guilty, because it's so complicated. You have to just go right through and say, hey, what did you find? Now, there are 2 types of juries, right? And Madeira Beach, what, my gosh, Madeira Beach caregiver, you are just the most amazing person in the world. And I have a very big respect for hospice nurses. Someday you will find out why, but not today. As you know, let us all take a moment and pause to pray or ask the universe, however you believe, right, to instill facts, logic, and good conscience. Now, let me put this up. I'm reading it. Facts, and thank you again for that donation. Let me start again, because this is so important. Let us all take a moment and pause to either pray or ask the universe to instill facts, logic and good conscience to do the right thing. It's been my pleasure to get to know Linda and Michael and the entire Justice Served TV family, seeking truth and justice for John O'Keefe and Karen Read. It should be the same thing. Shouldn't have been Dare Beach. Godspeed to the jurors. And yes, it gives me chills because as a juror, you have, in this case, somebody's life in your hand. You know that somebody has already died under circumstances that I don't know what happened, right? All I know is that there was no collision. All I know is that those wounds on the arm don't match up to any type of taillight fracture. And initially, when we saw the ARCA do the test for the taillight fracture, people were saying, wait a second, they just proved that the arm could break a car going, the tail light going at 24 or 29 miles an hour. Yes, they weren't afraid. The defense wasn't afraid of the facts, because if you had that break, you would have incredible wounds. You would have even and this is the coup de grace, in my opinion, Dr. Welcher. Remember him from Aperture? Who relied on the Shannon with one end Burgess figures, who had issues with his resume, his CV. Remember that? He had said that if you had that kind of hit, you would have a fracture in the hand, a hairline, or some type of fracture in the ulna, the radius, and the arm. And Alessi was questioning him, and he got very rude with Alessi. He said, well, you haven't proven to me there is an X-ray, and I don't see any X-rays, and without that, there may very well be those fractures that we don't know about. And then guess what? Dr. Loposada appeared on the stand with X-rays, as somebody put, the size of Rhode Island, furled out, rolled up to the jury. And I truly believe that is why the prosecution had no rebuttal case, because they were so insistent that Welcher had to do testing to prove that ARCA was wrong, that Crash Daddy Wolf was wrong, and that Crash Daddy Rentschler was wrong. And Rentschler turned out to be so very, 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 and very important. Should I say very 13 times? The amount of times that Officer Dever, not to be included with Dever, Officer Dever said FBI in this case. Okay, so Madeira Beach, thank you for your graciousness. We are so happy to know you too. And of course, we plan to be around covering more cases and doing, because after this case is going to be a big, so a lot of cases out there to talk about, and we plan to be talking about them in our 6 o'clock show, hopefully every night of the week. Okay, so spread the word, and thank you so much. And then programming note just for today, Steffi D. Oh my God, I love Jill. You talk about Jill Zarin. Can't wait to see her on with you both. Yeah, she's looking forward to it. She's also got a little Pomeranian Bossy who has his own Instagram page. Okay. It's really kind of going to be a lot of fun when we speak to her. We hope that she can stay on as long as she can stay on to comment, because by then, I guess, Judge Beverly should be giving the jury charges. We can talk over her giving the jury charges if we know what they are, and we've talked about them. But yes, so that's going to be the situation. So, okay. So apparently the defense filed for transparency, a motion for transparency on the alternate picks by making the bingo ball public. But Beverly Cannone denied it. Now, that is really terrible, because that was what was said. The reporters were all saying we were all going to see it, and she's denied us seeing it. So, Michael Bryant, I know you have a signal. It's not too great. You're looking a little, shall we say, pixelated, and I think I have the Jolly Green.
Am I?
And you look like the Jolly Green Giant next to me in terms of your picture. You're right there.
So can you hear?
We can hear, but you are very pixelated and choppy. Pixelated. Are you on Starlink or are you on? Are you on
No,
Starlink?
I'm on the phone. I'm on the
Oh,
phone.
well, that's a problem right now because you are, it's not a,
When they let us strap a Starlink to my back, I'll let you know.
well, now you really can't hear you right. Now you really are. I think maybe you should get off and try again because right now it's not very good. It's a matter of fact, it's pretty awful. And now you're frozen. Okay. Now you're frozen. Okay. Now you're not frozen. All right. This is welcome to live TV. As you know, yesterday you all learned that the electrician was here for the cabin, which is going to have a hot tub. So when the family comes, they have something besides woods, coyotes, bears, snakes, and everything to look at. As you know, but the last part, snakes are not my thing. Okay, but Michael, yeah. Now we have his avatar. Can you talk through your avatar, or if that's a possibility? But he had to get up like 5 o'clock this morning to get out there, to get up in Dedham. Okay. Yeah, no good deed goes unpublished. You're absolutely right. No good deed goes unpublished. Let's talk about these x-rays. But let me just take a sip of running on Massachusetts Dunkin'. Right. Okay. Running on Massachusetts Dunkin'. All right. These x-rays, I don't know what happened. All right. The medical examiner, when I do a case, I go to the medical examiner's office. I make an appointment. Usually the lawyers meet me, not the medical examiner. Oops, guess what we have? We'll talk about what happened, but let's go into court. Let's listen right now. I'll be behind the Tubi avatar. Oh, wait, I'm not going to go behind the Tubi avatar yet. Because guess what? We're beginning with a sidebar. Is everyone wearing black in that courtroom? Am I seeing that correctly? Is everyone in black on the teams? That would be interesting. I usually have a thing that I wear black in my opening and I wear red in my closing because I do want to stand out to the jury and let them remember me. But now we're just seeing nothing. We're seeing chairs. We're seeing black chairs, and we're seeing the families. And you know that I object to these type of pictures, even in that tiny courtroom with the Sacco and Vanzetti courtroom. I object because I think it's a spectacle to show the families and all. So some of you. Leah, so let's go back to the x-rays. I don't know what happened. I usually go there and I want to find out, and I want to see. And I always ask to see the original x-rays at the medical examiner's office because sometimes what they give you, I don't believe is actually correct. As a matter of fact, in Aaron Hernandez, we had things on the x-rays that weren't on the original x-rays because when they recopied them, you get sometimes artifacts. So it's so important to go there. And same thing when we were doing Spectre, we go see it. So I don't know. I mean, it's such good lawyering. I can't imagine the defense didn't ask to go see the medical examiner in person. But somehow I read that these x-rays only were given 3 weeks ago. Now, where could they have been? How could they have only been given 3 weeks ago? Why wasn't the medical examiner asked the question whether x-rays were taken? There's something wrong with this whole x-ray theory. Either the attorneys messed up or the x-rays were being hidden because they couldn't all be hidden because Welcher had said he's seen x-rays, but there were none of the arm. Okay, that there were none of the arm. Yes, Amber Owens, I am bedazzled today. I am bedazzled, and hopefully the dazzle will be relevant. Or else I have a black shirt here to change if the verdict turns out to be guilty. But and then I can look like the defense team, I think. There's only one person on the prosecution team wearing a light gray. Everyone seems to be wearing black in the defense argument. We are muted. We are unmuted. We are now just looking at the pictures of the courtroom. So there's something wrong with these x-rays, right? There's really something wrong. If they were withheld purposely, okay, I think that is a Brady violation should there be a conviction. But some court may say, well, you got the x-rays. You got them, okay? And therefore it's not. Law Nerd Amber, thank you, gifted 5 Justice Serve TV memberships. And I know the people that receive those memberships really appreciate them, because many people cannot afford the $2.99 a month for the members, and to get your questions added up and all. And Michael Bryant is usually posting some additional content for members. Let me see if he texted me. Okay. Hold on one second. I just want to check it out because I'm getting notices on my phone. No. Okay. Not yet. So he must be looking for a spot that he can get some type of signal, either whether it's, in some reason the phone is not working well today. And that's probably because if it's like us here, there's a big ceiling cover of clouds and all. But thank you. Leonard Amber points out that I have a lot of gifted memberships to pay forward. Happy to do it here. Thank you so very much for that. We really appreciate that. Also, you, Madeira Beach caregiver, this morning, just showing your graciousness and also your generosity. And we are proud that you are members of the Just to Serve TV family, which, by the way, is still a young family. As you know, we're only, 8 months old now. And we just hit 15,000 subs just for you. And thank you so much. And if you're here this morning, please hit like and subscribe. Okay, Madeira Beach, she said, not in the Idaho, not in the Coburger, Moscow. She's in Moscow, not Moscow. Okay, she's in Moscow. Wow, Madeira Beach, holy moly. What's the time difference there? Okay, let us know. All right, Joey Kane gifted another Just to Serve TV membership. If you didn't look at the animations Joey did for us, my favorite is Mr. Wiffleball, Ian Whiffen, who I called Mr. Wiffleball. And then, of course, there was the combination of the two EMTs, which I called Fluffernutter, and Joey did those animations for us. They were really fun and all. Everyone is into this case, as you know. And we are all into this case. We know we've been following it. We've been dealing with it. Yes, I can't believe. I have to tell you, aside from the issue of what happened with the X-rays. By the way, whatever happened obviously turned out better for the defense, because when Dr. Lopesada showed the fact, Welcher had made such a big deal and was at Alessi so much about. There's no fractures. There's no evidence of fractures, and there are going to be fractures, but there's no evidence of them. And there could easily be, because he implied the medical examiner screwed up by not taking X-rays, and then it turns out there's X-rays. I firmly believe that's why the prosecution didn't present a rebuttal case. I firmly believe either Hank Brennan knew that this was going to be, they were just going to literally kill on cross-examination Welcher, bringing all his statements back into court. Or if I were Judson Welcher, I would have not have come back. And what was he going to say? You didn't show them to me? There may be some Brady issue with there. If indeed the prosecution had them and didn't show them to Welcher, what, Hank Brennan, you're telling me Hank Brennan didn't know about the X-rays? You're telling me Hank Brennan didn't know that the holes in the shirt, remember that big whole thing for which they're still arguing over a curative instruction, were not caused by the lab? You're telling me that? Really? With all of his preparation, as he almost did the whole case single-handedly, which I'm not sure is necessarily a good thing. It may be. The old way of thinking years ago was that there has to only be one attorney, right? That you have to make that connection with the jury. But juries now get tired of just one attorney, in my opinion. They are getting into the fact there's teams. Ever since O.J. Simpson, which is pretty modern in the way cases are tried, they expect teams, all right? And I think they like the difference in the cadence in this and all, right? By the way, Lisa Charlton, thank you very much. And I'm going to punt this, and I'll tell you why. It was superficial right here today, Linda. Thank you very much. Because somebody decided they thought they were going to try to rag on me and said, your hair, you should get a new wig. Hello, this is not a wig. All right. And it was clearly an anti-Karen Reed. I think we've had some issues with that this week with some reports. Somebody our Tamus show the other night somehow got tagged by YouTube. That's the one with Neil and Stephen Plord, our independent accident reconstructionists. So we think that there's issues. But can you imagine Judge Cannone denied the fact that that you can see which jurors are being pulled as alternate jurors. I have never, in all of the years I have been practicing, in all the years I've been practicing, have never ever seen that. Never seen that. In any case, the poll of the alternates is always shown. It's shown to the lawyers. It's always shown. I mean, so she denied us seeing this. Oh my goodness gracious! And I'm going to show the hair again, only because you all, those anti-Karen Reed people, thought they're tagging me for my hair. Everyone loves my hair. I love my hair. My hair is done by a woman. Hi, Skyhopper, by the way, if you're here. I didn't see you go past, but apparently you did. All right. It's done by a woman who she works on a lot of TV shows now. Hopefully one day she will win an Emmy. She has worked on some of the biggest stars, and she is one of the most lovely people in the world. I can't give you her last name because she would hate me to do that, but her first name is Gladys. All right. And she's just fabulous and just a wonderful, 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 wonderful person. Okay, so I am shocked. Well, I can't say I'm shocked at anything Judge Beverly Cannone does. And yesterday there was something that seemed to be wrong with her. All right, Mr. Yannetti was giving all the arguments on the jury charges. Right, he was giving the arguments on the jury charges and the verdict sheet all the time. And then at some point, he talked about the jury slip, right? He was talking about the jury slip. By the way, thank you, Shy Gal, gifting one Justice Serve TV membership. That's so many this morning. We have already 7 gifted to people. Thank you so much for your generosity. But he was talking about the jury slip. And what happened there? What happened there when he talked about the jury slip? And then he asked that the judge take a moment to peruse it, right? He asked the judge take a moment to peruse that jury slip. And then when he said something about it, we think ours is clearer than that. She said something about, Mr. Alessi, I've looked at it, all right? I don't remember the exact words. I had them written down earlier. And it was an Alessi. And everybody in that courtroom, including everybody watching, kind of did a stun, right? They kind of were stunned. I know I was kind of stunned with regard of it. Okay. I was actually stunned by part of it. But then she said something about Dr. Turk's trial yesterday instead of the trial she was in. So there was something going on with her brain. Now, we have Diz has posted. I'll take a look at it. I'll read it when the court starts arguing a little bit. Defendant's motion to ensure transparency and alternate jury selection process. An affidavit of counsel in support of defendant's motion to ensure transparency of alternate jury selection process and certificate. And it was 6/13. That's today. Denied Cannone. Okay, denied Cannone. Okay. The judge denied it. So I think there's something. Obviously, first I was saying there was something going on with Judge Cannone yesterday. Now we've all had those days, haven't we, where we have called somebody something, or you're thinking about something else, and your words come out differently. But it was very weird that it was happening yesterday. And I pointed out because you have to be worried about somebody who does that, right? You have to be worried. And hopefully it was just an accident, not related to any type of medical condition. So it's 4 p.m. in Moscow, Russia. Am I saying that right? Moscow, Russia. Yes, 4 p.m. Wow. You are just amazing. You are just amazing. So yes, that's what happened this morning. They filed it yesterday and this morning. So when we thought, and when even Christina Rex was reporting that we were all going to see the poll of the alternates, apparently we're not. And to me, that's pretty telling, right? To me, that's pretty telling. Lisa Caron is saying what a lot of people are thinking. The prosecution is looking for a win by any means, not justice. It doesn't surprise me that the polling is going to be hidden. Okay, it doesn't surprise me that the polling is going to be hidden. Well, I tell you what, it even surprises me still, because I thought that there was something that you would show when every other state shows it. And remember, we have other issues that we're going to be talking about. In Massachusetts, okay, in Massachusetts, the judge gets to choose the foreperson of a jury, okay? And that's by their statute, okay? The judge gets to choose the foreperson of a jury. It's the only place I know of, although apparently there may be other states that do that. And we actually in Hernandez, and I can say that because having tried a case for Hogviche in Aaron Hernandez and gotten with our team, our three elite counsel, Jose Baez, Ron Sullivan, and myself, I did all the forensic work. I did in that case, and some of the other witnesses as we traded office. Sometimes somebody has to get something done, and someone takes another team's witness, right? And all, because we all know the case inside out. We objected to that. We argued that it was unconstitutional, that it was a violation of the Constitution because it didn't give everyone on the jury who was of every persuasion, whether it be gender, race, or whatever, to get a chance at being a foreperson. Now, most states have that the first one in the box is the jury foreperson, or that the jury gets to vote on that foreperson, which is kind of democratic, right? Or the first person in the box eliminates any possibility of bias, because it's the first jury number one who stays, who's going to be juror number one is always going to be the foreperson. This allows the judge, and they say, having been through this, well, I'm going to pick the person that's most attentive. Now, we know in Aaron Hernandez, the judge picked the person he thought was most likely leaning towards the prosecution. And it turns out he was right. And it was a white female. And we had so many people of color on the jury, and we had men on the jury. And we thought that was important, that rule be changed. And because we had a not guilty, there's no harm, no foul, so we don't get to challenge it. But I think the defense must make a constitutionality objection to this. They must make a constitutionality objection, even if it doesn't later affect the trial. Unless you make that and bring maybe a lawsuit, or and quite frankly, anyone has standing to bring a lawsuit on that. That's an issue that affects representation and all under the Constitution, equal rights under the law, right? And anyone should be able to bring that to change that rule. It is a wrong rule. It is a wrong statute. It is wrong because if you're picking the person you think should be the jury for a person, and by the way, in the first trial, she picked the former police officer of Rhode Island who had changed professions, and then was in the medical profession, and she picked him as the foreperson. And we heard from juror number 3 the other night that she believed he was interpreting the law absolutely wrong. All right. So just to remind you that the judges can have their finger on the scales of justice. They have their finger on the scales of justice by their rulings. And we at Justice Serve TV have been we were kind of surprised and happy when we saw some very fair judges. And whether you agree with it or not, if we take the Rush shooting, right, with Alec Baldwin, that special prosecutor there actually hid evidence, hid ammunition, and had it logged specifically under a different case number so it wouldn't show up as Alec Baldwin's case. And there was exculpatory evidence, all right? It was outrageous. And the judge did the right thing. She said, this is the one. And remember, one of the co-prosecutors in that case, all right, wouldn't go forward, wouldn't continue the case, and objected to continue the case, because when she found out that the lead prosecutor who she was prosecuting a case with had done that, she wouldn't continue. And so she did the right thing. And then the judge did the right thing and said, this is one of the most egregious Brady violations you could have, taking exculpatory evidence, logging it under a different case number so the defense doesn't even know it exists, okay? And I'm not even telling, me and my investigator who did this, we're not even telling the rest of the team, all right? It was found out because you know what? There are snitches that want to do the right thing, okay? or there are prosecutors that do want to do the right thing. So we said, wow, what an amazing judge this is, right? And then, of course, we had the YSL case, and we saw Judge Glanville, who was just terrible to the defense, and so much so that Brian Steele was ready to take the contempt, and did take the contempt, and was being sent to the Hooskow on weekends to go to jail. That was appealed to the Georgia Supreme Court. The Georgia Supreme Court said goodbye, and Judge Glanville was then off the case, and Judge Paige Whitaker came in, and we saw how fair she was. And then, of course, we had the judge in the ASAP Rocky case, who was incredibly fair and actually liked Joe Tacopino. You know, we had some exclusive reporting on that case, that the judge, we believe from our reporting with two sources, had told the prosecution, have you considered the ethics? That would be John Lewin, or some words to that effect, discuss ethics at a sidebar with the prosecutors about whether or not they should be able to continue the case with knowing that their witness really was committing perjury. And, you know, as you know, Lewin said, alleged that apparently Tacopino had violated the order, not realizing, of course, that there's a lot of people around that courtroom who probably didn't like Lewin. And word gets around, and we had two sources, and they have never denied that. They just said we reported on it. So, but that was one of our big exclusives as we were a young network dealing with that. But my point is that the judge was absolutely fair there. So we thought, and we're going to try to get, if this goes to Monday, I'm going to try to get Joe to come on to comment on this case, by the way. But we thought that, well, maybe things are changing. Maybe people are viewing defense attorneys in a better light. Maybe judges are changing. But then after we see Judge Cannone, who to me almost sounds like she's got this retribution going on, because the defense asked to remove her. It was denied. And then she said something snarky yesterday when it came to that slip opinion. And she said, and, you know, I was right with regard to it because the defense wants a slip opinion that's clear, a slip opinion decision, verdict sheet. I'm going to call it a verdict sheet, a verdict sheet that's clear to the jurors. And she said, well, you know, I was right on that. I want to give mine, and I was approved by, and the Supreme Judicial Court said I was right. That was kind of like a snark in your face, nasty comment. All right. In my opinion. All right. Now, as lawyers, we are, because of our license as lawyers, we can't criticize judges. Can you believe that? But as journalists, I can criticize the judge all I want. All right. And you have been criticizing the judge, and it has been shameful. Donnie Not Wahlberg, thank you. Another Justice Serve TV membership that's 8 this morning. Thank you for your generosity. As I said, people that get them really appreciate them and have a lot of fun with the other members in the community. And by the way, when this case ends, I'm going to start releasing. We'll figure out, we'll probably take a breath of a week, but we are going to go to the having a Who Killed Stephanie back in 1968 out in Oregon. You won't find her name because she's a forgotten victim. It was never ruled even a homicide. It was ruled undetermined. But we're going to bring that case back to life. And the question is, are we going to start with members who are going to have more senior roles to be assigned tasks to do? And I think that I may want to do that to start out. And then as the members get their feet into that case, we can open it up. So you will be a member, and maybe we'll have a special membership meeting to discuss this case before we go to others with it for a couple of weeks to deal with it. And I'm thinking of bringing in some co-hosts that have other podcasts to help us with the case, because I think exclusivity to me is not what's important in this case. Exclusivity may, as a matter of fact, prevent it from going further than it should. But I think to begin with, that there's certain things that need to be done that we need to keep control on, because I can't have you all out there calling people and hassling them. I have to have you do kind of like if you were on my team of being trial lawyers, I have to have you do specific tasks. So, but we haven't forgot that. Okay. Oh yes, Lisa Charlton. I'll tell you about Melanie McGuire. I'm going to star this. We'll talk about it afterwards, because that's the case that we're interested in doing a full write-up on treatment to try to bring it to network, and Michael wants to talk about that. And we have a different perspective on that because we may have some involvement. Okay, yes, and New Jersey's my home
All
state.
right, so why don't I see counsel over here at Sidebahhh? I've got my computer up.
Okay, I was just going to say, let's go into court, okay? And listen, and what do we do? Okay, we don't. So most of my cases I tried in New Jersey. That's where I started. That's my home state. I'm from Red Bank, New Jersey, as people point out. My sister is still there. Joan is going to be on the chat later on. As you know, she's my sister. I love her to death. And you all greet her so well, especially since she went through her surgery with her, like with me last December, where she spent, the week in the hospital with that very serious surgery, and then 2 weeks in rehab and all. Yeah, she said an 8:45 start. She wanted the lawyers there at 8:30 so they could start early. We knew that this was all.
I need my mouse too.
She needs a note. We got an open mic. Hold on, let's listen. Let's listen because she needs her notes. But now we don't have an open mic. Okay, now we no longer have an open mic. Yes, she told the attorneys to be there 8:30. They were going to start 8:45, and she had the jury sitting in there at 9 o'clock. Okay. She really, by the way, they really should let the jury, if they're going to let them start on a Friday afternoon, deliberate till late, like many states do, as far as they want to go on a Friday. But the more she takes on this, and the more this happens, this is all. So Joe Tacopino was actually in my house consulting on that case with a member of my family who I won't name, but who you all know. And also, I know the Melanie McGuire case because I'm from New Jersey. All right, an interesting case. And Michael Bryant is absolutely interested in that. So we want to get Joe on. And I'll try to text him to see if he can jump on. But we want to see who Michael Bryant, since he's up there, we want to get some local color. We also want to hear the closings and all. And there'll be a break between the closings. We can talk. I'll try to get somebody on, but it's hard to keep people on standby. Lawyers who have actual practices like I do. I was actually up last night, and Missy accuses me of not sleeping, which basically I don't even know how I'm functioning because you have to understand that we have our own clients. Right now, I'm representing a major female grandmaster chess player, and I'm going to say her name because I adore her, Jennifer Shahad, against U.S. Chess. And we have a lot of paperwork and things that are going on right now. And I mention it because trials are kind of like chess matches. You have to think ahead. And indeed, if the defense knew about the x-rays at the time they were asking Welcher questions, they may have just set him up, right? With regard to that. They may have just set him up. And that's a chess game. That's thinking far ahead, right? Now, let him commit himself. Now, let him not walk away with his. I actually bought a second computer down here, and I have my iPad here, and I thought I'd mimic how Welcher was kind of on the stand. Okay, by the way, we may be doing something. Maybe moving Jill a little bit upwards. I'm seeing that she needs to move up or push the time. Yeah, ask her, Missy, what time is good for her. We'll make whatever arrangements. We just don't want to interrupt the closings. So that's the only thing we don't want to interrupt. And if we're going to change the time, we need to note it on all of our social media. So, if we want to push the time to later, that's fine. The jury's going to be out. We want to move it to 3. That's fine too with us. Just Missy, since I'm in the air and I really can't answer, you hear me. All right. This is what we call a production meeting in the middle of discussing these with you. And obviously, okay. So yes, let me get Legal-Minded Friends says in the Dr. Turk trial in Massachusetts showed the old style lottery ball rolling box, put in juror numbers and pick them. Yeah. I just don't understand what the issue is. I really don't understand the issue at all with regard to it. I don't understand why she feels the need to hide it. I don't understand at all. Now, what is she talking about with the lawyers that can't be spoken about in real time unless there's a problem with the jury? I don't know. Okay. you know, lawyers are into, by the way, lawyers are into, hello, Skyhopper, there you are. There you are. I'm just posting you. Skyhopper, as you know, is our 16-year-old Skyhopper T16 Media. So a couple weeks, no JSTV. Oh, the withdrawals I'm going to have. No, we're going to be on. We'll be on. We'll probably just do our nighttime show, Skyhopper. We just won't be on all day. Okay. And all. So, by the way, Michael Bryant has just texted me. He has shot some stuff outside. He's also got a nice interview with Aiden that he is uploading right now, and with Cheech. And also, I don't know if we're going to be able to, if we're going to play those, or he's going to get on and play them from where he is. I think Diz and Missy should be talking to Michael if you can, since it's hard for me to talk to him while I'm on talking with you. But anyhow, I was kidding with you, and I said, look, I have computers and all. By the way, I had to get a new pair of reading glasses, which I told you about yesterday that I was using, and they were like so fresh lenses. It was like, wow. And it turns out that I had dropped my reading glasses as I loaded 2B into our SUV, because 2B is trained not to go near cars. So he will sit like 5 feet from a car, and then you have to pick him up and you have to put him in the SUV. So and 2B is 50 pounds. All right. And everyone's amazed. I just looked him up and put him in. But apparently in doing so, my glasses had been hooked to my jacket and they fell on the ground. And then apparently what I didn't realize is I just drove over them at like 1 mile an hour. So when I got here, I came here, and it dawned on me that this is a great story for this case. They were all like broken apart and moved with very little force applied to them. And this was a piece of plastic glasses, all scrunched and scrunched. So you can imagine an arm, okay? Imagine an arm. By the way, there's rustling coming in from my mic every time I move. All right, is that better? Maybe it's because the jacket is hitting the microphone. And if that's the case, since there's rustling in live TV, we're going to do something. We are going to take the mic and we are going to put it up here. And therefore, there shouldn't be any rustling. Is that better? Is that better, all of you? Is that much better? Can you hear me easier that way? Okay. All right. So let's see if that works out. It wasn't an open mic when she said I need my notes, and then they completely cut it off. I thought that was an open mic. Or she didn't hit the whatever button she has to hit up there, because somebody realized that she was saying that and hit it. But I don't understand, why couldn't this been done, earlier? Why couldn't this been done earlier? Yes. By the way, Jennifer, I should take a screenshot of this, okay? And I think I will, as we're talking right here. Michael, yes, Jen Shahad is awesome. Unfortunately, the chess community is insanely sexist and misogynistic. Yes, there's no reason to have different standards in the game of chess for men and women. There is no reason, but her case is about her case is alleging pedophiles and harassment and all sorts of stuff. And also, you have to go to Pacer to look at her complaint, but I would wait a while because you may find that there's an amended complaint that may be coming. But we will see on that. Not promising you at all, but we'll see about that. So yes, Jen Shahad is absolutely awesome, but she is exactly what you do as trial attorneys. Sometimes you have to wait, and it's hard, and you have to wait. And you have to wait, because your best ability to bring a point home to the jury is when you wait and then you slam it home. And as I told you, I've had a couple cases where we did that. I had a client who was albino and he was legally blind. The judge did not know that. He was charged with doing some kind of assault and throwing rocks that hit bullseyes and all sorts of stuff. And all of a sudden, and I saved that. The judge never knew it. And I saved it to the trial. And as I told you, the judge looked up at me and said, "He's blind?" And I said, "Yes, Your Honor." And he dismissed the case. All right. And we went with a judge trial on that because of that. I knew that situation. So sometimes you just hold and you hold and you hold and you hold as hard as it may seem, and then you can slam it home. So the defense had those x-rays, which I think they had for a couple of weeks, even though they may have been withheld by the prosecution. They may have let Welcher dig his own grave, or they didn't have him. And then it was like, oh my goodness. Okay. Oh my goodness. All right. Because it was just the funniest thing. It wouldn't, and remember Judge Beverly Cannone, she was kind of like, she knew what was happening because she said to her, well, did you print these, Dr. LaPosada? As if it mattered whether Dr. LaPosada had printed them or not. And Dr. LaPosada, yes, I printed them, like a big art printer. All right. And then unraveling and unfurling them, and and I thought that was another point that showed that a little bit of bias, because she said you got to show it all to the jury, and that's not exactly how she said it, but that was what she said, and to me that's what the tone of what she meant. All right, now jurors, you have asked, a lot of you have asked with regard to Judge Cannone, do juries pick up on that? Well, interesting enough, juror number 3, again, interesting interview if you're a jury consultant, and we're going to try to get Dr. Michelle Ward or Richard Gabriel, by the way, on the show. Also, if it goes to Monday, again, interestingly enough, juror number 3, as I've told you, jurors like the judges. They seem nice. They let them. She lets them go to the bathroom. If they raise their hand, they have to go to the bathroom. She knows what that means. If she'll take a break, they get their lunch. They rely on the judge for transportation into the courtroom. But then she said there were things that annoyed her. Okay. And what annoyed her was something like, I'll let them have it this time, when there would be an objection from the defense and the prosecutor would show something. She thought, I'll let them have it this time. That's not fair, And then the I'll allow it really got to her. So by the end, she thought that the judge was biased, and she had picked up on that. By the way, Sandra Martin and others gifted membership number 9 this morning. For all of you generous who watch this show so much, gifted 1 Justice Served TV membership. Sandra Martin, again, we appreciate that. But no, I don't mean to suggest we're going to go off the air, just that we're not going to be on the air 11 or 12 hours a day like we've been on the air. Which I'm sure some of my clients and my co-counsels and my firm will be very happy that I could do some legal work, not at 3 a.m, as I have no bounds. I figure you can read it when you read it, but when I have to text, I text. So I text. So, as if my assistant is on here, she'd also know. And I'm emailing and all, because I have to get my work done when I can get my work done, and I sometimes can't wait when I'm doing this to send out this. And Missy will also agree to that. Oh yes, she does. Matter of fact, Missy and I were speaking. When was the last time we had our text last night? I think it was. Let's see. I'll tell you in a second. Hold on, I've got to look because there's been a lot going on, because we all communicate. We have to communicate on the show, obviously. Oh my God. Well, Dizzy was texting us at 5:34 in the morning. So Missy and I were texting at midnight last night. So still. All right. New poll is up. How long to reach a verdict? All right. So what are the options, Diz? Do we know? And you have to go to our community page on Justice Served TV on YouTube to vote. Okay, you have to go to our community page. So on Justice Served TV to vote. So please do that, and we will announce the results. Okay. All right. The options are going to be today, Monday, Tuesday, or later. All right, today, Monday, Tuesday, or later. Now, a week ago, exactly, I was on Fox Nation with the panel, and Paul Morrow, he and I have different views on the case, but he is a gentleman, and we respect each other, and a good host, okay? And then there was another woman, Tarlika, who on from Florida. She was excellent. I'd hope to get her on the show here, but we just never had time to call her as a guest. We were dealing with so many issues every single day. And then there was John DePetro, who was on, and made the rounds on the internet of a little to do he and I had. But at the very end, we did ask for predictions, and even the other night we had asked for predictions. And I was of the opinion that the jury was still going to be hung on that second count. Okay, I'm not sure I hold that opinion now after the X-ray debacle. All right. So I think that I'm more leaning now to a not guilty all around. But if they're going to hang, they're going to hang on that. Jersey Girl gifted another Justice Serve TV membership. That's a thank you so much. We're now up to, I think, 10 today. That's fabulous. I appreciate it. Blessed in Texas. Linda Kimbo Sliced asked a great question. Can there be objections and sidebars during closing arguments? Yes, there can be. And I'm sure there will be. Okay. But the judge may say, the judge may say, hold all your objections to after the attorney finishes, and we will deal with it. So they're bringing the jury in after all of this time on Friday the 13th. We are about to go here. We're about to go. And I know it's going to be most interesting. I'm going to try not to interrupt at all during the closing of Alan Jackson. I'm not going to tell you that I can say the same thing during the closing of Hank Brennan. I'm not sure I can hold myself depending on what he does, but we shall see. Now, let me tell you that you tend not to object in a closing, even if somebody has said something bad, unless it is really serious, unless it's a real serious issue. All right. So that's how we as lawyers run. Okay. And so again, remember, we do have a lot happening here. Let's see, as Michael Bryant posts, he's got a nice Aiden interview that's uploading. I'm not sure if it's uploading to the Justice Serve TV page, but we want to obviously play it even when it does upload. And an interview with Cheech, we want to play that when it does upload. That's why he is there to be in Dedham. That's why he left at 5 o'clock this morning to get there from Texas from Connecticut. I sound like Judge Cannone from Texas with a 3-hour drive from Connecticut. And he will be there all day until this ends. We will obviously do a wrap up when the judge sends the jury home, and that'll be the wrap up show, whether it's at 5 or 5:30. It won't be a 6 to 7 formal show. And then Michael Bryant will be back next week, as long as it takes, if the jury does not have a verdict today. Okay. So yeah, Texas was on my mind because yesterday you talked to somebody. You remember I went to an event that I had to have the high hair on, and then somebody ragged on me like, "Oh, you get a new wig." But as it was said yesterday in Texas, they say the larger the hair, the closer to God, and I like that statement. Or I would say the closer to the goddess. Okay, up there. But my hair is regular, back to being its regular, flat self today and all. So all right. Linda, who decides for the Commonwealth who closes? They decide. Okay, they decide. You're surprised that Loudly's not closing because the jury hates Hank Brennan. We do, or not. I hate's a big word. We don't like him because we think that he has been a little sneaky and whatever. And I was a big supporter of him, and I still say that he is a very good trial attorney, whether you like him or not. But very good trials attorney. Don't make the mistakes he made with regard to the shirt or the X-rays. Right? Those were big boo-boos. That shirt is a big deal. And by the way, they're still arguing over the curative instruction, which I'm sure now has been decided, but we haven't heard exactly what the curative instruction is going to give. I have the whole curative instruction that's been proposed and all, but there's no point going over it till we see what the actual instructions are. And, for all the transparency in the courts, right? All the transparencies in the courts, we don't have transparency here and all. And these sidebars, these constant sidebars, the judge blames the attorneys, hurry up, defense, hurry up. How long are you going to be? Hurry up. Can you be finished by this? I'll give you 5 minutes, right? And then she has these sidebars that go on forever. By the way, it was reported that at one point, remember I told you a good attorney has to be willing to take a contempt, that Alan Jackson, who had it with her, and he's going to push his case the other day, which he did, that he said, hold me in contempt then, Your Honor. That's what's been reported. And if he did, that's the Alan Jackson I know. That's the Alan Jackson I tried a case against. That's the Alan Jackson that both of us were ready to be held in contempt on our cases. And as a defense attorney, you have to be. Because if that judge is doing something improper, okay, if that judge is doing something improper, you have to be willing to say that. I see Michael Bryan is trying to get back on with it. There, he's waving with a better signal. I see you. You look much better.
There we go.
There you are. Oh, there you go.
Yeah,
well, looks like we're about to start.
I figured. I just wanted to pop in before we got started. I've got my new tent, but I'm not sure I'm going to put it up or not. I might get arrested if I do. But what's the deal? What's with the delay? Yeah, let's get here early.
8:30. Let's get here. I want that jury in the box. Right.
We can start at 9 or maybe 5 till. Give me a break. Come on.
She clearly didn't do the instructions right. She clearly, and they weren't deciding them last night. They were going back and forth. She denied the motion. They filed a motion to have the alternate poll in public, and she denied that. She denied it. I mean,
that's like not even being shy about hiding the ball. Do they use balls or they use slips of paper?
No, I don't even know.
Yeah. Anyway, it's
Massachusetts use balls. Some of them use balls.
Yeah, exactly. Like ping pong. Yeah, because she doesn't tell you and doesn't show you, and Jimmy is not helping us. He's helping her.
Yeah. So I don't know. So tell us what interviews you have, and are we going to?
Yeah, I talked to obviously talked to a number of folks, and just got a sense of the environment, which is very different, of course, since the First Amendment zone has been reenacted. Who is one of the stalwarts and supporters that are you there? Hello. We hear from occasionally, so she had her point of view. A lot of people there, and I talked to Aiden for quite a while, just about his victory, what he thinks that today is going to look like. He got shut out of the courtroom. The randomizer got him. Here's the situation. You got people in the list, right? News Nation, Law and Crime, Boston Globe, all these allegedly, well, he wasn't listed. Listen to my list here. Law and Crime, Boston Globe, News Nation, some of the more well-known outlets, I'll put it that way. And Mr. DePipe is not in that list. So the fact that they never show up until today.
Of course.
So today, the drive-by media shows up, and they are taking some of the seats because there were 5 empty seats. 5 of the 10 people randomized didn't even show up. But Jess Machado got in, and a couple of other folks, and then they have the alternate to the alternate list. And I also talked to Tim, the local print reporter that we talked to a few times, and he was waiting to see if he was on the alternate to the alternate list. It's like going to a restaurant and they give you the beeper. Here you go. Except it's just some sort of text you'll get if you happen to win the lottery and get in there. So today, a clean sweep for Justice Sir TV. Never in the courtroom. Never credentialed.
Unbelievable.
What a joke.
Unbelievable. What a joke. Adventurous Spirit, by the way, 66, donate $10 to let you get coffee, Michael.
Thank you. You know what I found?
And a cardboard cup.
I'm in. I like this location. I like this
cup.
location here because it's by this cute little park, and the Skylink is a good signal. But I also like it because it's right across from Dedham Pizza, which is, I'm blaming them. They are guilty of adding weight to me. But then I also found today, and I'm glad I didn't find it until today, or I'd be 20 pounds heavier. It's called the La Luz Pasta Pastry and Cafe. Oh my gosh, the stuff they have in there. Oy. For me,
maybe that's what you could get. That's what you could go get. By
for
the
me,
way,
baked goods are like crack to me. That's I just I can't stay away.
Colin Sixhitter has this great comment for you, Michael. It should put up the tent, and if the cops come, they should tell them this is how you secure a crime scene. I think that's great.
I wished to take that a step further. I wish I had brought some crime scene tape. We all have it. You have some. I have some. I wish I'd brought that, and I would have put it around my tent.
Oh, that would be great.
Next time.
This goes to Monday.
Yeah.
That'll be great. So by the way, you may not have heard that Jill Zarin is trying to either move up or push the time of the interview. So I said whatever time she wants to come, as long as it's not during the closing. We can't interview her during the closing.
Exactly.
All right. So whatever time, and then we can.
So Jay-Z is going to be on. Jay-Z will be on.
Yeah. So Missy's working on that right now. Dizzy's working up. We're seeing. I told you about the motion, the transparency. I know you've been on the road, and you were texting with us at midnight. So I don't know how much sleep you got, but it could have been very much.
just
it had to be like
just
the rest of us.
enough. Just enough.
Yeah.
Yeah.
But
I'll
so
be fine.
you can have coffee, or you can have.
Yeah, I don't drink coffee, but I did.
Okay,
I did have.
tea.
No, I admit I had a few sips of a monster drink, just
Well,
but I'm going on just natural adrenaline, man. It's just natural high. I'm out here with the people. This is a very important case, and that's enough.
You have
to keep
any?
me going.
You have any still photographs or pictures of people? We can.
I did take a couple that I haven't. I've been busy uploading the video, so since that's done, I'll post a couple of the pictures.
Okay.
And people were taking
on Justice Serve TV. You're going to post them, and then
I'll post them on our X account. Yeah.
Or,
but people are
wait. They're on the X or they're on the YouTube. They're on the X account.
Well, the video is on the YouTube. I'll post some stills to X.
X account. Okay.
So people are stopping. We love Justice Serve TV. It's great. Tell Linda hi, and taking photos of my bad side. Anyway, just that there are probably 200-300 people compared to 20 or 30, which we've seen. So I rag on the drive-by press, showing up.
Ridiculous,
finally.
Right? They haven't been here, and then they'll report some bullshit stuff because they haven't been here and understood the whole thing.
And you get a little of that even with the supporters because they can't afford to be out here every day. Most of them are working folks. They can't devote that kind of time. But today, everybody knows is important, and they're out here in full throated support. I have not seen any prosecution support team. In fact, I'm almost surprised that Brennan showed back up. But it was not a good finish for the prosecution's team.
Yeah. So no, it was a ridiculous finish. And as I said, I even miss Hank Brennan being in the court yesterday. He was so mousy. I don't know what.
Yeah, I know you said he wasn't there. I said no, he's the shriveled up guy who's hunched over his computer. Some were saying that he was watching or monitoring somehow the Aidan Carney case.
Well, there was a picture. Jen Machado showed a picture of him because when you're in these Zooms, you see of him in the Zoom that the court was showing.
Who's in there?
Things. It was in there. Now I said, is that really him, or is that somebody just using him as an avatar? Right? But apparently it was him. Now it was interesting because you know what? When I was on with with Fox Nation last week, they had the wrong conspirator. The co-conspirator was supposed to be somebody else, but they said that Hank Brennan would be monitored that because he's going to charge. He's going to then charge if she's not guilty, Karen Reed with intimidation of witnesses. Are you kidding me? After yesterday?
Oh my gosh!
Are you kidding me?
Yeah, we know that they had proposed and then apparently quickly abandoned the instruction suggesting that there has been evidence of intimidation by Karen Reed, and if you find that is true, and then hoping to use that to kind of bootstrap some of the other charges because there is no charge for witness intimidation.
Right.
We didn't hear anything about that instruction, so I don't think it lasted long.
Well, it'd be nice if what we could see the instructions. It's clear to me that they're still having problems. The curative instruction was a big issue from the shirt because the defense rightly argued that having more had to be done, and she said, well, she'll do it at a jury charge. Well, if you're going to do it, then you got to, that she should have said that the prosecution misrepresented that.
Yes,
Period.
I mean she doesn't have to say committed fraud like I suggest, but she could clearly make it known to the jury that it was at best an innocent misrepresentation, right? And she wasn't willing to do that. That doesn't surprise me, though. Does it surprise you?
No, nothing surprises me.
No.
And that's what's turned me on this case. I was all for, let's listen and if they haven't proved their case. But now I'm like, well, they haven't proven their case. And I've seen so much bullshit crackers going on, right? With regard to the prosecution and how they've handled it with that shirt, with the misrepresentation about Yannetti, with the misrepresentation about the defense team and the federal documents. That to me, I don't care. And I've said this. I don't care whether Karen Reed did this or not at this point. I mean, at some point, prosecutors have to be held accountable for Brady violations and for misconduct.
Of course.
And, I don't think they've proven the case no matter what. I mean,
that I think, but, I mean, obviously we care about getting the right person.
Right.
If that's, I just don't think I'll ever know if it's Karen Reed or not. So you combine that lack of proof with all of the apparently biased shenanigans going on, and how could it? I mean, we're only human. we see what we see, we react to what we see. How can you not feel that this case is so jaded, so slanted, so biased against the defense? How do you not see that?
Right. How do you absolutely not? It's mind-boggling. And the prosecution. Let's talk about specific. They had no answer for the wounds on John O'Keefe's arms. They had no answer.
No,
they had no answer. They had no answer to the fact that these were dog bites with Marie Russell or animal activity, bites with the prosecution.
I'm hearing some rustling. Are you hearing rustling?
I'm hearing rustling.
Yeah, I think to me the case turned not only on the combined 3 witnesses that the defense put on at the end, but when Alan Jackson was allowed to talk about animal bites.
Right.
That to me should be game over.
Well, and also collision and rental. By the way, everyone loves my jacket. It is Fashion Friday. It's by Legends, LANGENC. It's a little bolero. Okay. And I'm wearing Justice Serve TV leggings.
And I've got my green on.
And you've got your one.
Here we go.
Okay. Let's. I guess we'll go into court. We'll listen. I may be behind the avatar. Maybe Michael will be behind the avatar. We'll see. Let's see what she says.
So I have started far too many mornings by saying to you folks, I apologize for the inconvenience, having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. I apologize. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing argument. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is, you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof, right? The burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes. I'm not going to stop them. So we'll start with the defendant's closing arguments.
Here we go.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, Not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall. longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton Board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You coming here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident. Did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rinchler, PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judge Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffen's data, Ian Whiffen. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffen himself conceded that he has reasonable doubts about the accuracy of John's location data. Remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rentschler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. LaPosada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be want answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass bitch. She's got a leaky balloon knot, leaks poo, 0 chance she skates. She's fucked. And up to this point, Michael Proctor had done 0 investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses, and for bias. Not just any bias, bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those Solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm, because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing, not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sallyport. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash. Didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth hasn't presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, using location data on John's phone showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for alleged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage. I was asking her about the front door, the side door, and the garage door. And her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Reed. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins. But Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history, a dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was timestamped by Celebrite at 2:27 a.m. A Google search that read, Hoslong to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Kerry Roberts. About Kerry Roberts, not with Kerry Roberts, notably. What Kerry Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Kerry's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Kerry Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video. It's not on audio. It's not in a single police report. It's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video. Multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenney Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moment that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop. And all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not, I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt, not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, They all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Read because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Read, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Read of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Read not guilty, not guilty, not guilty. Thank you.
Thank you.
Wow, no break between Hank. Now we know why no collision was 3 times, because the not guilty is 3 times. This was a brilliant, bone-chilling closing by H.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world, but to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard, she made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described to you one time, to get away from the scene, he walked into his bedroom, but the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keefe drinks a lot and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks, more shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober? And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide 1, please? At the waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins, barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intakes, probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest at the time. It tasted just like old soda water with lime.
Slide 3, please.
wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet, the roads were very quiet, you can see it on the videos. And I was going, you know, when I padded during this kind of drive, I always drove extra slow. I know my alerts aren't as sharp as they should be. But I shouldn't have been driving.
Thank you. Do you think she drank when she got home? When they leave the Waterfall Bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Dr. Judd Welcher took that data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key critical piece of this case that did not exist before. He found it recently. And it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said it at the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Slide 4, please.
Very close to the Alberts. In fact, when Jen was navigating John to the Alberts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that a little, please. And it shows you with the healthcare data, it registers as flights climb, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you can move down, please, Ms. Gilman. And then the bottom left, that's 34th Fairview. You can see second by second the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there, they're together. The data matches up perfectly. Perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They fall behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. And they didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nagel said they're there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down. She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car. And we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves to 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly what John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole, but that in itself is not enough. But there's more. There is more. There is the healthcare data. there is the temperature of the cell phone battery. And so he moves for 20 seconds, it turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing, it could be a straight line, it could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds, he's moving. And in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, John McCabe. And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannone will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Ms. Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Ms. Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove and what we have proven from the evidence in this case of second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge and they see cars going by and they have a boulder and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge and it comes down and lands on the car, and there's somebody, passenger, child, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorbo wants, he stops moving. Tunnel Keith stops moving forever. Forever. Have slide 6, please. You'll get to see this more closely, and you can probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCA, they did some crash test dummies. You know what else they do? Text stream data. There's nothing about that data that is uncertain. Nothing. Take that down, please. When Miss Reed hits John O'Keefe, collides with John O'Keefe, we don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12:31:56, 12:32:04 to 12:32:12 is the data which is adjusted when you reconcile the clocks in the Lexus. 12:32:09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12:32:16 is his last steps. Mr. Disorder says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We could have slide 10, please. Could you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly lays on the ground, abandoned, you're going to have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo, and I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone, and I ran over his foot and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
When she left Fairview and left John behind, she didn't think he was mortally wounded, but she knew she hit him. She knew she'd hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. Can you play voicemail one, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so was John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe was in the house, absurd. 66 turns to 61, it's 12:53. 48 unanswered calls from the defendant. He's not in at a party. He's not wrestling with Brian Higgins. He's not in a fight. He's in a fight, his cell phone would be moving. There would be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps because his phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm dealing with a fucking kid. Nobody knows what the fuck you are, you fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him and now he's not responding and she's getting nervous and she's getting anxious and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. You can take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, where's John? She doesn't call Brian Higgins, has his number, has been texting with him. Hey, was John at a party with you? Did you see John tonight? She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says she's panicked. She can't understand what she's saying. Call Jen McCabe. Call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, I left him at the waterfall. I left him at the waterfall. See, now it's gone from panic to self-preservation. I left him at the waterfall. And Jen says, left him at the waterfall? He saw you in front of the house. Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Kerry Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Kerry Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, Kerry. John's dead. I think he got hit by a plow. Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Kerry Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that for what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Kerry Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Kerry Roberts, separately at that time, answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond, John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing, no taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing because it's back at Fairview. That's why it's missing. It's not there. It's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35. 28 minutes. It's about a 10-minute ride. Where does she go in 28 minutes? Where does she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Kerry Roberts comes, take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going to the back to Meadows. You're going to follow me. Leave the car. I'll drive. At this point, Jen and Kerry don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Kerry Roberts, Jen McCabe, they're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview. And this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone, so you probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe? She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him. You're going to see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert house. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her water. He took the glass. She says it. So the Albert house, they don't need to give glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a cell-bright record is not the same as a call detail record. There's no evidence there was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can ring. It can go to voicemail. They have no evidence, none, that there's a conversation between Jen McCabe, the person who was ripped out of her sleep to come help and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McCabe see their best friend prone, lifeless, frozen on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time does anybody say, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Could we have slide 14, please? You can see there's Kerry Roberts' vehicle, and then on the left, you can see where they're working. Right off the road, that's not 20 feet. That is a clip, a stumble, and a fall. And remember when John fell, there wasn't snow. It was just the beginning of the dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? Causes this type of injury all the time. All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night. Remember the straw? I asked you to take a look at that picture. We're leaving the waterfall at 12:12, the black straw in the drink on the street. Collision, glass, nose, straw, back, hits his head. You play the clip on the left, please. 59.
So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics, getting to work 2 hours early to know the blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody, but to him, it's another human being. This is his passion. Katie McLaughlin, first responder. This is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with it, so she has to bring people with her to face it. And now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent core people who hear her say, I hit him. I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So I must have said was, did I hit him? I know I said I hit him, but did I really say this many times as law enforcement's claiming I said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself she hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Ms. McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's sitting next to or standing next to Ms. McLaughlin, she tells you she saw or heard the same thing. Remember what happened to her in the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Ms. McLaughlin, firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of the story was trying to help the defendant from incriminating herself. The irony. Can we have slide 9, please? This is the battery temperature. You're going to have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, you know, even the waterfall, 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it started to go down to 72, 12:45, 66, 12:53, 61. And you see it drop and steady off at 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And the blood's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Kerry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next reading, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then The vote is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in a cold. And there's Miss McCabe in her winter jacket, soccer mom, trying to help. She has MS. Her hands aren't working. She's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again at 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27, look the other way. Don't look at what she did. Former Trooper Proctor, look the other way. Don't look at her. Every time they make those, oh, she got the glass from inside the Alberts, maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data. And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Trying to evoke that primal reaction, disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper McKennick was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? He said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't, but that does not change. It doesn't create a conspiracy, doesn't invent a dog. It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there was a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He hasn't been near the car. And then the Dighton videos themselves, when you close it, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please? .507. You can play any angle you want, but if you look at this angle, it's gone. You know, plant is already gone. You know where it is? 34 Fairview Road, on the Lee Field. January 29, 2022, page 23. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing when you do the videos, it's a different angle, a little smaller, but if you play that and watch the lights go up and down and slow it down, you'll see it expand. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad bar, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I show him that bottom right photo with the snow, with it missing. And I say, is this the way it looked? It's, of course, before the snow melts out in the salad board so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the salad board. There's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Kerry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here. She's on her profile, but she can't explain the methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. LaPosada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. Oh, is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scorti-Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that, in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she, in 90 days, saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries. The suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car and have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there's no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert, what objective expert uses Signal, an encrypted app, to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all. And because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Renshaw came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. Do you adjust it? And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? Brendan asks you a question, make sure you ask for a transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some. And so what happens with Dr. Renstrom, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. He said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a lunch, and not a big deal, just ask him about it. And he says, I have a sandwich and I stand in the corner until I remind him that we got video footage from a documentarian and he's in one of the scenes. And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judge Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Can I have slide 19, please? You bet they can. We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Thank you. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down your driveway if your kids were at the end of the driveway. You'd say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe was not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
Take that, thank you. All right, jurors, the next up is my instructions to you on the law. I'm not gonna do that right now, you've been sitting for a long time, so I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other, all right? So we'll send you back for lunch, it's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today. So I'm going to send you back maybe about a half an hour. Is that enough time for you folks? All right, so we'll give you a half an hour for lunch and then we'll come back. I'll give you my instructions on the law and then the jurors will go out to deliberate. I know there are 18 of you. We seat only 12 deliberating jurors, so 6 of you are going to be alternate. I can just tell you that, you know the odds, right? And I can tell you it's Mr. McDermott's least favorite part of his job is smoking. So we'll do that this afternoon. Do not discuss this case. See you in about a half hour.
Well, here we are. I know Michael Bryant is, I see him. He's out in the field there. There he is. We're going to get quick reaction from him. Let me just get my camera a little better here. I didn't even know he was at the end, except he ended it, Michael Bryant.
Yeah.
My feeling was it was not thematic. He was trying to respond to
Counsel,
Jackson.
can I see you just a second?
It was counsel's going to see that. Quite frankly, it was not a good closing. Okay, that's all I can say without being more disrespectful. I don't know how you felt. If you're hooked up.
Well, I think there was a great line that he used. Look the other way. I mean, that was amazing. That line that he used. It was genius. Oh, wait a minute. That was what the defense used in trial number 1. Never mind.
How about the fact that you said
that
that the witnesses happened to remember? I have been live tweeting this, Xing this as this is going on of our reaction, because I know your reaction is the same with my reaction. The EMTs just happened to remember. They happened to. I mean, I just thought that was terrible, and that he wasn't going to stand there and he wasn't going to vouch for the credibility of Proctor, but they didn't need to call him, and he called him Super Proctor.
He dismissed him with one line. We didn't need him. We just didn't need him. Yeah. Okay. Just in general, yes, far too disjointed. Didn't really crescendo. It just kind of petered out and finished. But he did, and I made note of them. I think he made some points because I'm looking at this objectively, even though I think his case blows. He did make a couple of points. Do you mind if I share those, or you want to make?
No, you're on to share them, because I'm sure that what you are going to say is what you and I seem to have the same viewpoint of this. So go ahead, please.
Okay, couple of things. The attack on Dr. Russell. The only thing I would suggest was legitimate is that she did reach out to the defense. She reached out, which is not the way you normally retain an expert. She reached out to the defense and said, I think I might be able to help you. I think that's a point. It's not a knockout blow, but I think it's a jab, and I think it's worth mentioning. I also think that, and this takes us to the time where Karen Reed discovers John O'Keefe's body, right? And he says that there's a reason that nobody else saw John O'Keefe's body with all the conditions. And, anybody who's seen the video of the front yard that we've put out there for my visits a few times, you can see it's a very small space. So it's hard for me to believe that others did not see the body. Let's set that aside for a second. He makes the point that the reason that Karen Reed saw the body, even before they were really adjacent to it, is because she knew where he was. And if you don't think a juror or more will latch on to that, you're naive. That's a point in the Commonwealth's favor. Let's see. I had a couple other points that he made here. Oh, I thought it was interesting. I don't know if this is a point or not. I think it's kind of curious. We know how upset Karen Reed was when she is looking for John O'Keefe, when they find his body, and she's frantic. she's going crazy. He somehow believes that helps the Commonwealth. He somehow believes that that is some sort of consciousness of guilt, I guess. But I think a normal average person would look at that and say, like, well, yeah, she's freaked out because this man she cares about is dead or dying. And prior to that, he is missing. And yeah, they had a fight here and there, but nothing to suggest that it was going to, end with, hey, I think I'll just run you over to settle the score here. So I just thought, I don't know if I would relied as heavily on that frantic nature of her reaction and how she acted when they found the body to suggest it helps the Commonwealth. I probably would have minimized it, if anything.
Also, it suggests that she didn't believe that she wasn't out to murder him. But he started by making that clear, and it took him an hour and 5 minutes before he even mentioned the word collision. All right, and then he said, "Well, data shows it, but the data does not show a collision. That's the whole point."
Yeah, well, I think he was going through the smoke and mirrors that all of this. Here's one thing I like about Hank Brennan. He says data, not data. I do like that. I'm old enough to remember when people called DATA data, and then all of a sudden one day it became data, and I didn't go for that. So he repeatedly talks about the data, but in a way that I think is used to maybe obscure whatever it really means. I've always discounted the data from the very beginning. I don't think it's reliable. I think it's a mess, and I don't know that the jury is going to latch on to that and dissect it to the degree they would have to help them get where the Commonwealth wants them to go. So I think he relied on all of that.
Can I ask you this?
Yes.
In the middle of that thought, put in this equation, then continue. Shannon Burgess, data or data? Okay, go ahead.
Shannon Burgess. Yeah, here's the best thing going for Shannon Burgess: the distance between his testimony and closing arguments, because memories start to fade. Can you imagine if he had been the last witness or one of the last witnesses? I mean, the guy is a fraud. And so I don't know how you resurrect, how you rehab that witness. I guess you do it by just pointing out some of his conclusions, which obviously help the Commonwealth, and hope that the jury doesn't remember that the guy's a doofus that has zero credibility.
That's a modern word. But it took him over an hour to go there. Okay.
Yeah.
It took him over an hour to go here, and then I thought he also see if you agree with this. He asked a lot of questions, Brennan. But the point of a Commonwealth summation and a Commonwealth's case and a government case, of which the Commonwealth is, even though it softens by sounding Commonwealth, is that they must prove beyond a reasonable doubt. They should have all the questions answered by now, in my opinion, not asked.
Of course. Yeah. And he almost reinforced my theme, my axiom, which is if the end of the case leads you to what the hell happened, that's reasonable doubt. That's not guilty. He kind of reinforced that a few times, and obviously not what they want to do, but that's the fact. Nobody, expert, layperson, witness, nobody knows what happened that night.
And he said that. He said at the very end, he said, "We don't know how this accident happened." Well,
Yes.
then you're assuming it's an accident. You're assuming something happened, but we don't know how this accident happened when you can't even show that it happens, Michael.
I mean, you don't have to convince me. I've been saying that from day one, or at least from the end of trial one. So let's talk about how he kind of took a side trip into the charges, right? He was leading up to, sort of a dramatic moment in his discussion about finding John O'Keefe's body. And he says, okay, hold on a second. Now let's talk about intent, because I think he got to where she, Karen Reed was in the car, and if you believe the data, backed up 74% on the throttle, drove forward 34 feet, drove back 53 feet, all of that, right?
Mm-hmm.
Goes into all of that because he needs to convince this jury that this second-degree murder charge isn't an intent to kill somebody. It's an intent to do an act that leads to serious bodily injury or death.
Yeah,
right?
He called it conduct that is created, is what his words. He said the second-degree murder is conduct that is created.
Yeah, so he has to break that down, because on its face, I don't care how big a squabble you think they might have been having. on its face, I don't think anybody's going to believe that she was out to kill him. I just don't think it's going to sell. So what he has to focus on is that she intended to back that vehicle up. She intended to step on that accelerator. She intended to hit him. And the consequences are the consequences. And that's where the second-degree murder comes from. So he's got to sell that. The intent issue really relates to the third charge, which is leaving the scene of the incident. And so she has to intend to leave. She has to know something has happened and intend to leave. So he can't get totally out from under the intent element, the mens rea, to leave the scene. Because how do you leave the scene if you don't know there was a scene, right?
Right.
So,
right.
and then of course
exactly.
we know that the number 2 charge has always been the most troublesome for the defense, and that's the DUI related manslaughter. How do you like the counter arguments on the alcohol consumption? Start first with Alan Jackson's.
I love it. I'll tell you why. That's what we did in Jason Williams, because he was charged with this drunkenness, and we got the retrograde extrapolation pushed out because we were able to suggest that he went after this incident happened, and he was so upset that he drank, and that she didn't have that second test. And they have the same problem here. I mean, if she's drinking, she's going back to the house. They have no proof that she didn't stop drinking at the house.
Yeah, and that was the point made by Alan Jackson. When was the last drink?
Right.
Nobody knows. Once again, something nobody knows. But Mr. Brennan's counter to that was just to rely on the retrograde calculations.
Yeah, right.
And if she was X at 7:30 in the morning, then she must have been Y at 12:30 when this happened. So therefore, ipso facto, she was drunk. So he wants the jury to just, check that off the list. We got the data. We have the data to prove that. So that then gets you to whether or not it was done in such a way that she was. Is it? Let me make sure I get the right phrasing. Wanton and reckless. So you can't just be inebriated. The action has to be wanton and reckless.
Yeah, and you think about that. Let's assume she wasn't inebriated. Let's assume I'm going to take a hypothetical. John O'Keefe is blasted drunk too. He just happens to sit behind the car, doesn't go anywhere, so no one can see him, and then she's waiting for it. Let me give you that as a hypothetical, because that's as easy a hypothetical as anything else. And then she backs up. What are we talking about here?
Yeah, and he and Brennan suggests that whatever this spat was they were having.
Tori, we're done.
Let's hear what's going on. Yeah,
we have some law in motion here.
Let's see.
You are muted.
Okay, well, that was exciting.
That's it?
Yeah, maybe they had a little sidebar or something, and then they are now officially off the record. Why do we know that? You are muted.
Right.
So, did you just hear some music, or is that my stomach
what was that?
growling?
I did hear music,
I don't know what that was. What were we talking about? I forgot now.
Well, we were talking about just the hypothetical. Well, what if he just, he was falling down drunk? He fell down drunk, and then no one saw him falling down drunk and sitting there.
Yeah. I mean, you have to. Well, the bottom line is you have to fill in all kinds of blanks, because why? We don't know what the hell happened. So, Mr. Brennan is suggesting this fight, whatever it was, led to them deciding he was going to go in, or at least he's getting out of the car, right? Because she's still driving. Dome light comes on, makes a big deal out of that. Dome light comes on.
He makes a big deal of that.
He gets out of the, John O'Keefe gets out of the car. And then after that, it's time for creative writing, everybody. Get out your blue book. Let's all just tell a story, figure out what the hell happened. I don't know. What did he? I don't even know if he immediately went toward the house, in the house, didn't go in the house, never made it in the house, wandered around the front yard in circles, and then tripped and fell down and hit his head. I don't know.
It sounds like he walked to the garage. That's what it sounds like. And
well, he certainly moved. He definitely moved.
Absolutely moved. And that measurement that they did with the private investigator now comes into really good, 63 feet when he moved 80 feet. So it puts him, if you want to put him inside that garage, with something happening there, he walks in accidentally, whatever, you can put him there. You know what we haven't talked about? Alan Jackson.
Oh, Alan Jackson. We were going in kind of backwards.
Yeah.
Yeah.
I will venture to say that was the best closing statement I have ever seen.
Really? Wow, that's some high praise.
And that's a high praise from a former adversary, as you know.
Yeah,
I thought
it was
I thought
solid.
it
There's no
fabulous.
doubt about it. It was easy to follow. It was passionate at the right times. It pointed out, well, let's face it, as much as I think he is an amazing attorney, wouldn't we all love to have those facts to argue to a jury? Wouldn't we all love that position? So it doesn't hurt. He is a master, though, at putting them in the right order. And I'm thinking Elizabeth Little helped it because they were absent from yesterday's hearing. So, yeah, it's such a great defense case to argue, and he did a hell of a job.
Yeah, not only that, I hearken back to, and when we teach, we talk about this. You start your case at the beginning, right? You start your case, your opening statement is going to mimic your closing statement, right? You have to know that, and you know that as an attorney. You teach this too, okay? Alan Jackson opened with no collision, no collision, right. No collision. His whole theme of his closing, opening again, no collision, no collision, no collision. And then what I thought was absolutely masterful and brilliant, when he gets to the very end, and I do have notes on him, okay? I do have notes going all the way through because I had so many high points of it. He ends with, okay, not guilty, not guilty, not guilty, no collision. All right. I thought the thematic of the 3 times of no collision, opening 3 times of closing with, starting with that, ending with that, and then the not guilty for 3 times was just a brilliant linguistic move for the jury.
Yep, I agree. And the rule of threes is always solid. And he's just the way he incorporated what he wants them to find with the key issue in the case, which is, was there or was there not a collision? Because all this other stuff is all very interesting and fluffy. But if there was no collision, what are we here for? What's the case, Commonwealth? So, yeah, it was great. And it was, as much as anything, it was entertaining, which is not the core focus of your closing argument. But to me, if you can't be entertaining, you're losing the audience, and this is not an audience you want to lose. So
I was riveted by him as compared with Hank, and I had to take notes, but I don't know. I found myself drifting. Thoughts? Not that I'm a drifter. Not a drifter. How did you?
You were drifting off. I don't think the court did Brennan any favors by not putting a little pause between them. I didn't expect it because she was keeping them short. You know, look at cases like A$AP Rocky and our buddy Joe Tacopina. That guy went like 4.5 hours, right? 5 hours. Right. So this was not that kind of case. Obviously, he had breaks within his closing, let alone between the two, and then Mr. Lewin. But that was not the situation. But I think Hank Brennan was hurt by that because as you still hear ringing in your ears, this Alan Jackson, very pointed, very well-spoken, almost poetic at times closing, that's still in your noggin. And then here comes Hank Brennan and he tries to start off kind of with drama, right? John O'Keefe was a good man. And, and he kind of goes through that whole thing. Nobody is more sympathetic about John O'Keefe than everybody that's been watching this case. And it's not like they, I hope, have not forgotten why we're here, because this guy needs some justice. He ain't going to get it in this trial, I don't believe. But if there'd been a half an hour break, 15-minute break, I think it would have helped Hank Brennan, because I don't think people heard the first 15 minutes because they're still kind of resonating with what Alan Jackson had to say.
And also, I mean, they didn't have a break. I have to tell you, okay, this was a confession. I had to take like a nature break.
You had to have a comfort break?
Yeah, I had to have a comfort break. I think it would have been better too if you gave a comfort break between that, because I'm like at the very end, like, okay, come on, finish out. All right, let's go. And that's with a comfort break to finish that. And I have 8 pages of notes. The other thing he did, Alan Jackson, because to go through this would take probably the whole afternoon. He told, that's not a confession. That's not a confession. That's confusion. I was like, whoa, what a great, switch of words.
Yeah, I like that too. And there was another one of the big themes was the system failed. And I think that's the bigger story that everybody here in Canton, Dedham, Stoughton want people to know. this is the case. It ain't the disease, right? And so, in talking about that, he's got plenty to work with, so he can go into the Proctor factor. Why wouldn't they bring the lead investigator in? Just common sense that most people would be wondering. Yeah, why didn't they bring him in? Apparently, he's a douchebag, but why didn't they bring him in? Wouldn't he still have something to add to this story? He talks about those texts, which of course didn't need Proctor to get in, but there's going to be serious charges against the girl, and no chance she skates. And he reiterated that at the very end.
Right.
That was one of the few things that he brought back in.
Now, with regard to other thing he said, and this is Hank Brennan's answer this week, he said, not a single, and you and I've talked about this, not a single medical expert, no one from across the whole United States could the Commonwealth bring in to testify that this was a car collision. And you and I've talked about that. And then Hank Brennan's answer is, well, Dr. Squiddy Bello closed her investigation 90 days and all. You can always go back to the medical examiner office with new information and say that. But she didn't have the data. I mean, that was, and I'm like, buddy, give me a break.
Yeah, obviously, if she had learned anything new to change her opinion, she could have done that, but she didn't, and the opinion was not changed. That's a loser argument. That goes right along with Proctor. You don't have the lead investigator, and the only person who actually touched the body of John O'Keefe said his death, the cause was undetermined. These are the kinds of things that make you wonder how this even got to trial. And then that brings you right back to who was motivated, the text of Mr. Proctor, and this apparent attempt to find somebody to take the fall for his death. Let's talk about that, because they didn't go into
you have a question though on that specific point that you just mentioned. We have a question from somebody. Okay, just on that very specific point. From our member Joan. Question, Michael, for what it's worth, I know someone on the grand jury, they didn't get any of the corruption information, and she said that Karen knowing where the body was important to them.
Yeah. So like I said, I think that is something that could resonate with people. But remember, the grand jury is what it is. Only the prosecution presents anything. There's no defense counsel there. You're not going to get any of that. You're not going to have the Commonwealth telling the grand jury, let me tell you how shaky the investigation was here. Yeah, you're not going to have any of that. So it's so one-sided. And why? And that's why you can indict a what?
Ham sandwich
if
with
you're
mayonnaise or not.
If you're not using it for one of your witnesses.
Yeah. By the way, Jill Zarin's new time, just so you know, is at 4:00. We wanted her to have the benefit of a lot of other things are happening, so she's not going to tune in. No, if you're tuning in for her right now, she will be here at 1. But you should tune in for her. You should stay with us anyhow. And I so rudely interrupted you because we had that question on that specific thing that you just spoke about.
Yeah, because I do think that was a point that would resonate, and it on its face seems a little interesting. Oh, why would she be able to spot this needle in a haystack? I don't think it's that obvious that somebody needed to know where he was to see him. Not when I've been there and people have seen the video. It's a tiny yard. Come on. And at that time, even with 3 or 4 inches of snow, that is a flat lawn. So you would see a hump, a lump, a big 6'2", 215-pound person laying down there. What about Lucky? Let's talk about Lucky, which came up, of course. Lucky was, I think, universally liked, although I have seen comments that people don't like the guy. But I think in those that have been following this, don't see that he's got any agenda, right? And this jury was reminded, this is our first siren of the day.
Wow. Are they coming to get you?
Well, hope not, because it's a hook and ladder truck. Am I on fire? Am I on fire here?
You are on fire.
I'm on fire.
You are. You're totally on fire. You've gotten interviews, by the way, with Aidan Carney already, who was found not guilty yesterday. You've shown us what the scene looks like. You should tell us about the atmosphere around there. I think you, Michael Bryant, are a hero. You were the plaintiff, one of the early plaintiffs in the lawsuit that allowed the First Amendment zone to occur, to allow people to be there, people like you to be there. And you're my hero for being that plaintiff and taking that step when no one, there was about 3, 5, 6 of you initially with 3 different cases, but that's it.
yeah, I mean, I'm glad we could do something because it was just wrong. And now it's to see all the folks out in front of the courthouse. One of the reasons I'm not there with my tent, it's, you know how it is. People parachute in on the last day. So I'm here at one of my favorite locations, and I have my own tent up, which is actually working very nicely. Although it did start, it started to blow away, and somebody's walking down the sidewalk, and it started to blow away, and they grabbed my backpack and put it on one of the legs for me. But who knows?
I put pictures. You were putting pictures up, so I've been very active. If you haven't gone to our at Justice Serve TV X Twitter page, please do so. We have another question, and I'm going to read this because actually this is my sister, right? Who I never spoke to about this case. She's got two things, right? When this trial is over, the Alberts, Higgins, and Proctor should all be investigated for obstruction of justice, a conspiracy after the fact to cover up a homicide. We will never know exactly how his arm got the punctures and scratches or his eye the laceration. I think they had nothing to do with his death, which is kind of interesting, that they may not have caused his death, right? But they're there, so they had to be answered. They had to be accounted for.
It'd be nice if there was an actual investigation into those things, right? And that gets us back to, you know, justice for Officer John O'Keefe. It ain't coming anytime soon. So that is unfortunate.
What did you think about Alan Jackson's, again, I'm probably loading the question, masterful discussion of never say never or neither.
Oh, yes. Yeah. You know, I know I have a note on that somewhere. Hold on just a second.
Okay, take your time. Take your time.
There it is, Dever. Yeah. My note was she's 25 and done. And then I changed my opinion on that because I'm a sexist. She'll be fine because she's an attractive young woman. She'll be fine. It may not be in police work. It may not be here. She'll be just fine. But I do like that he highlighted the obvious to this jury, which is what kind of crap is, you know, not that I didn't say it as an excuse. And remember, this relates to her testimony about being at the Sally Port when the former chief was there. And it was matches up magically with the 42 minutes of missing videotape, right? And she testified about that, how she thought it was odd, right? When she testified to a different organization, right?
Right.
And all of a sudden,
right. Oh, yeah, right. How many times is a different organization?
Oh, she said FBI. What? How many times you counted?
13
times she said FBI.
Yeah.
I'm sure every time she said it, Judge Cannone was, you know, tightening her sphincter. So anyway, so she says, no, that was something planted by the defense. It's just so absurd. I can't imagine the jury not seeing it for what it was.
Yeah. By the way, we had a poll. How long will it take the jury to reach a verdict? 2 hours ago.
Okay. What are the numbers?
54% said today, 34% said Monday, and 12% said Tuesday or longer.
Wow.
Just so you know.
Okay. And of course, we know nothing. I mean, it only takes one really, you know, strong-willed person that believes in their convictions, and I don't mean that legitimately and legally, they just believe they're right, and if that right is opposite of the other 11, then they ain't ever going to come to a unanimous decision on one or all of the charges. I know we have it, I don't know if we need to pull it up, but I was reading the motion from the defense for transparency in the selection process. That to me is amazing.
Dizzy did convert it to a PDF, a screenshot, and we're just going to give her time to pull it in. They can pull it in here as we talk. We have a whole screenshot of the motion and the handwritten on the bottom that says denial. So
Mark Wardle says the sirens for loitering. I've seen two of Dedham's finest patrol cars go by. I haven't actually, you know, even looked my way. I have a feeling they're just saying, is this over yet? Is this done? Can we get back to our sleepy little town?
Yeah. So I don't know if we can pull that in. We'll see.
So let's talk about that. That happened.
Here it comes. It's going to come in right now. I see it coming on the bottom screen. So I'll tell our viewers what we see. We just got to give our producers time to get them.
Yeah. So this morning, the defense said, and you'll remember from last time, first of all, the overall information is that in Massachusetts, they have the 18 jurors in this case, but whatever alts they have are selected at the very end of the trial. And they do it with, I didn't know if it was slips of paper or not, but now I know it's ping pong balls. It's like roll the balls out and, you hold it up. So juror number 13, you're an alternate. The judge picks the foreperson, which is also subject to some scrutiny. But anyway, the judge picks the foreperson, and then the 6 alternates in this case, because we still have all 18 people, which is a bit surprising. They get eliminated basically with the ball bin. It's literally a tumbling drum. And all the defense wanted was, can we just see that process? Can we see the balls go in? Can we see them come out? Can we see who you're identifying? Oh, no. Negative. What is it? Can you see the handwritten note on the bottom of the motion there?
It says denied. I don't know if we can see it. There's a handwritten note. It's on the other page. It's on the first page. It's on page 1. Yeah. On the bottom of page 1. If we can go up to the bottom of page 1.
There we go.
There it is.
Denied.
There it is. All right. So the motion was defendant's motion to ensure transparency in alternate juror selection process. And it's a 2-page motion. I don't understand why it's denied. I just, yesterday Christina Rex said on her that we were all going to see this, that this was something that was going to see, and apparently they say ultimately Ms. Reed herself should, and this is on page 2, it's number 4, should be permitted to draw the alternate jurors' balls. We know that was never going. That was
definitely never going to fly. I thought that might be as I used to say in the TV biz, a producer's turd, which just means we really don't want it, but that way you'll feel like you denied us something. But she didn't really itemize anything. She didn't say this is in, this is out, this is out, this is out. They're all out. It was just denied. So we'll see. We'll see what happens.
So do you think that she's going to do what some other judges do, which, they do all that, but then they put everything in. That's not transparent, but you see the 6 come out. What do you think about that?
If I don't see them all go in, how do I believe that the 6 you're pulling weren't predetermined? Right?
That's the problem.
You could just pick 6 balls. These people, maybe they seem to be leaning one way or the other. Some agenda, whoever's picked those 6 balls. Yeah, we will never know what went into that unless we could see it.
Yeah. So what is the scene like outside there for us?
Well, I'm a block away. In fact, you can probably barely see the dome of the courthouse behind me. I'm a block away. And I'm telling you that folks, as they have gone back and forth, and they still are going back and forth because it's lunchtime, easily 4 or 5 times as many people as have been here on, a normal trial day and certainly pre-trial. And this is really the first opportunity for a larger number to make their presence known because of the First Amendment zone now in place. I commented on the video this morning how the battle line seems to have moved now to the sidewalk in front of the courthouse. This is High Street is where all the action is. Why wouldn't they have the courthouse on Court Street? I don't know. It's on High Street. Court Street's like adjacent. Anyway, so that sidewalk.
We have that in my home county, New Jersey. We have Court Street and High Street too. So
yeah, I mean, people. I guess the town planners were bored. So that street is empty, except for media that queues up when the folks come or go. So that's kind of I think where people decided, okay, we're not gonna fight over that anymore, because technically, how's that any different? It's not in the courthouse. It's still on a public sidewalk.
Right.
So anyway, so that area is clear, but right across the street, Registry of Deeds, it looks like the Trevi Fountain in Italy. All the people are camped on the stairs. The Trevi Fountain has got the stairs.
Right.
Yeah, they're all just hanging out on the stairs there. I encouraged them to throw coins at me, but that didn't happen. So that's busy. That's a busy area, and there are certainly factions of supporters. Those that are very comfortable with one another. Hanging out together. And then there are kind of newer groups that may have had less presence, but now they're here and banding together.
Interesting enough, Alan Jackson, I had to laugh because when I closed in the Spectre case against him, we also had a reasonable doubt PowerPoint behind me where everything that went on was reasonable doubt, stacking it up, reasonable doubt. Today he had what he's calling a reasonable doubt board, and he had 20 little things of reasonable doubts, stacking them into this kind of an array. But the Commonwealth in Massachusetts has this a higher burden, I think, a lot of times when they use the word moral certainty. A lot of states don't have that, right? And I thought Alan Jackson, when he said, and I'll read it, reasonable doubt, this isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. Those are powerful words, not just legal jargon. They are your mandate. They're your obligation, and they're your community's protection against injustice. Does that resonate to what the community has been feeling about the Karen Read case? Did he pick up on that outside feeling and bring it into the courtroom?
Yeah, certainly everybody is passionate about it, and whether that's because of the Karen Read case specifically or the alleged corruption in this area more generally, this case just resonates with people because they just see her as them. What if this happened to me? So they're very passionate about it. I think that moral certainty add-on, I think it's kind of an old world concept. It's kind of as a religious overtone, right? To just beyond a reasonable doubt. You start getting into people's morals and their the way they look at things and basically right from wrong. So I don't know if anybody understands what it means. I'm not sure I do. Is it one of those things that if you see it, you know it, or if you feel it, you know it? I don't know. But I do think it gives jury members a little more to think about. If reasonable doubt is everything but the last 5%, maybe, moral certainty gets you that last 5% to where you feel you got to be 100% right when you make the decision.
100% right. I'll have that too. I mean, this other thing that he had a number of, and I'm not picking on Hank Brennan because I couldn't literally. Okay, I'm going to show you. Brennan's closing was one legal page of sporadic notes, and then I felt bad. So I went to page 2 when he got to the attack on Dr. Russell. And that's it. That's what I wrote. Karen Read, should be convicted. But I had a hard time. I have a whole legal pad of stuff, and every time I did it, it was something I thought that we should talk about and put down. Like Albert never came out of the house. And what I thought was great. In the theater when you watch a play, that you get crescendos and you get activity and things go faster and faster. And you go, blah, blah, blah. It's coming up to, it's coming up to the intermission. That things happen fast and the songs are loud. And when he started talking about the bedlam on the lawn and everything, he got, his whole voice, his activity was bedlam and how he was displaying it as opposed to just talking as a lawyer, giving a closing and giving the concepts.
Yep, no doubt. I mean, it's a theater, it's a performance. And the more theatrical, as appropriate for the case, the better. You got to engage your audience here to get the message across. And you may have the best message in the world, but if it kind of drones on and doesn't really have a high and low, and it's just, I'm not saying Hank Brennan didn't at times have some highs and lows. I thought he got a little over dramatic at times, like almost like, dude, come on, that's just a little melodramatic here. But he was making the effort.
Here's something I bet you didn't know about.
Oh, that's probably true. What is that? State troopers escorted Alan Jackson to a couple of groups of Read supporters. Jackson asked them not to yell. Oh, was there some yelling going on? That's Alan. That's Alan Jackson now. No.
You want his
I don't
number?
know. Was there?
Would you like his number? I can give it to you, but not.
He's got nothing going on. I'll give him a call. What? Have you heard, from inside the courtroom, from that audio, I've not heard yelling. I can hear, noise because I'm so close. But do you think they were hearing it in the courtroom and that Alan Jackson
I don't think
telling them not to yell?
But maybe he's worried. Maybe he's worried that something will happen, that the judge will do something.
He might have been a little hypersensitive. Sure.
Yeah,
sure.
Right. And maybe he heard something we didn't hear. But also when you come to a gag order, once they close, that gag order should not be in existence. Once they close, not even when the jury goes, not even in I remember with Joe Tacopino, not even when they're deliberating. Once you close, that's it.
That's subject to interpretation, I guarantee you, because I can't wait to see what happens when they exit the courtroom after the case has been given to the jury. There's going to be a peppering of questions, right?
He should be able to answer them because it
and
shouldn't be affecting the jury. The
we'll
jury's in
see.
deliberation. All right.
We will see.
Yeah,
Yeah.
I'll tell you what, there'll be a ride or die if he tries to. They try to extend that gag order beyond that. If that jury's in there deliberating, okay, absolutely. The dog bite, the waterfall. What do you think about Alan Jackson? He started with bedrock. He started initially talking about injustice and bedrock principles. After he did no collision, no collision, no collision, okay, and integrity. And every investigation must be, filled with integrity. That's the bedrock principles of reasonable doubt. Your mandate is to protect from injustice. And then
Excuse me while I'm flying away here. Excuse me a second. There we go. Okay. Sorry. Okay. Yeah, there's just a gust of wind, and I may go airborne. Okay, I'm sorry. Go ahead.
Okay, well, then you'll be like the movie. What, I won't say the movie because we don't want to be touting movies. And then he went right from that to the waterfall video. What did you think about that change right to the waterfall video?
That's interesting. Yeah, I mean, there were so many examples he could have switched to show, that maybe there wasn't such integrity in the investigation. I don't know. I was watching it as it unfolded. I wasn't sure I was needing, or I didn't know if it was helping to have kind of beef up the Brian Higgins didn't really know John O'Keefe that well. So why is he asking him to come to the house, or at least are you coming? Are you here? Are you coming over? It was I wasn't sure they were going to go there because we didn't really spend a lot of time on third party culprit, right? And that doesn't really have any impact on, unless this was done by Jackson as an attempt to connect bad investigation with potential third party culprit. Remember, they sort of abandoned third party culprit, but there is some overlap with the incomplete police investigation.
Right. That's what the judge even said to them, by the way. Yeah.
So I wasn't sure. Okay, he's going right into that video, that whole fighting stance thing. I never bought that. I never thought that was legit. I never thought that was some sort of rehearsal for what they're going to do to John O'Keefe. Never thought so. Even that little interaction where we see Higgins and the other guys, and there's a gesturing, and there's looking back toward John O'Keefe at the bar, and I just never bought any of that as anything substantive. I thought just these guys just goofing around at the bar didn't mean much to me. The text from Higgins to John O'Keefe at about the time he should have arrived at 34 Fairview, I made a little something of that because this is a guy he doesn't know that well. Why does he care if he's going to be there?
Right. I thought that was really interesting because when he said that, I never put that in that perspective that he really didn't know him. Right.
Yeah.
And I thought, well, okay.
And I think that was a good point to reinforce because with all the players, and again, this trial versus the first, you weren't weighted down with nearly as many players, but still you kind of forget who was buddies with whom and who ended up, helping whom. So I think it was a good thing to reinforce.
Yeah, no, I thought that was really interesting. And then he went to his structure was going to the bedroom outside the house and all. And then at some point, and I don't know exactly where it was there, but it may have been later. There's a dead body on your lawn, and it was you, and it wasn't somebody with privilege like the Alberts. The police would have been inside your house immediately,
of course,
searching, right? All. And I thought he made a great point about that.
Yeah, and that supports his initial thought that it's this homeowner is going to take some hell or something. He said no, he's a Boston cop too, so it reinforces that. And I don't care how often you try to water down that back and forth exchange. Remember, the text was from and between he and Buchanan, as I recall.
Yes, it was.
It was, right, because he has the text between his friends as well. But the bottom line was there was a suggestion that whomever lives there is going to be in trouble. And it's a Boston cop. I don't think you can disconnect those thoughts just because there was a text in between them. I think the jury gets that.
Yeah. By the way, I felt very honored by Alan using the reasonable doubt board. And also he talked about science being the silent witness. It doesn't lie.
Oh, yeah.
That was my whole
the silent witness.
That science doesn't lie. And so he had that. And it's true. He said the science doesn't lie, and you may want to ignore it. You may want to say, well, I don't care what the science says. You may, want to ignore it, but I felt kind of whatever. So I felt pretty good about it.
Yeah. Well, imitation is the highest form of flattery.
Yeah, but So the photo and the X-rays. Talk to me when Alan Jackson talked about the photo and the X-rays.
Yeah, I think he makes the jury think, okay, we know there are X-rays now because we showed them to you. Why didn't Welcher have them? Is it because he was never given them by the Commonwealth, or was it because he was lying about what he actually saw? Either way, it's not good. It's not good for the Commonwealth. My gut tells me he was never shown them, because I think he would have then been able to massage his way around the fact that doesn't seem to be any, broken bone or other injury that would be consistent with a car accident. So, again, another point, tons of points made. One of the issues I think Alan Jackson did a great job dancing around, because he could have gotten downright ugly, was the sweatshirt and the holes that were cut in it by the Commonwealth lab. He used the phrase dangerous, that, when Brennan was basically caught with this misrepresentation, he called it fraud.
Right.
But
he said those three prosecutors sat there.
Yeah. And he said, he just said it's dangerous. So it's an indictment, not just of these people, but to get back to his original thesis that the system failed. And that's why, because you got people that are doing dangerous things with evidence in a trial like this.
But that's what you and I talked about. You and I talked about that when there's a lie in court, especially if you're the prosecutor, you have a duty to correct it. And I thought, for me, now maybe the jury doesn't understand the importance of this, that the three prosecutors sitting there, not correcting it, and was going to let it continue. And Lally had to know that, and McLaughlin had to know that. They tried the first case. And I can't believe Hank didn't know it. He's always so prepared, but let's give him the benefit of the doubt. The other two had a duty to correct it. And that was important. And Judge Bev had no grave concerns. That should be a referral. That should be a referral, in my opinion.
There should be some sort of consequence after the fact. There's no doubt about it. That's a black mark. And you're right. The others, by their silence, are complicit. So they should also suffer some consequence. There's no way that all three of them did not know those holes were cut in there by their own lab. There's no way.
No way.
And so to allow that to be displayed and question after question to be asked about it, I'm sure when Mr. Alessi heard that, he couldn't believe his ears. I'm sure steam was probably starting to rise because he knew he was going to sink his teeth into that. He probably also knew, as much as he wanted a mistrial without or with prejudice, he wasn't going to get it.
Right.
But still, it's inexcusable. I don't care whose side you're on. That's the least you can expect from the participants, not to mislead or commit a fraud on a witness and on the court and on the jury. Just little things like that.
And we see Judge Cannone, by the way, the thing about it is we see Judge Cannone, she didn't have any grave concerns. She didn't reprimand the Commonwealth, in public. Really, I'm going to give an instruction. And we don't, quite frankly, I don't even know what the curative instruction is that they have agreed to. I
don't either. I'm not so sure they're going to give another one. Remember, that was the request by Alessi yesterday. We know there was a curative given at the time.
Sort of.
And so Alessi wanted another one incorporated with the jury instructions. I think she said no. I think she's not going to give it.
Yeah.
So
well, I'll tell you what, that's why people are concerned about her bias. And you have to admit, if she's confronted as a judge, as she was, with a serious misrepresentation before that jury about in cross-examining an ARCA expert, and she's not concerned about that. And it's not just Hank, and that's what people, again, don't realize that Lally is sitting there, McLaughlin's sitting there. I think there's somebody else. The whole office has to know. People have been preparing that case. They can't.
Of course. I give them a little bit more, not much, a little bit more leeway if this was trial number one. But even then, it'd be inexcusable. This just is compounded because you folks have been through this in very intense detail. So no excuses.
What happened with the x-rays? Were they hidden?
What happened with what?
With the X-rays? With the X-rays, were they hidden?
Oh,
how did this whole thing come to be? Do you know? Because clearly, at some point, Welcher has been set up either by the Commonwealth or by Alessi, right? Either the Commonwealth didn't give him the X-rays, or Alessi knew they had the X-rays, or the Commonwealth had withheld the X-rays from everybody. What do you think? What's your best guesstimate?
That's I thought it was totally on the Commonwealth, but the testimony from Welcher, when those questions came up, he waffled between there were no X-rays to the ones I saw didn't include the arm. So unless he's thinking as he's on the stand, oh, I think I just sold out the Commonwealth by telling them there were no X-rays, and maybe he pivoted right in the middle of his testimony to say he saw X-rays, but not the one with the arm. I don't know. I just don't know if it was on him or on the Commonwealth.
Well, it'd be interesting. And you don't think that do you think the judge knew how it went down?
In a normal case, I would say no, because they wouldn't have their hands in the evidence to that degree. But in this case, I don't discount anything. Sorry.
Yeah.
What do you think about the one point that I was making? In fact, I made it here in town when we had Miss Shorty on, and I kept thinking, why in the world, if I ask you to search and Google hypothermia, how do I in my brain translate that to how long to die in the cold? I couldn't get the connection, and Alan Jackson pointed that out. That even if you believe Karen Read asked to have some information on hypothermia, how does Jen McCabe translate that to how long to die in the cold? To me, it's an unanswerable question.
Didn't Jackson say something like that? You Google hypothermia. Was that in his closing?
Did he say what?
That you just Google hypothermia. You wouldn't Google how long to die in the cold.
Exactly.
Right.
Exactly.
Right.
And
that's what you've been saying, right?
I mean, that's like say, I could even consider the opposite if somebody said, "Oh my gosh, how long does it take to die in the cold?" Well, then maybe I would Google hypothermia, but not the opposite. That's insane.
By the way, both parties got about 90 minutes, despite what Judge Cannone,
it was a push. It was definitely Jackson went like an hour and 23 was my rough estimate there, and I kept thinking, okay, is she going to step in? Is she not?
No, there's no way she was cutting.
I'm glad she didn't, because she did the first time.
Yeah,
with
but this time, and she gave. I had about an hour and a half for Brennan. So
maybe it just seemed like that.
Or maybe it just seemed like that.
I didn't time his.
But the experts, he really didn't discuss the experts. It was a few minutes discussing the experts. He discussed the ham sandwich. He discussed signal, and the import of signal, and that people don't know, is that the ABA recommends that we use, when we do cases, encrypted apps, that we communicate, and that we encrypt our documents, and we encrypt phone calls. As a matter of fact, in my retainers, I have to put in whether my law office or any counsel I'm working with has that encryption that will help, or whether or not there is no encryption. I have to put that in as a matter of ethics, so that the client is known. So, but see, they don't know that. So
I think WhatsApp is also encrypted. So it's a very common way around people ripping off your stuff. So I don't know that he made any points. Again, if this jury is, as they've been described, younger, then they're probably not giving it much weight either. Oh yeah, they use Signal, probably a good idea. Why don't you use it more often, dummies? Poor soccer mom. Yeah, I counted 4 soccer mom references. She was woken up early. There was yelling. There was snow. She was doing her best. Yes, she was trying to help. She was just trying to help. So I wonder if the jury is making anything out of her demeanor at the scene, because from all the cop car video and the descriptions, versus Karen Read's demeanor. Who maybe kind of knew what was already happening? Was it Karen Read because she miraculously spotted John O'Keefe's body when nobody else possibly could? Or was it Jen McCabe because she was orchestrating very calmly everything that was going on, very calmly? And this is a good friend of hers dying or dead on the lawn. So
Yeah, we have a couple other questions for you. Red Green asks, can you explain why Bev never allowed the basis for objections and arbitrarily ruled throughout the trial?
That's the way we do it in Massachusetts. That's the way we do it. No, I think that's her personal reason, and I've kind of blasted her in the past saying that it gives her an out when something goes up on appeal, because if there's no record as to what the objection was, therefore any decision on that objection is meaningless because we don't know what the objection was. That leaves the appellate court to totally defer to the trial court, as they do anyway.
Wait, I see Neil Rockhine's in the chat, not guilty. Neil, are you ready? Are you ready to come on, buddy? We've been trying to reach out to you. Can you come on today? Like now? Because if you can, Missy's going to send you because we can talk even through the charges a little bit. Missy will send you a link. Don't it? So could you just let us know, Missy? You're hearing this. I know you're working on people to come on so we can have the reactions and discussions. But in the meantime, we do have another Brooklyn ask, and Brooklyn has one of our mugs. It's behind me. I don't know if you can see it. I don't know if I have to go which way or the other way. It's there. I don't know. It's right behind me over here. Okay. I love you. Neil says, I love you guys, but can't right now. Well, what about later on? Like, how about 3? How about 3 o'clock? That would be good. 3:30 to 4. That would be good. 5 o'clock would be good, Neil. Please let us know. Okay. I'm a tough master, as you can see.
You're man.
Brooklyn says, Turtle Boy says that juror number 11 is the most favorable to Karen Reed. Hope she doesn't get bumped off. I know Turtle Boy's been keeping a running count. He's been going through of the jurors, right?
When I saw him this morning, he hadn't gotten in, and we went through that whole randomizer BS. But maybe he became an alternate to an alternate.
Yeah. He had gone in. He actually did get in, and is watching.
Who wanted
the
to
jury.
see me? I'll see you at Sidebahhh for just a minute.
Oh, of course you.
Okay. Who wanted to see? Let's see who wanted to see if we can tell.
Let's see. Sometimes who's leading the charge? Was that Alessi that was first up?
No, Leslie's back here. It was the prosecution. Yeah. Look like it was the prosecution. I don't know whether they have something to. So anyhow, it's there's a lot going on, is all I can say. Let me go to Turtle Boy's chat. Of course, and by the way, the interview with Turtle Boy, maybe we can pull it in and play it later, Michael, when you're on. Maybe we can.
Not a bad idea. I'm gonna break and wander around a little bit. I'm not.
Well, they're back already. They're back already.
I don't think I'm going to sit here for the instructions, to be honest with you. I'm going to power down and go wander.
Right. Let's see what's happening here. By the way, Aiden points out that Hank video 77 minutes into a speech never showed the paint video, the blue paint video, supposedly Judge Welcher, the most important witness.
It's funny. I called it a high school experiment, and I think Alan Jackson called it a grade school or kindergarten experiment.
Yeah.
I was giving it way too much credit.
Yeah, that's so. He did get in, Aiden, which is really the way it should be. Yeah.
It should be, yeah.
Yeah, and the Hank Brennan calling Barrows basically a liar. I thought that was pretty awful. That was pretty.
Yep.
Disgusting.
Why would he? And again, I wrote that down as a good point, just because it does sound odd that he traveled all the way to their defense hotel instead of just getting the info on the phone. I think there's something to make of that.
I think the defense demanded to see him. You're not going to win the day because
I have no problem with. Right. I would want to do that too, but I'm telling you, somebody might resonate with somebody like, hey, what do you need to meet with them for face to face? Probably trying to convince them to say something.
Yeah. Let's see what happens. What is she going to do here?
She's going to start reading, and I got to go.
And you're going to go. You're going to go take interviews, and maybe if she goes on a long extended break, we can bring in Aiden's interview. Get that ready to bring in.
Yeah, I think that's about 20 minutes, and it's a couple of different interviews. His is built into the middle of it.
We could stop and start. Apparently, Dean is live streaming in front of the courthouse or around the courthouse. So, just so
good.
You know.
She's doing that for
Resistance Now.
Yes,
or
Resistance to Silence. Yeah.
Okay. Right. Okay.
Well,
all right. So, you're going to go.
I'll leave you and the fan alone.
And, me and the fan of injustice. And if there's a not guilty verdict, it will turn into the fan of justice.
Okay. I'll check with you later. Bye.
Okay. Bye. I'm going to still be here with you here on this.
All right,
see.
jurors.
Remember, we have Jill Zarin at
Going to give
4.
you the instructions
And
now
this
in the law.
instruction
But
should
first, I want to thank you
take
for
about an
serving on
hour,
this jury
just so you know.
and for
So
being so attentive.
I'll
You'll
be
soon
behind the
deliberate
TV
for the
app.
purpose of reaching a verdict. But before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. only the testimony of the witness, that is, their answers to the questions and the exhibits or evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable, or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involved factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle. The condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser vehicle under the influence of liquor, also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, I'm sorry, hold on. And the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay. Thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right, so I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous to reach an unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at Sidebahhh, but I'm required to see counsel at Sidebahhh.
Okay, so she is required to see counsel at Sidebahhh because that's where they're going to make any objections to what has occurred here in the jury charges. Now, remember, by the way, let's talk about, she picked juror number 1. Now, as I see, there's all sorts of conspiracy theories out there. And Carney said that he took no notes. He's a middle-aged black man, took no notes. But that avoids, quite frankly, any challenge because she's just going to say, I picked juror number 1, all right? Just like most states do to avoid the challenge. That's going to, in my opinion, avoid any, certainly it's not going to have an equal protection challenge that you couldn't have somebody racially identified who's less than, who is a minority that doesn't even get into consideration. So I think that is over. Whether or not you think he's for the prosecution or not, that's a different issue, okay? So let's put that aside. The jury charges. She said that she had to give the whole charge on murder, even though the prosecution was, an agreement with the defense was not seeking the first 2 ways you commit murder by a defendant, okay? I think that makes it very confusing. She said that the Supreme Judicial Court said she has to give it. The second is really confusing. The prosecution didn't want the involuntary manslaughter charge, but and the defense agreed. She gave it anyway. All right. To me, that's the most dangerous one for Kennedy. Anyhow, what we're seeing things go into.
Yes.
We're hearing ping pong balls. Okay. Let's watch. Let's see.
Could the juror sitting in seat number 13 step down and take your place as an alternate?
Uh-oh.
Could the juror sitting in seat number 7 step down and take your place as an alternate? Juror 6, could you step down and take your place as an alternate? Juror 17, could you step down and take your place as an alternate? Juror 2, could you step down and take your place as an alternate? And juror 8, could you step down and take your place as an alternate?
Have it. Juror number 13, 7, 6, 17, 2, and 8
right.
are alternates.
Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternates in some separate but convenient place until they agree that you not suffer any person to speak to them, and to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged their verdict, except by further order of the court, so help you God? Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
I will tell you that according to Aiden Carney, the remaining 2 black jurors, there were 3 black jurors out of the 18, the remaining 2 out of 6 just got eliminated, okay? Interesting. So there you have that. And then according to Aiden Carney, too, juror number 1 did not take any notes, but he seemed to be fine. I don't think Aiden Carney reports, I don't think that 4-man choice is a bad thing. The juror does not come across as a kind of guy who likes Hank Brennan and blindly trusts police. He showed 0 facial emotions the entire trial. I have no idea what's going on in his head. Well, that's the way it, quite frankly,
I'm going to see counsel one more time.
Okay, I'm going to see counsel, and that may do maybe to still suggest that her picking the jury, they still may have to make the point that her picking juror number 1 is still a violation of the Equal Protection Act, in that you're not considering all the jurors in the jury pool to become jurors. All right, that's the basically instruction. Anyhow, so she gave the lesser included involuntary manslaughter. They're very confusing. I even said to myself, well, what's the difference, okay, between manslaughter and the involuntary here in Massachusetts? I usually know most states. And so she said, well, let me explain to you jurors what's the difference. It has a negligence aspect to it, but you still have to prove all the other stuff. But all the other stuff is very confusing. I mean, to me, that's, again, the most dangerous count here, that some jurors just like throw up their hands. And she told them, by the way, that she says, don't take a straw vote. I've never heard that before. Jurors many times do take a straw vote. There's usually several types of jurors. We were trying to get Dr. Ward back on, but she can't come on today. She's busy. They do normally, there's 2 types of juries. It's ones that will take a straw vote, like see where everyone is, where they're at, and then go from there. And the others who want to look at all the evidence, and they want to find their truth after themselves. The second part takes a longer time. The second group usually takes a longer time. The first group says, well, where are we at the big issue? So you really need somebody to say, well, isn't the issue here first that she hit him, right? Did she hit him? If she didn't hit him, we don't need to decide all this other thing. But the fact that she says that the Massachusetts Supreme Judicial Court requires her to read all aspects of a murder charge, when that's not what the prosecution is charging, I don't think that's kind of what the Massachusetts Supreme Judicial Court meant with regard to that charge. But she did it the first time, and it wasn't overruled, so she's doing it the second time. Okay, so let me go through. Most people that have been in the courtroom know what the jurors look like better than those who haven't. Juror 13, Juror 7, Juror 6, Juror 17, Juror 2, and Juror 8 have been chosen as alternates. Juror 1 has been chosen as the foreperson. Aiden Carney reports he is a black middle-aged male. Michael Bryant, by the way, is out in the field. He is getting some reactions, and obviously he should stay out there, because I assume that Karen Reed's team will come back out and possibly go to where they have been, or David Yannetti's office, to wait for any notes from the jury to come back to the court. Okay. How late will they stay tonight? Well, I have a lot of questions to ask. There may be, she said initially 5 or 5:30, but she didn't tell them that right now. So maybe they're going to stay to 4, and then she'll send a note in, do you want to continue today or not? If they say they'd like to continue, she'll keep them to 5 or 5:30. That's what I anticipate she means. Okay, now let's go to some of your questions. Penny G, why not describe the difference between unreasonable doubt and reasonable doubt? Because these jury charges that we have usually are mandated by a Supreme Court. There is a charge committee in every single state. The charge committee comes out with standard charges and judges aren't allowed to deviate from
Judge,
them
the
unless
first thing
they
is,
have a
counsel
special
this
charge.
morning and
But
yesterday.
let's
looked at
listen.
exhibits,
There's a problem.
And I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150? 155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory is not perfect, but I believe that we were going to have this redacted, subject to the same redactions from last trial. I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe it was redacted last time, so if defense
Okay.
wants to make that reduction, we can go into evidence.
Great.
I'll see that Sharpie and maybe I can take care of it.
I think we
Of
probably
course,
have
we-
one here you
I
can
have one.
have.
I
We
definitely have
can't
one.
hear what the actual exhibit is.
right.
I didn't
That's
hear.
number one. And number
Okay,
two is,
let's listen.
can counsel look at the verdicts and just tell me if verdict slips and just tell me if they're okay with it? Thanks.
All right, so
You'll see
now we're
that it's
going to
not
hear
what
the
you
verdict
provided
slip.
me yesterday, Mr. Kennedy.
Maybe we can get a copy of it once she has handed it out so that counsel, whose case this is, are seeing it, it looks like, for the first time. I mean, that's kind of frankly pretty outrageous, don't you think? Now they got to hover and all. I said this jury's not going to start till about 3 because they don't have verdict slips anyhow, and they have to wait for the evidence to come in. But she just provided them, and believe it or not, David Yannetti had to ask, can counsel see the verdict slips that needs to be redacted? Yeah, one line needs to be redacted on that one exhibit. I just don't know what exhibit it is and what the line is that needs to be redacted. But right now, they argued this yesterday about the verdict slips, right? And the defense wants to make it clear that the jury can, tell them when they have a hung jury, and if they're hung or if they've reached the verdict on other parts of the case, the judge won't do it. But now they're just seeing the verdict slips for the first time and have to make an objection, okay? Because unless you make an objection to them, you can't preserve your record. Quite frankly, it's outrageous. And did you see that Yannetti had to ask? Is it, can counsel be provided the verdict slips? Oh, give me a break. I mean, in every court, the judge goes through verdict slips with you and goes through where they don't call them slips. They call them, the verdict form that the jury has to fill out. So I will get back to your questions, but this is quite frankly pretty outrageous in my opinion. Aiden has not tweeted about this, but by the way, he also tweeted just what Michael Bryan said. Legacy Media, who hasn't been covering this trial, and who's when they got picked for randomizers,
Counsel, you can
not
keep
been in
doing
the
that.
court.
Mr. Rose,
Let's
can you
listen.
raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they agree, nor suffer them to disperse them, they charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you.
Okay, that's because you have to swear the court officers who are going to deal with the jury to make sure that they can take the jury, make sure the jury doesn't get tainted in any way. But obviously, there's a problem with the verdict slips the defense does not like. And what I find is outrageous that, Yannetti had asked, can counsel, I'm going to get to your questions, but I think this is more important. Your questions are all obviously important, but this is really, this is a core issue in the last trial, all right? So in order, before the jury even gets these, let's see, him here, so we can hear. Almost content, almost. So there's a problem. And why they couldn't have these last night or this morning?
Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses.
It's usually what most states do.
Really ran into the same issue last time. I think what complicates it is fact that there are two theories for two of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying
We
that.
don't
I'm
have
saying
verdict
that
as in.
It makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So
Okay.
we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti? I have not found any. I've looked.
How about the U.S. Constitution?
There's not a lot of case law out there even to support this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean that
So
with all respect.
that's fine. So your rights are reserved. Does that help you?
No.
Right, well, all we can do is object, Judge, and you make,
Okay.
you make the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know.
We'll do.
Okay.
The last couple things, judges, that we were provided with a clean computer laptop. Thanks. We were, with a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think it's fine. But
All right. So we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
and then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right. Thank you.
All rise for the court, please.
Okay, so what you had there is the jury's going to get the exhibits now with the one redacted exhibit, one line redacted. I don't know what that is. Counsel's happy with the exhibit list that the court clerk has provided and all. But this is the same issue we had last time. So you're talking about weighting that jury. It's quite frankly, it's weighting that verdict slip. There are 7 choices for guilty and 1 choice for not guilty. 1 choice for not guilty. She's accused, and by the way, she's accused of only the 1 issue of the murder, not 3, and all. And then she's accused of the manslaughter and the lesser included involuntary manslaughter, and she's accused of hitting somebody and leaving the scene of the accident, right? After you have hit somebody, right? And all. So she's accused of all these lesser included that, by the way, counsel had agreed upon that weren't appropriate. And now the judge is weighting this by setting in 1 guilty, 1 not guilty, and everything else is guilty on the basis that, well, I guess if you're not guilty of the murder on the top charge, you can say that. But the jury doesn't know that if you're not guilty then of the top charge, that all of that fall, that that of the collision, all that falls, because they know usually what it will say. Look, if you find it not guilty of the murder, then you go to count 2 and you look at the number 1, voluntary manslaughter, involuntary manslaughter. And if you find not guilty of voluntary manslaughter, you can look at involuntary manslaughter. So the step process by which a jury has to deal with goes forward. And she was, quite frankly, very kind of like, well, you have any case law on that? And Yannetti said, there's no case law on what you're doing, Your Honor. And she said, well, it hasn't been found to be wrong. And he said, not yet. So she kind of like, how does that happen? I mean, it was like a child. To me, it was like a kindergarten child. Right. Right. We're gonna weight this verdict slip, which is the verdict form. I have never seen verdict forms that if you're asking somebody whether or not they're convicted of crimes that don't have not guilty on them. If you say that they're not, I can't. I'm beside myself here, not just by the fact that she did it, not by the fact that Yannetti had to ask for it at the last moment, right? Maybe when we see it, I was like, well, here. Oh yeah. Oh, here it is. Yeah, you can have it. Here it is. All right. And then they all have to sit and hover to try to go through it to see what the problems are. And I'm sure if there's more problems, they'll come to, they may file some kind of motion on it. But this is, again, ridiculous. Well, your rights are preserved. Okay. Well, your rights are preserved. What if Karen Reed gets convicted? Her rights would be preserved. Supposedly, the remedy for what happened in the first trial, the reason why the court didn't do anything, is because she got a new trial as a remedy. So when you get the new trial as a remedy, what are you going to do? You're going to repeat the same verdict slip or verdict form that you did that caused all the problems to begin with. I mean, it is, quite frankly, ridiculous. Okay, it is ridiculous, and we didn't even get a chance to talk more about the jury. I don't know, about it. I haven't had a chance, by the way, to tweet about the verdict slip. But again, it says, here we go again. All right, it's Groundhog Day, but not in a funny way. It's Groundhog Day, but not in a funny way, right? It's ridiculous. Okay, we didn't have that problem in Aaron Hernandez. The judge gave us, for the most part, a fair trial. Yes, did we go head to head with him on a few times? But he was kind of cute. He would bring us a sideboard and say, "What did I do?" Because he knew that we knew what we were talking about. He didn't go at your face and say, "Well, I'm going to give you an unfair trial," because I know Mr. Hernandez was convicted of a murder case, which was on appeal, of course, at the time. Then let's ram it down your throats, or try to become the prosecutor who sits with the prosecutors by giving. I'm telling you, this is an unfair verdict slip. This is one that's going to cause these same problems. And then she told the jury that you can't go in and take a straw vote, or she suggests you don't, which that suggestion carries great weight. All right, because jurors can and may go in. Many jurors do say, well, it's not a straw vote. Well, why don't we find out where we're all at? Do you think there was a collision? Do you think she hit him? All right, if they all say, no, we don't think she hit him, that's it. So what is this thing? Well, we got to look at all the evidence first. To look at all the evidence is going to take them, obviously, a longer time. And they may not feel they need to look at all the physical evidence exhibits that went in because they feel they have enough of it. Juror number 1, by the way, who's now the foreperson, didn't take any notes. So I think we're bringing up the verdict slip. Is that what I think is happening here? That we're bringing up the verdict slip? Okay. Yeah, all right. So, by the way, I just want to let you know, hopefully I see we have friendly emojis. Oh, that is so great. We have friendly emojis. And I'm all for that. I was a big supporter when I was in Martha's Vineyard of the school up there. Most of you who are hard of hearing know that there was a school up there for sign language and people that were deaf, and it lasted for almost 100 years until it closed down about 5-6 years ago, I think, just before the pandemic and all. All right, so let me go back to your questions for a second, okay? While we're I'm going to say Injustice Watch right now. I would like to say Justice Watch, but I think that slip, unless we have some really strong jurors for Karen Read who understand what went down here, that the prosecution has to prove collision beyond a reasonable doubt, I don't know. So the standard model jury charges don't usually go into unreasonable doubt. Sometimes a judge will ad lib and say, well, it's unreasonable if, I'm looking at I can't even think of some of the, one of the old type of things they used. Okay, yeah, I'm looking at my husband upstairs, okay? I'm staring at him, and somebody tells me that it's not him. Well, it's kind of unreasonable because I'm seeing him, I know him, and also I can't draw an inference that it's not him, right? That would be unreasonable. But the model jury charges, the modern ones, really don't talk about unreasonable doubt. Again, you can't have a judge that ad-libs, but not, this judge not ad-libbing except in the verdict slips. Okay, that was from Penny. All right, Penny G. I mentioned that before, and then we went to the judge coming back, not showing whatever it is. Now, here it is. This is the verdict slip. Now, I have not seen this till now. Let's see if we can close in on it, then we will get back to questions. Let me see if we can we bring it up a little bit bigger? Okay, I see, there we go. Okay, offense number 2, man, this is the verdict slip. This is the manslaughter. This is, I guess we passed the murder, but here's the manslaughter one. Let's look at this, because this is the one that's most confusing, and quite frankly, I think the most dangerous for Karen Read. Manslaughter by OUI, operating motor vehicle, under the influence, okay? In the above entitled case, the jury says defendant is not guilty of the offense charged or any lesser included offense. And then it goes, but guilty, 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 okay? So what Yannetti is complaining about, that one line that says not guilty of the offense or any lesser included charge, is confusing, because you look at, like, that's one, but what about all, but now you're telling me I have all the rest underneath it. And he says it's weighted because you have 1 not guilty, and then you have 7 guilties, right? And I think that is absolutely wrong. I mean, I think it's wrong. I think Yannetti's right. But to just thrust that on them at the very last moment and not to have the defense have a chance to look at the proposed verdict slip is ridiculous. Well, I guess you could say they had a chance to look at it, but after she did it and it was like very clear she wasn't going to change it. All right. And that's what's driving people crazy about her conduct in this case. Okay. Let me go back to 007 from Texas. Okay, I guess my hair is not closer to God today. Remember yesterday we had a whole thing about, because I had this thing, my hair was high for an event that I was closer to God, and as they say in Texas, I love the sayings there. That's really good, but it's back to its normal phase. All right, 007 Texas. Can she be found guilty of anything that doesn't include hitting John? No, she has to collision. If they find that there's no collision, that's it. Case over. Okay. But you're going to need a strong juror to go in there and say that and say, look, why don't we decide the seminal issue? Is there anyone have any doubt whether or not there's a collision? Let's talk about that. Because if there's no collision, there is no crime. No collision, no crime. No collision, no crime. I think I would have made that other, shall we say, jump. If I were AJ, if there's only one thing I would have said, no collision, no crime. No collision, no crime. So make sure the jurors understood that, because even the fact that you're asking the question and you watched this 007 Texas, I know that because you've been with us the whole time. Tells me that maybe the jurors think that you can find her guilty of something else. Okay. And by the way, you're going to stay with us next hour. We do have Jill Zarin coming on, by the way. Oasis Cat, again, I know this is the most boring part for us to hear. This is the most important part for the jury. It's what they have to follow. You're absolutely right, okay? Now, when we are attorneys and after we finish trying a very hard, long case, okay? We hate sitting there, by the way, because we know what the charges are going to be. And we hate sitting there and listen to those like 29 pages being read, all right? Because we're tired and we know what they are. But they are, and by the way, when they're read, when you come back in after the charges are going to be read, except for objecting to something that may have happened if she didn't read the charges right, you put your pen down. You may not even have a legal pad. I know that there's only usually one member of my team who has a legal pad on it, but you put your pen down. There's nothing else you can do. And it's not a feeling of relief, okay? It's a feeling of, what is it, if anything, I could have done better? Because, now the proverbial saying, the rubber hits the road. So you're almost blaming yourself, thinking, what could I have said? What could I have done differently? Could I have done anything differently? Because now it's out of my hands. My client who is sitting here has trusted me with their life, okay? It is a very hard feeling. The only worst feeling is when you have to stand and wait for the jury to render their verdict. Okay, and I can tell you, every trial lawyer in the world, whether you're on the prosecution or the defense, has a pit in their stomach and wants to throw up. All right, at that point. So, but Oasis Cat, thank you for reminding everybody this is the most important part, because they will go to those jury instructions. They will have a copy inside, and they will go to them. And sometimes they'll get hung up on a specific little point and all. Usually, juries will have a question about the jury instructions because they're so confusing for everybody, okay? 007 in Texas again. See, you're confused. Can she be found guilty for driving unsafe even if John wasn't hit by the car? No, that's not here. The driving unsafe has to be that there was a crime. There has to be a hit. So, so there we are. But see, the fact that you're confused and you watch this case and listen to these charges, it's kind of telling, isn't it? It's kind of telling. And the fact that Judge Cannone, who in front of the jury seemed very nice, right? But there, with her attitude toward the defense on that verdict slip, okay, I'm embarrassed. I'm embarrassed that, and I'm probably never going to be asked back to Harvard to teach at the trial advocacy workshop after my comments here. But I, quite frankly, I'm embarrassed about her conduct here. All right, and I wasn't. I was defending her, as you know, through most of this trial. The same with Hank Brennan, and then it just became too much. It was too clear. It was just too much, and it was terrible. If this is what people are watching overseas, hopefully this is not what you're seeing. You're seeing more, this is more like seeing Judge Glanville. Actually, it's even more underhanded, right? Because Glanville was clearly over the road. The jury was offended, but she's kind of nice to the jury, right? Kind of like, and then we see the conduct towards the defense when the jury is not there. Rizful me. Can someone explain the first count? They claim she beat and assaulted him, resulting in death. No, this is it. This is the problem. In Massachusetts, there are 3 prongs to be able to convict a person for murder. The prosecution and defense said, you don't need to read these first 2 because that's not what we're charging. All right. Even the prosecution, give Hank credit. Okay. That's not what we're charging. We're not charging that. We're not charging that in intentional murder. Right. And then what happened was she said, well, the Supreme Judicial Court says I have to read this jury charge as is no matter what. So she read the jury charge, and now it's going to lead to confusion. They're going to think, I'm confused. I think, for instance, even the whole idea of bad conduct with Aruba, what bad conduct? They had a fight. All right. You want to tell me which one of you want to come forward and say you have never had a fight with a loved one. All right. Which one of you want to come forward with me? I'll guarantee you Judge Beverly Cannone's had a fight with a loved one. Okay. Not a fight in the sense of let me beat you up, but a disagreement. Right. And because she had a disagreement or because she was upset because he appeared to be cheating on her with the 2 sisters after she had taken care of his kids during the pandemic, and I say his kids by guardianship, she was upset. All right. That doesn't mean that a year later, or 3 months later, or 2 months later, or 1 month later, it can be 1 day later that she ran him over purposely. Okay. So if you're confused, I'll guarantee you the jury is confused. All right, Karen McCord. Seriously, she basically said, if you can't come to unanimous decision, we're trying this case again. Oh yeah, there's no doubt in my mind that if this jury hangs again, there's no doubt in my mind that the prosecution is going to try this case again. All right, there is simply no doubt in my mind. And there have been cases where a judge has been allowed, or jury has been allowed to come to try a case 3 times. Then sometimes they'll say no more. The courts will say no more. But there's a famous case where the man was tried 5 times, and finally, I think it was the Supreme Court that said 5 times could be cruel and unusual punishment. You can't, after so many years and trying 5 times, and the jury can't come to a decision, give it up, prosecution. So talk about being unfair. It could happen again. Okay. And at some point, the attorneys who aren't getting paid and the money runs out, you can't keep going through it. Okay. Penny G, any instructions about unanimous on all needed? Yeah, she did say you had to come to unanimous verdict on all of the early on, and was one of the generic charges early on. She divided them into the generic charges, then the specific charges, and then the charges afterwards about the how they're going to come to decision, and the fact that there were going to be alternates and the 4-person and all. And as I said, she avoided the four-person by just picking juror number 1, who's also a Black male, middle-aged. So she avoided the issue of age, she avoided the issue of race, and avoided the issue of was she being unfair. So, we'll see. We'll see. In most states, he would have been the 4-person anyhow. So everything we were complaining about. But he didn't, apparently, according to Aiden, he never took a note in the whole trial. But that doesn't bother me, because jurors, and I've seen this in a case I've had, they will sometimes come to an agreement. Okay. And they may think that juror number 1 was always going to be the 4-person because they know they watch TV. They say, well, let the juror number 1 listen to all the evidence. Juror, I will take all notes. You juror, you take notes on this aspect. You juror, you take notes, and they will decide among themselves. They will even have assignments with them as to who's taking notes on what. So you can never tell just because a juror doesn't take a note. That doesn't mean the notes aren't being taken. But sometimes there's a juror who takes notes on everything. That doesn't mean they can remember it. I take notes on a lot of stuff too, but sometimes it's my memory of how I think the evidence went in. So I always tell people, don't get worried if jurors don't take notes, because they may have thought number 1 was going to be the 4-person. They said, okay, you listen to everything. We'll take the notes, but we want you to take everything in. I mean, it's very common. You'll be surprised what jurors agree to. Let me just take a sip of my Dunkin' Mango tea. Okay. All right. So I'm not as worried about at all. Plus, jurors can take wrong notes when they're not listening to evidence. You can take notes that are wrong. I've taken some notes here, and then also I missed what was said on the stand, and I said I missed it, and had to come back to ask all of you what did I miss? I feel like I'm singing in the Hamilton, what did I miss? And I'm Thomas Jefferson. I was away from the United States for a period of time. The alternates are 13-7, 6, 17-2-8. You can research them. I know Aiden has a list of, he had ranked with what he feels are the good jurors for Karen Read and not the good jurors. I'm sure, you know that the team had them ranked too. They had them ranked based on sociological research. They had them ranked based on talking to prior jurors as to who was good. It's my feeling they felt that younger women were better for Karen Read. That's my feeling. Okay. I don't know what the final makeup of the jury is that went in to deliberate. Let's see if we can go well, let me answer two more things, and then let's go. Blessed in Texas, thank you again for another Justice Serve TV membership. All of you are so important to us. And of course, you're going to stay, because at 4 o'clock, we have Jill Zarin on, who's been following this case. She's one of the original gangsters, I like to call it, the original housewives of New York. I'm going to say New York as opposed to New York City, because I think New York City is probably, there's a map of it being the world. All right. And she's going to be on. She's been following this case, and she's been very active on her Twitter account following this case. So we're going to have a discussion. We're going to answer her questions, and hopefully she can answer our questions of what she's seen. All right. By the way, then we have, Kay Lala. Hi, Kay Lala. How are you today? All right. There's nothing wrong with an initial vote. That's a normal part of the jury process. As I said, jurors there's two types of jurors. Okay. There's two types of jurors. One that go in and they say, let's see where we stand. All right. Why don't we just take an initial vote to see where we stand? Okay. And they see where they stand, and then they go from there. They deal with their deliberations from there. All right. And that's what they normally do is go with their deliberations from there. And that's how they do it. Other jurors will say, no, let's look at all the evidence first. Let's discuss it. And let's find for ourselves. And those are the juries that take a little bit longer. And so it's definitely the kind of jury I had inspected. It was definitely, we thought that at least there was certainly one juror in Hernandez that was that way, because that was 5 days. They were deliberating and they came to a not guilty. But the longer you go, you usually is definitely, you need to hang on a long time, a fairly long time. And fairly long time these days is 4 or 5 days for a hung jury. Although we've seen hung jury votes come back after 2, right? And then the judge gives that Allen charge. So in the world of social media, and everyone has a quick decision, quick verdict, it's gotten a lot less in terms of how long juries will stay out before they say that they can't decide on a verdict. Okay. Apparently, the last jury we know had decided, according to many people there, had decided that counts 1 and 3 were not guilty, but the judge didn't do anything once that was that. Now, there was a danger, right? They said, well, the defense didn't ask for them to be read, and that's true. And we saw that yesterday, and it was yesterday, the day before, in Harvey Weinstein case, where the jury said they were hung. And so then the defense asked for them to the judge to inquire further. And it turns out they actually were hung on 1 count or 2 counts, but they had decided 1 count. In that case, had the question not been asked, it would just been a hung jury. All right. So there's always a danger. And I'm sure in the last case, that's what the attorneys were considering, the danger of asking for, well, have you reached a verdict on any count? So she did not tell them that. She didn't give them that information. So if we get to that point that they say they're hung, the defense is going to have the same issue here. Did they ask for, have they reached a verdict on any count? Of course, the question you want is, they reached a verdict of not guilty on any count, and they come back and say, no, they haven't reached a verdict of not guilty on any count, or something like that. But that Judge Beverly Cannone is not going to do anything that's going to help the defense. You and I both know that. So Michael Bryant is out in the field. He is getting interviews. Let me see. I think he has uploaded them. I want to see if he has uploaded some interviews. I know we have one of Aiden this morning, but he was talking about that he was uploading at that point. I just want to see so I can tell you if they're there. Hold on one second. Any other interviews that he was getting? Yeah, he's got a couple interviews. He's got the exclusive. We got the exclusive interview with Aiden Carney, and then he just started about 30 minutes ago, uploaded a 12-minute segment on the closing arguments. He was taking live reaction at the scene of closing arguments. And I do want to go to Aiden Carney's page, his X page, while I have you right here, just because he had a tab of how he felt the jurors are. Now, that doesn't necessarily mean anything. But, he's on top of this case a lot. He's been in the courtroom as much as he can. So he had ranked the jurors from 1 to 18. Let me see where he ranked. He ranked 13 as being best to worst based on his observations. He ranked 13 as being third from the worst. He ranked 7. I don't even see 7 here. Oh, here are the jurors that were eliminated. 4, 7, 9. He's got 4. He's got the jurors at 4, 7, 9, 14, 16, 18. I have him at 13, 7, 6, 17, 2, and 8. So we have different ranking. We have different jurors that were eliminated here in terms of his list and my list, Dizzy. So I really can't help with regard to his, because he talked about the ranking of the jurors first to last, and then his jurors that he has eliminated are different than my jurors that I have eliminated here. So I don't know why that is, because I know I took the numbers down right. Okay, so we'll have to see. We have a little, so I can't really tell you anything except tell you that the out of the 3 black jurors, 1 is the 4-person, and 2 others out of the 6 were eliminated. That's all I can tell you. That's all I know at this point. So we'll have to wait. Okay. Let's see. Jessica Machado is talking about the juries. Let me see what she's reporting on. Okay. Juror number 1 did not take. Juror number 2 was a middle-aged female who's been chosen as an alternate. I have her. Juror number 3 remains on the jury. This is Jessica Machado. Juror number 4 remains on the jury. Is a younger male who was first seated closest to the witness stand, but was moved to this seat. So he was the one who was talking apparently with the young women, and they were having a conversation. So they moved him. Okay. Juror number 5 remains on the jury. Let's see. What else does she have in her comments here? Okay, so then don't see the rest of her ranking. So comments in the comments below. All right, so let me see. Can't tell you. So we'll get a better feel of that later on with regard to the jurors and what is going on, and who is defense friendly they think and who is not defense friendly and all. So, yeah, Dizzy says, yeah, no more Arbor for me. Yeah, probably not. I think they'll take a judge over me because that's the way power works, Power chooses power, right? So that's the problem. And that's why I think Alan Jackson made such a big deal out of what was going on, that in the courtroom has to be reflective of protection for everybody. So, will I come back today? Well, we're getting out a little late. I know that we have Stephen Plort on standby. He and Neil Rockheim both thought that today would be a not guilty verdict, that they'd go in and all. So we're going to see, okay? We're going to see, Okay, let me answer this. Anika A. Linda, the other day you mentioned you were a little concerned about quickly the first 10 jurors were picked in the jury selection. Do you know of how many of those the first 10 made the jury? I do not, because it appears that the juror seats, was apparently changed, unless they're just doing 1 through 10, and they eliminated 2, 6, 7, and 8, and 2, 6, 7, 8 were the first 10 jurors. I felt that was their numbers, but if that's the case, if they went straight through 1 to 10, then 4 of them of the 6 were eliminated. If my numbers are right, but Aiden has different numbers. All right, so I did hear something in my ear. I think that's something in my ear. It looks like it's under a 10, and that may be Michael Bryant, because I was about to go play the interview with Aiden Carney that we had, but he just did interviews with, shall we say, the person on the street, and there he is back there. So
I'm exhausted.
You had, well, first of all, you were up at 5 driving. Let's face it, to where you are, right?
So did you see what I posted about the gag order? Did you
No,
notice
that? I did not see that yet. Okay,
and I just uploaded the video. So we were getting the folks as they were leaving, of course.
Right.
I'm shouting out questions to the attorneys.
Right.
And Alan Jackson, the first thing he said was, we don't have any comment right now. We will in a few minutes. And I'm thinking, okay, well, that's interesting. Are they going to make a statement? So as the scrum is moving along and my IFB is ripped out of my ear, I'm still just thinking, oh, hopefully it's still recording because I can't hear a damn thing. And I asked Mr. Yannetti, I said, Mr. Yannetti, are you surprised you didn't get the verdict slip
Right.
ahead of time? He says, I can't talk to you. We're gagged. And you said, you're still gagged. That's wrong. And
That's
he just
wrong,
said, I'm
right.
sorry, I can't. So that's the story. They're gagged still,
Okay.
for whatever reason.
Judge refusal. That's absolutely wrong. When you, once the jury goes in, that's simply absolutely wrong. In the speculative case, the judge tried to gag us forever on one piece of evidence. So you can't. Well, they have no jurisdiction over you afterwards, right? So.
I guess they're just trying to play nice. I don't know.
Yeah. How about that verdict slip being? Yannetti has to ask for the verdict slip to see it. She said, "Oh yeah, let me give it to you. Oh, by the way, this is my lunch. Okay,
that's
that and
why
a Dunkin'
I asked,
Donut. Okay,
if he was surprised, and he didn't really say because he's gagged. So I was surprised that he's. I told you earlier when you said they'll be releasing him from the gag. What did I say? We'll see.
We'll
and
see.
Sure
Yeah,
enough,
obviously she refused.
They're not.
She refused to release him. Okay, that's ridiculous. It's simply ridiculous because the jury is now in deliberations. Okay, there should be absolutely nothing that they can't say to us because this is Massachusetts. If you can't get the verdict slip ahead of time to look at it, all right, and then it repeats the same things that happened on the first trial, trying to show, well, we showed it, Michael. You can barely find the not guilty, okay, in that verdict slip.
It's a mess, and I think if you didn't know from the first trial why the jury had so much trouble with the second count, you do now, because she's reinforced what a mess it is with all the lesser includeds.
Right. She put the lesser includeds, and no one wanted them. The prosecution said, no, we don't want the lesser included.
Yeah, I know. And they also did a lesser included for the second degree murder, correct?
Right. They did the first two prongs of murder when there's only the third count they're seeking. She said, I have to read the charges. No, you don't.
No, you don't. That one didn't bother me as much because I think it's going to be disposed of, but it does give them another sidetrack to get messed up with. But that second charge for manslaughter with the DUI overlay, you have, I wrote them down because I can't believe that they break it down to this nth degree, because it's almost like I was waiting for the fourth lesser included to be jaywalking.
Right.
Just something, give them something.
Like seven, right? 7 lesser included, right?
So they have only 3 officially: motor vehicle homicide.
Yeah, that's right. I'm sorry.
Felony DUI, and then under the influence, just a generic under the influence. So obviously,
but that has a negligence aspect to it.
Yes, and obviously that would be a win, I think, if that were the one thing that resulted in a guilty verdict. I think the defense would suggest that's a win. But my point is that it's a mess. You start going through the requirements for each of those. One of them, the final one,
had 6 requirements, right?
Yeah, the third charge is for leaving the scene, knowing there's an injury or death. And there's 6 elements. Some of them are throwaways, knowing the defendant was operating on a public way, knowing that the defendant was operating under the influence. They still got to go through this. They have to know that there was an injury that led to death, that the person failed to stop, and that they avoided apprehension. I don't know that they get all 6 of those, even if the jury gets to the third charge, which is probably why we believe the jury was unanimous in a not guilty on charges 1 and 3 last time. It's the second one that is just a convoluted mess and rife with the ability to compromise.
Right, and the only thing you have it on it is this tiny little not guilty under one. You can find the Karen Reed is not guilty of all of the charge, including the lesser included. What does that mean then when you're putting the lesser included underneath them to find the verdict? That's the problem.
Yeah.
And with only one not guilty.
It's structural and also substantive, both a mess. And I don't know that she did anything to fix what happened last time. I was listening to that instruction about whether you can or can't separate out the charges, right, and come to a decision.
Right.
And she read that you can come to a decision on each specific charge. And I'm thinking, okay, here it comes. This is gonna be the fixer. But then she goes on to say, but you still have to come to a decision on all charges. So there's no clarification there that they could technically come to the court and say, look, we're hung on 2, but we're solid on 1 and 3. What do you want to do?
Right, exactly.
They have no help on that.
It's unbelievable. And she's I won't say snotty, but snotty about it with regard to anything. You know, I just think I mean I thought when the way she answered Yannetti, like, oh, here it is. You want to see it? Here, it's okay. Yeah,
like I'm asking for it. You know,
right.
Don't you think? Oh, it's our.
They're coming to
I
get
lost
you.
track. Stand by.
Hold on. It's funny, if you hadn't come back, I was going to play your interview with Aiden, but we do have a link to it. And so if we never get to it today, we've been kind of busy. And also, you know, at 4 o'clock, I'm going to remind everybody Jill Zarin's coming on. She has confirmed. Did it go by? Yeah. Okay, we can hear. Okay,
yeah,
so
kind of hung up at the intersections. That same engine 7, very busy today.
Yeah, I mean, you know, he asked for not guilty on the verdict slips last time too. You know, but it's I can't. I'm at a loss, Michael. I'm at a loss. I'm sorry.
And that doesn't happen often.
That's my partner in crime. Here I am having to talk and talk and talk while you're out.
Yeah, I have full confidence that you never miss a beat. So, oh my gosh, these guys are. Oh, now the ambulance has joined in. I swear, this may be the most dangerous town I've ever been in. I'm not sure where these folks are going or what they're doing, and I hope everybody's okay. But they have a lot of activity for a small town here.
Yeah.
Anyway.
I'm beyond it. By the way, Aiden posted what you had posted beforehand, that it's outrageous that 5 of the people that are in there never even got in there, that ordered the randomizer or the legacy meter. They came for one day. They can't understand really what's happening in that courtroom because they haven't really been there, right? And then and people like Ted Daniels, who've been covering this case, and Jessica Machado, who've been covering this case, did not get in.
Yeah, it's almost like we don't get in. What the hell is going on?
Yeah,
I was talking to a friend of mine from Court TV who was actually there when I worked there, but she parachuted in for today because they wanted extra help on the ground for today and whenever the verdict comes in. So that's, you know, not a surprise. That's what happens.
Yeah, I don't know. So anyhow, the alternates that Disney and I have down were not the same alternates that Aiden said he had down. So I don't know what
you mean in terms of the numbers.
Yeah, I don't understand.
I wrote them down and I heard you repeat them, and they're the same ones I've got.
That's what I had too. So you know, I'm not sure, you know, what is going on, because he said he ranked them from no, he's pretty good at this. Ranked them how he felt from 1 to 18. He said the jurors were eliminated were 4, 7, 9, 14, 16, and 18, and they weren't. I have 13, 7, 6, 17, 2, and 8.
I'm confident of those. I listened to Jimmy just along with you, and I wrote them down contemporaneous. I'm confident in those numbers.
Yeah. So
I don't know.
I don't know the answer to this question. Okay.
Have you nailed down the official Justice Watch? Because we're on Justice Watch.
Missy,
we don't do
we're
Verdict
on
Watch
Justice
here.
Watch.
We do Justice Watch.
Right. In this case, it may be Injustice Watch. But
well,
we hope that
we're
it's
always
Watch.
looking for justice. So it's always a watch to count down to justice. I had 236. I've heard others say 238. So 239, somewhere in that ballpark. And of course, we're picking the moment that the judge says you may now, you know, retire and knock yourself out.
Right.
But we also know, as you do, that they've got to get the exhibits. So I guess it's a technicality. Do they officially begin deliberation when they hit that room? I would say yes, even while they're waiting for exhibits and things to be brought in. They're immediately, you know, after 8 weeks, they're gushing.
They're talking. They can't wait to talk. You know. Well, actually, what they're doing is going to the bathroom first. They're using the rest facilities first, and then the jury room. Jury rooms usually either have a bathroom inside them or right outside, but there's still a door to the you know, that protects them. And then there's a sworn court officer out there. Blessed in Texas again. Me, Blessed in Texas. And at 007 Texas in chat. Thank you again for that. Okay. All right. Oasis Cat says Aiden may have been going by seat number because one was juror number 5. So that makes a lot of sense. He probably was going by seat number and all. So, but we're going to have to coordinate what the seat number is. Okay. By the way, Kathleen XO wants to know, why did she leave out the moral certainty bit so many times? No, she actually had it in there a number of times. I heard it now. When she said guilty or not later on, she didn't say all the time, every time she said guilty or not guilty. She didn't go beyond a reasonable doubt, because the first charge talks about you have to prove every single thing beyond a reasonable doubt within the moral, you know, realm of moral certainty. Some states don't have that. And if you ask for that, you ain't going to get it, you know.
So. Yep. So, folks, if you get a chance, when this is the rock kicking time, as I call it. We got a couple of posts from folks outside the courthouse. Again, I continue my search. I'm like looking for an honest man with my lantern. Anybody here represent
An honest person.
the Commonwealth? Anybody? Who's
Is
that?
it- but do you want? We have Aiden's interview geared up. Do you want to play some of it, narrate it?
Oh, sure. Well, I would narrate it, but I can. Yeah, I think I narrated on the video. So
Yeah.
if you want to just roll it and you need to have a comfort break, then this is as good a time as any.
Yeah, I think that would be a good idea. Well, I thought you would stay on for a second. I'll be right back.
Oh, I won't go anywhere. I'll stay. I'll stay and watch myself walk around. And yeah, that's fascinating.
He knows me too well, doesn't he? Okay, I want to be ready for 4:00. Now the question is, should I move rooms? I think I'm just going to stay where I am.
All right.
We have a good signal, and I don't want to jinx it when Jill gets on. By the way, we had a poll. Twizzlers won once before, so I'm Twizzlers. Okay.
What was the poll?
Yeah.
Twizzlers versus what?
Red Vines. I'm seeing that. We're at that again, Law Nerd Amber.
Let me think about that.
All right, I'll be right back. Yeah. Okay, you go. Go ahead.
I think I like the texture of a red vine better. I think the Twizzlers are a little softer, a little mushier. I like a little snap to my red licorice, so I'm going red vines. But they lost.
They lost last time. I'll be right back, Michael. I'll be right back, everybody. Stay with Michael.
Okay. So you don't have to beg. You don't have to beg. So Missy, do we have that video that I did from earlier today where we talked to Aiden, etc.? This would have been pre-closing arguments. Let's watch and enjoy, or at least watch. Okay, so just going to record a little stuff since our live was a bit of a challenge. But as you may imagine, on the day of closing arguments, it is a larger crowd. It's interesting. Everybody still kind of respects this one block that is in front of the courthouse. I, of course, do not. But if you look back this way, that's where the SUV drops off. That's where folks queue up there. They queue up huge across the street. I'm going to walk over here. After I go, I'll take the loop. I'm going to walk on down. Then I will cross the street and go into the fray there. I just think it's interesting. And I'm sure it's because they've, kind of been rousted to some degree. But nobody on the sidewalk here directly in front of the courthouse steps. Media in the normal places that they always gather here along High Street. And then we're crossing over now to the side where the Registry of Deeds is, again, famous for their lovely bathroom. And you got media that queues up on this side as well. This is actually a better perspective, I think. My space, which is over here on the steps, has been totally co-opted and ripped off. I've been booted. But what a surprise that is. Anyway. What are you guys waiting for? Something happening today? What's going on? No? Something? Okay, what are we expecting? All right. So, just before the First Amendment zone was reopened, this was, how you doing?
Good, how are you?
Good. Yeah, this was not possible, because everybody was kept out of here. How you doing? How you doing? How's everybody doing today? Good. Optimistic?
Absolutely.
You're in the pink. I can see that, right? Oh, how you doing? How you doing, man? Good to see you. Let me wander over here. How are you doing?
How's Linda?
Hi, Linda.
Good morning, Linda.
So, I don't know. Just give me your thoughts, gut feeling.
I'm hoping today is the verdict, and I think it's definitely not guilty.
Definitely. Not today.
But who knows what Bev will pull today, so.
And it's a jury. I know what everybody thinks and wants, but it's a jury.
I hope it's not a mistrial, Mike. I really do. I hope it's not. I mean, I think it's hard to prove that, like they said, the experts saying that the car didn't hit John and John didn't hit the car, so let's just hope and pray.
So, if you could remove yourself from what we all know from the first trial and from the things that have been left out of this trial, what would you be focusing on as a juror?
I would be focusing on the experts by saying that the car didn't hit him. That's what I would go on. I mean, that's just my opinion because, I mean, you have all these experts, even the Dr. Lopasada, all of them saying that. I mean, you can't even, I think the jury probably already forgot about the 227 call because the last four.
I kind of forgot about it there.
Yeah, because the last four witnesses are all about being hit by the vehicle and it wasn't. So that's what I would focus on.
What's your take on the last minute change, no rebuttal case?
I think Hank realizes that he can't have Dr. Welcher with his blue paint come up against them. It's, nah.
I was kind of hoping for it myself. Personal, selfish reasons.
Yeah, me too.
One thing that made an impression on me, let me get your take on this, is when you have an expert like Dr. Rentschler say, well, I'm salaried. I'm not making an hourly rate on this. That you don't hear that in trials.
Right. Well, because Hank wants to say that the defense paid him and stuff because they paid him $23,000 but if you look at Dr. Welch's $400,000 to put blue paint on his arm, Jesus, I might as well get that job. I'm in the wrong career.
Yeah, as that was unfolding, I was thinking I could do that.
Me too. Absolutely. Stick my arm out for $400,000. Yeah, absolutely. I could do that. We're both in the wrong business.
Exactly. Well, good luck today. I'll be circulating, and I appreciate your perspective.
Absolutely, Mike. Anytime.
Okay, let's wander on back down here as we. Some of the faces obviously very familiar. How you doing? Some brand new, at least to me. How are you? Good. Hello. Well, there he is. Are you? You look happy today. I don't know. I can't understand it. I had to pause for the selfie. Can I get a second?
Yeah, sure. You don't mind anything.
Hey, appreciate that. So, congratulations. I sent you a little note, but I'm sure you were totally.
Yeah, I've been bombarded. Yeah.
So, give us a little. How did it play out yesterday? What's kind of a sense of obviously the conclusion we know.
Yeah.
But I mean, anything surprising to you? Any of the witnesses stand out? Anything that?
I mean, every witness helped me. Even they called they called two Dedham cops, both of whom backed up my story that I tried to get away from the building. I thought I was 100 yards away. I was actually right up here in the grassy knoll. All right. And that's where the cop told me to go. So I went there, and it's not a crime to do that. And I shouldn't have had to leave in the first place. Paul O'Keefe testified yesterday. He kind of confirmed that the whole thing was indeed a setup. So I think he helped me. So the judge saw through the bullshit.
As you're sitting there and this thing's unfolding for you, you had to be just amazed that you were at that point in the process that somebody was on trial for this.
On trial. I mean, that's the craziest part, that the government dedicated all these resources, and that triple dip Cosgrove was running up the bill on the taxpayers.
Special prosecutor.
Special prosecutor. We call him triple dip because he's collecting two pensions of over $200,000, and he's getting paid by the hour to do this nonsense. He knew this was bullshit, and he just did it anyway. He knew they weren't going to convict me, but he's just getting paid off the taxpayers, and this is what you're paying for. Instead of, having your roads fixed, having your schools funded, you're paying for this garbage.
I saw you yesterday as you were leaving court. Obviously, you hope that what happened with you is a sign of what might happen today, or at least ultimately in the Karen Reed case. Thoughts?
Yeah, I mean, I think it's an omen. I mean, it's just weird. It happened the day before closing arguments, that I'm acquitted. It just seems like it's all coming together. The way that this trial ended with Hank basically throwing in the towel and not calling his rebuttal to the rebuttal witnesses because they would be a disaster. Having Lally get up there and speak yesterday, the whole thing just reeked of giving up. And I think all the momentum is with the defense. I think Alan Jackson's going to do an amazing job today. I did have a chance to text with Karen Reed this morning, and she said that. I'll read it to you. I'll just read what she said. She said about the closing statement. She said that Alan's close will be 10 times better than last year. We listened very intently to what people thought should be fixed. So, they pay attention to this stuff. And, like I said, I think last year's closing was good. It was artistic. But ultimately, what they just need to hammer home this year is what reasonable doubt is. I hope they watch those Jose Baez closings with Casey Anthony and Aaron Hernandez, who were both acquitted, in both with far less evidence, exculpatory evidence than Karen Reed has. So they just need to hammer home what reasonable doubt is. Let this jury know that you can't convict somebody based on, maybe this happened based on blue paint. You can't convict people on blue paint. It's not enough to take someone's freedom away. That doesn't prove a car crash happened. You don't have to prove who did it. You don't have to prove, who beat him up and put him where, what time. You don't have to do any of that. You just have to prove a car crash didn't happen, that his body wasn't out there for 5.5 hours, which they've done, end of story. So that's it.
Today, is it going to happen today, you think?
If the jury's smart, it'll happen today. If the jury's smart, they'll go to deliberate. They'll get in that room for the first time and talk about it. And they'll just be like, so this is all, they'll look at each other and they'll say, well, this is all bullshit, right? And this is clearly we all agree she's innocent, right? And then they'll laugh and they'll have a chuckle and they'll say, yeah, that's it, and let's pretend to do something for an hour. Let's pretend like we're actually deliberating so we don't come back in 50 seconds. And then they'll come back and they'll say not guilty. That's what a just jury would do. And we'll see what happens.
I've seen tons of Friday verdicts, been involved in Friday verdicts, and they are a thing. They're a real thing. Your take on the judge deciding to extend deliberations if necessary. I mean, she's pushing for a Friday verdict, it looks like to me, but I'm not sure what she wants.
She's trying to open up the Cape House. She wants to get out of here for the weekend. She wants to be done with this, and I don't blame her. It's like the one time I agree with her. They should be done by today. They should deliberate, get it out of there. There was 0%. If there is a verdict today, it will be not guilty. Like, let's just put it that way. If there is a verdict today, it will be not guilty. If they deliberate longer into next week, that means there's maybe a couple holdovers that just have to be won over. But this is a jury that I saw them. They took way more notes than the last jury. There was just a lot less to confuse them with. The last jury had, okay, so this person said this person said, oh, he never came in the house. There's a whole list of McAlberts to go through, and you had to come to the conclusion all these people are lying, right? You don't have to do that now. You don't have to do, Jen McCabe's a liar. She manipulated Kerry Roberts, right? And Michael Proctor's a scumbag who they won't even call and put on the stand, and he was in charge of the whole investigation. That's it. So I think it's a lot. And the science and the data, 4 doctors testified. Russell, LaPosada, Wolf, and Rentschler, and Scorti-Bello. All of them testified, 5 doctors actually, 4 of them for the defense testified that John's injuries don't align with the car collision, right? Several of them testified that he's covered in dog bites. The Commonwealth did nothing to combat that. And all they have is some phony baloney text stream data, which Matthew DeSogra also helped debunk, that shows that she went in reverse at some time. It doesn't say she hit anything. And that's about it.
All right, sir. Well, again, congratulations. You're going to be hanging out here today? What's the plan?
Yeah, that's the plan. I didn't get in the courtroom today because a bunch of...
You were randomized out or what?
Well, yeah, but I've been able to get in all week because the AP, the Boston Globe, News Nation, Law and Crime, and Grant haven't shown up. So that's 5 extra spots. And then I've taken the alternates, Jess and ABC have taken the 2 alternate spots, and then you get extra standbys. Well, today, for the first time, News Nation, the Associated Press, and the Boston Globe decided to finally take an interest in the story and show up and take, where have they been? How's that just?
Classic.
They've been ignoring this the whole time. It's been happening in their backyard, and they get be in there. Complete bullshit, but it is what it is.
And it's consistent.
It is consistent. I got in for next week, but hopefully I don't want there to be in next week. So we'll see what happens.
Okay, man. Take care.
I appreciate it, brother.
Congrats again. Oh, sure. Here.
Go with him, honey.
Well, she wants to get a picture of
Okay, hold on.
This is a celebrity. No.
You got that right. Here, let's see if I can do this.
Okay, thanks.
Take care. Something went down there. Oh.
I'm sorry, did I hear my
All
case
right.
is being mentioned with Jose?
Obviously, Aiden could not be more happy about the
Excuse me,
result from yesterday.
Michael Bryant.
And he hopes it
maybe
spills
on
over into today, or at least to the
Michael
ultimate
Bryant.
decision this jury is going to have to make in the Karen Reed case. So,
Michael Bryant.
it's pretty tight schedule. This jury should have the case by 1-ish, give or take. Sometimes jurors delay making a formal decision because they want a free lunch, but I think they're going to get their lunch before they even get started today. So This is the original line with the buffer zone. So let's see if
Oh,
somebody
Michael
here is
Bryant.
interested in chatting. How you doing? How's everybody feel?
So good. Awesome.
Did you have that pink chair before, or did you buy that?
I did buy it just for the trial. No, I'm just kidding. I did have it.
You did have it? All right. Okay, enjoy the day. Hey, how are you? How's it going?
Good, good.
I was just talking to
Yes. So excited. It was so awesome.
Did you go?
I went to it for a little while, then I had to leave for the second half to go get the kids, but it was amazing.
Damn those kids.
The judge was awesome.
In the way.
Yeah, I know. God, don't they know what's happening here? These schools making half days and stuff, they should know better.
So Aiden's hoping that's kind of a good sign.
Yeah, I think it's going to come back not guilty today, too. It's going to be a great week for the people. You know what I mean? Factually framed, and today's the day. I feel the justice. I feel it. It's coming. Justice will be served.
Hey, there you
Yep,
go. I've heard of that somewhere.
Yeah, somewhere.
How you doing? How's everybody doing? It's very busy here.
Go
A lot of
ahead.
folks showed up today. How are you?
A lot of people that have never shown before are showing today.
Well, better late than never, I say, right? Hey, how you doing? How you doing? Tim? Tim is always lurking. What's going on, Tim? What's the deal?
I'm just taking in.
You got bounced out? You didn't get in on the right?
No, we're in the alternate list. So
alternate
yeah,
list.
so we're waiting to see. So I was just out here, kind of seeing what people are saying and what it feels like.
What's your sense of the vibe? Obviously, this is the hot zone. It has been. It's just a lot busier today.
Yeah, just simply that. It's a lot of excitement, and people are ready. Not guilty today.
That's your prediction?
Not guilty today.
And if there is no decision today, what do you take from that?
Overtime.
But is it a good overtime or is it a bad overtime?
Even if it's not guilty today, this isn't going to end.
Yeah, I realize there's more things stacked up here in the community. Yeah.
Yeah.
Best of luck.
Thank you.
I'm looking at my roof and I missed
Can't find the TikTok right now.
There's the man.
TikTok link because it's not
What's
opening
going on,
for some
bud?
reason on my computer.
Turn this down for a second.
Oh yeah. Obviously they haven't started yet. I love Judge Bev is like, let's get here early. Maybe we'll start before 9 o'clock. Yeah, right. Of course
She's
we will.
busy denying defense motions.
There were a couple of last-minute motions they brought. What were they? I wasn't able to hear. What are they?
I find funny. So in trial one, when her judge's clerk Jim picks the alternate juror numbers out of the 100-year-old tumbler, he doesn't exactly have it open and honest. You don't know what the numbers.
It's kind of a hide the ball, literally thing.
So the defense literally filed a motion saying, "Hey, we want a much more clear and distinct. Show us the numbers, and so we can't,
no fudging.
Play around with it."
Are you surprised?
She immediately denied that motion, by the way.
Oh, of course.
How dare we disparage her judge's clerk, Jim, in that manner?
Poor Jim. Okay, so what's your take on not losing one alternate during the course of this second trial?
That's a good sign because, as we know in trial one, if you followed it, there was several jurors that were tossed before the alternates were picked. So we have all 18 intact the entire trial.
Is this the people who want to be on this jury, maybe for the right or the wrong reason?
We all hope that it's, a well-picked jury where there's nobody biased either way. But, in trial one, there was a couple jurors that were allegedly, pointed out to be Free Karen Reed, and those are the very jurors that Beverly Cannone removed from the jury.
And, of course, we know after the fact all three of them were likely not guilty voters.
Aiden Carney, Turtle Boy, is in the courtroom now.
No, I just talked to him on the street. He didn't get in.
He didn't get in?
Yeah, you know how that.
I thought he was going to get in.
So did he. This is the first time he hasn't.
He has several jurors that he believes are very pro Karen Reed, and he's saying if their numbers are called to be alternates, then the fix is in on Jim's tumbler. So we'll see.
All righty. Thanks, man.
Nice seeing you.
You too. How's everybody doing? Everybody good? Excited? Optimistic? Nervous? What?
don't want to be on TV.
Oh, sorry. Are you in the witness protection program?
Yeah.
You are? Okay.
I love watching you and Linda.
Oh, thank you.
Yeah.
I appreciate that. Oh, sorry. Ran into. Yeah, well, I'm not good enough to get in the courtroom, so, you know,
You're good enough to stand with us.
thank you. All right, so enough of that. Yeah.
All right. That's really interesting because I was about to text you. Richard Gabriel is going to join us. I just put it on our thing
Oh, good.
at 5 o'clock. The jury consultant who I use, he partnered with Michelle Ward, and they both picked the ASAP Rocky case. But more importantly, did I hear Aiden say that they were looked at the Jose's Casey Anthony, Jose?
I knew your
And
ears
Aaron
must have
Hernandez,
perked
yeah,
up.
it was-
You said Casey Anthony and Aaron Hernandez
Aaron
because they both
Hernandez,
got not guilties. Yeah.
Right. Yeah.
And I just want to point out
it.
that was all recorded before closing argument. So, and before Aiden got in as the alternate to the alternate to the alternate.
Right.
So,
That was
yeah.
great. Yeah, I heard it too. So, Jose and I were co-counsel on the cases. I did Casey Anthony, all the forensics on the case that he used. As a matter of fact, there's some great clips when he is cross-examining somebody. He has his phone up he had his phone up at the lectern with him, and his phone is because he's texting me at the same time, and I'm texting him back on some forensics.
That is totally inappropriate.
Of course, it's very appropriate. So, there's nothing wrong with it. Yeah, it's really funny because the only thing I wasn't was her. I couldn't, when they cut off all funding for costs is ridiculous for any out-of-state attorney. It was just ridiculous. That was to get rid of me. And of course, Aaron Hernandez, we all, it was Jose, Ron, and I, we all had a third of the questions and all. And I did all the forensic work on Hernandez, and as you know, sat next to him the whole trial. And I was just, it hit us hard when he killed himself in jail in prison.
I can imagine. Brutal.
Yeah, it is very hard. So but I was interested that they were they took a look at these cases. So I wonder,
reasonable doubt. Yeah. So and then the other video just posted I saw, which was everybody coming out of the courthouse after today's activity, after the case was submitted to the jury, and again, Attorney Yannetti telling me he's still gagged. So.
Unbelievable. This judge is still gagging them when the jury is in deliberations. Joe Tacopino was on with us in California. Like, okay, well, the jury's deliberating. There's no gag anymore. And the judge was like, no, there's no gag anymore. I can't gag.
I don't know how there could be. Again, I think they're just playing nice just to, maybe it's also helpful. Maybe they like not being able to talk,
Right. Exactly. Exactly. Because things get taken out of context too. And there's some other things that may be going on that they're not talking to the media at this point that we're not privy to.
Yeah, it's got to be a very emotional time right now. This is the point in time where I always allowed myself about 8 seconds of relief. Like
that much.
It's over. Yeah, 8 seconds, 7, 8, and then crap. Now what happens? What if? What are they thinking? What are they? Yeah. Where's the jury?
What could I have done differently?
Yeah. What did I screw up? What did I leave out? What did I mislead them on? What was confusing and I thought wasn't? Yeah. All of those things. Yeah.
We have Jill Zarin coming on in a few minutes. Joey Kane gifted one Justice Served TV membership. Thank you, Joey. Joey Kane gifted another Justice Served TV membership. Thank you. And of course, another woman named Linda, whose name I love, of course, gifted $50. Linda, I know you've been following us, and I just love you, maybe just because of your name. Okay.
Yeah, you might be a little biased. Yeah.
Isn't he a little biased? God is in control. This is the year of exposing the lost. Okay, let's really hope for that. But yeah, when Aiden was talking about my cases that the jury looked at, I was like that the defense looked at. I'm like, I'm prone here a little bit.
I guess.
Like, Michael.
I lost the. I guess I could have promoted you at that point, but
yeah,
I actually thought he might. Might just throw that out, but
although maybe they don't want to, they're saying those cases, but they don't really want to tell. They don't want to tell the prosecution who they may have been following here on it, because as you know, my history with Alan Jackson, you have the clip of him saying he loves me, Linda, and even though we fought for 6 months against each other, we had obviously have developed great respect for each other.
Yep. And I'm sure After this is over, he'll be saying the same thing about Hank Brennan.
I don't think so. Well,
No?
you know what? I know it's not 4 o'clock yet. Okay.
But we don't have to follow no stinking clocks. We do whatever we want whenever
Yeah,
we want.
we're in control. We're like the jury. We're in control. Unlike the lawyer, as you say, the lawyers now are not in control. They've got pits in their stomach. Okay. And quite frankly, they want to hear that the jury has made a decision, but they don't want to hear the jury's made a decision if you're defense counsel. If you're Hank Brennan, you're just going home. You don't care. Right. But if you're a defense attorney and you know that your client, right, your client may go to jail, you can go home. You're always going home. But your client had their hands in your lap and you made all the decisions. And if you made the wrong one, you could end up getting your client convicted. It just was, I can't even tell you the feeling that you have as an attorney having tried all these high profile cases. So why don't we bring, if she's ready to be brought in, why don't we bring Jill in?
Let's bring her in even if she's not ready. Maybe it'll be more fun if she's not ready. Oh, is she ready? She looks ready.
I'm trying to add this this thing to my, I don't even know how to sign up, this yard thing, whatever. Anyway, don't worry about it.
This yard thing. Oh, look at this.
Oh, there's a
that's bossy, right? Is that bossy?
It's bossy. But we have a surprise for you, Missy. Where's our?
Oh, there you go.
We have a bossy.
Oh my
emoji.
God, are you kidding me? Whose dog? Is that yours, Linda?
Yeah,
that's yours.
That's yours.
Well,
oh, that's mine.
That's bossy. Mine is this one. Mine's 2B. If we have 2B, there's 2B. That's 2B, the standard poodle.
Well, don't leave out the Domino then. Come on.
Then there's Domino is Michael's. He's coming up too.
There you go.
We are a dog-friendly show. Okay.
Beautiful.
So
and
Jill,
before wait, you got to get the important things before Jill introduces herself. Let Jill introduce Bossy's Instagram, and then Jill can introduce.
Oh, wow.
She has about 5,000 followers. She
nice.
Does. And they're all real. I don't say that. It's Bossy Zarin, BOSSIZARIN.
There you go.
Nice.
Follow Bossy Zarin.
Jill, nice to meet you. We've never met.
No, we have not.
We appreciate you joining us here. This is the clashing of two worlds, the world of entertainment and true crime, and sometimes there is a major crossover. Why don't you tell us why you're so invested in this case? What is it about it?
Well, I think I had heard about it late in the game. I'm late to this party, late. So I watched the documentary, I'd say about 3 weeks ago, and I was hooked in terms of the case and the fascination. And I've got, as Linda, I've got my notes.
You got your notes? Oh, good. I'm so glad. And you're ready to be my co-counsel on the case? Am I paralegal?
So my sister is an attorney and a judge in Westport, Connecticut. And she has a daily talk show in Connecticut. And my dad is a lawyer, never practiced. Never practiced a day. And my boyfriend, he also has a lawyer MBA degree, but he never practiced a day of law. But I like to think we're kind of an intellectual family, and we talk a lot about different things. And I have a lot of opinions, and I sometimes find things that nobody else sees.
All right, we're putting you in the middle of Michael and I.
There you go. I feel better now. Although Linda, you and I are on opposite sides now. Can we fix that? There we go. There we go. Now I feel better. Okay.
Well, I'm gonna split you two up. Perfect.
You said nothing would come between us, Jill, and look what happened.
I'm here to shake it up.
Hey,
I have
tell everybody about yourself before that.
Yeah.
Before you get on, I want you to tell and promote your causes that you're involved with.
Oh, thank you. So my name is Jill Zarin, and I was the original housewife from the Real Housewives of New York City, which I actually have in my office behind me. Woo! One of the OGs. And since then I've done some other TV projects, but I'm an entrepreneur, serial entrepreneur. And right now I have a rug company, and I make rugs, outdoor, indoor rugs, pet proof.
Oh, wow.
And she does every day, and I clean it up every day. And I also have a bedding line, and I have a candle line. So I'm working.
Wow.
I work my tail off, and I do TV shows. I just did a game show last week in LA. And
which one?
What's the cause? We always like to ask people what the cause is that they want people to donate to.
I'm sorry?
We always like to ask people, what's your cause that you want people to look at to possibly donate to? We know you're involved in charities and all sorts of stuff. You have.
And I mean, personally, I have my Bobby Zarin Memorial Trust, because I raise money for that every summer. I have a big charity event. If you're in the Hamptons, July 26th, it's my 12th one. And it's a giant gifting suite and gift away over $1 million worth of products to everybody who comes. It's an incredible event, and you get all this free shit. If I can say that word on
You
YouTube.
can say that. Yeah.
I can say that word. And it's really, really fun. I raise money for my husband who passed away. He did end up dying. You know, he succumbed to cancer. But, you know, I still raise money for thyroid cancer. I do. Feel very
Well, it's not great that your husband passed away, but the fact that you do that type of work is so important and are still involved with it. It's so
I think,
very
and
important.
of course, I'm Jewish, and I, you know, am very involved in the Jewish community, and you know, trying to do what I can.
Yeah, yeah. You and Neil Rockhind, another one of our guests who also has co-hosted with us. He was on the other night, also very involved and all. And his son actually passed away from cancer, so he's also very involved in both your court. I wish Neil could. We asked Neil to join us this afternoon, but unfortunately he couldn't because he actually has a law practice. You know.
So I got involved in. I started TikToking about the Karen Read trial, and I guess I found an audience. And they started listening. It was crazy. I think I had 150,000 on my first one, which I thought was a lot. I mean, that's a lot.
Yeah. Yeah.
So, and so I've done it a few times, and then you guys reached out to me, and I was so excited. I said yes right away. I say yes to everything. I mean, it's a good way to live.
Yeah, we're a young channel, but we come with a lot of experience. So mine is the high-profile cases, and Michael's the Emmy award-winning attorney.
That's
so,
it.
You know,
that's all I got. Oh, all right.
That's pretty damn good.
You know what? I'll tell you something. You came in very handy today because I don't like. Nothing, no shame. I don't like court TV the way their format is. I don't like that I don't know when they're live. Sometimes they say they're live. Sometimes they don't say they're live. Sometimes they're live like by 5 minutes. I mean, it's crazy. And there's too much stuff on the screen. So I, you know, and it distracted me. You know, I'm listening and then I'm like watching and it's just too much for me. And this morning, you know, they're cutting out to commercials. Hello, we're in a live. This is live, baby. We've got 90 minutes to watch of each side, and I'm with bated breath. And then it's like, I'm sorry, we're gonna have to cut to a commercial. Now I get the commercial, but then it's, I'm sorry, we're gonna cut out and listen to people's opinions during the closing statements. Are you kidding? You guys were great. You didn't.
We just shut the hell up. That's what we do.
And then you've got plenty of time to talk about it after. Give them the 90 minutes each. And then I guess it's my dad's 96th birthday today.
Oh, my
congratulations.
Congratulations.
For lunch on the beach. So I had to run out and do that. So I did not listen to the judge's
instructions.
Instructions, which by the way are critical.
Crucial.
The outcome of a case many times.
Yeah, crucial. And this verdict sheet that we're talking about. Did you know about the controversy from the first trial? What they call it a slip, the verdict slip, what they give to the jury to fill out to say guilty and not guilty. Do you know about that? Because that's what apparently the jury had decided that Karen Read was not guilty on 2 counts, and they were hung on 1 count, but no one ever asked. So. We're in a second trial, and the Supreme Judicial Court ruled that's your remedy. You get a second trial. So today she sends this verdict sheet in with all these. She charged all these charges that the prosecutor didn't even want. The parties all agreed they didn't want these lesser includes. She charged them anyhow. So now there's 3 charges under the second count, and she's got a verdict sheet that has 7 options to possibly find Karen Read guilty. Or 7 options, 6 to find her guilty, and only 1 to find her not guilty.
Well, you know what that says? That's called bias.
Oh, yeah. Mm-hmm.
That's called judicial bias. And I heard that she's retiring after this. Is that true?
I think she's going to the Supreme. She wants to go to the Supreme Judicial Court. My understanding is that she wants to go to an upper court. So
closet and throw away the key.
Yeah.
She's sitting on the bench. She's done. Yeah. I'll tell you when she was done for me. And like I said, I came in late in the game. And I saw it happen live, but then I saw everybody picked up on it in the news. When she looked at, what's his name, Henry or Hank? When she looked at Hank, when somebody was testifying and she goes like this, and he's like, I object. She goes, you know, sustained, come on, let's go, let's talk. She wanted to interrupt that line of questioning. And thank God for cameras. Otherwise, nobody would believe it. That alone is grounds for an appeal. I mean, there's so many grounds for an appeal that if they find her guilty, unfortunately she'll end up in jail for that period of time. But there's like 5 how many times did he try to get a mistrial? 3?
And they probably filed more motions. Or they probably filed an omnibus motion because I don't think that was all. But that whole what did you see the stunt about the shirt? about taking John O'Keefe's. Tell us what you thought.
I have questions about the shirt. Absolutely absolutely misconduct on him. And I don't know what the remedy is when the prosecutor deliberately tries to mislead the jury. There's got to be some consequences. Is there any legal consequence?
No, there was none. She just like had this jury charge. She was going to say you to draw no inference from it at one point. She was going to tell the jury that. And then the fact that,
These are all grounds, by the way, these are all grounds for I don't think that the jury, especially because she was going to correct it and tell them that the shirt did not have holes in it. And I don't think they're a stupid jury. But that would have been grounds for a new trial, for sure.
Yeah,
it's pretty bad. Hey, let me just say, in case I'm gone on mute most of the time because I have the lawn being mowed behind me now. It is unbelievable. So I'm not being rude, but I'm going to mute except when I have something amazing to say. So I'm listening.
We got you. I just want to talk about the shirt for 1 minute. I have a question for you. So the shirt has no holes in it, yet there are marks on his arm. The prosecutor says the marks are coming from the glass, the plastic from the car. How does the plastic from the car get through the shirt to scratch an arm where blood is clearly seen, or a scab or some kind of thing is seen? Show me that magic trick, Hank. Tell me.
Really? No, that's exactly right. You're absolutely right. Not only there's six holes in the shirt, and yet there's 32 marks on his arm?
Are there holes in the shirt or no? I thought there were no holes.
No, there's six punctate wounds.
It's actually 9, but who's counting?
Is it 9? Okay,
there are
I have
9,
6 in my
and there are
notes.
36 holes in the arm. So
Okay, that's what
I'm no math
figured.
major, but it does work out to 4 times
There were
9.
holes on both arms?
No, just the one, just the right arm that had the injury.
That bothers me a little bit. Why are there holes on one side of his shirt? Well, it could be from the bite marks of a dog.
Exactly.
But I didn't understand how it got through the shirt when there were no holes. So there were no holes on the back of the shirt.
Right, there's no holes in the back of the shirt indicating he was dragged or fell on the shirt or anything. And what Hank Brennan was trying to do, he was suggesting to Dr. Rentschler that this was a road rash, right? That the holes were caused by road rash, that he was dragged a little bit on the road when he fell backwards. And that was wrong. I mean, I think that was total misconduct. I think that was grounds for mistrial. I mean, that had to be purposeful. You can't tell me that Hank Brennan represented Whitey Bulger for 8 years and had this case, and he didn't know that those holes were created by the criminalist that he was intending to call on rebuttal, Maureen Hartnett.
So I have another question for you, and I'm the common sense jurist, right? Because I'm not a lawyer and I don't have the benefit of having all these other cases that you both have in your life that you have a lot to bring in, that you don't even realize you're bringing in. I have nothing. So the car, why did they okay, I have a couple questions. Why did they recreate the accident, alleged accident, in like literally, how did it was a 3-point turn allegedly. So she hit the gas, can you literally go 24 miles an hour from where the car started to where his body was?
Impossible. Impossible.
So I don't know why didn't they bring in an expert of just inertia? Like, you cannot hit the gas hard enough, fast enough to go from here to here and set 24 miles an hour.
I got the impression, and again, it wasn't from the Commonwealth because their experts did nothing but paint their arms, but even the defense experts made it sound like that wasn't a disputed issue, that you could, if you depress the accelerator 74%, that you could hit that 24 miles an hour in that short distance. So I think it became a bigger question as to could you physically do that? Because have you ever driven backwards, Jill? Have you ever driven backwards at some speed?
I've driven backwards, and you know what I do when I drive backwards? At night,
hit things?
At night in a snowstorm, I go very slowly.
Well, you heard the prosecution.
I don't think there was any intent anyway. I mean, if you believe it could have been an accident, no.
You heard the prosecution suggest that she was so mad. That's why she did it. She intentionally stepped on the gas, put it in reverse, and aimed at John O'Keefe because she was so mad. How does that whole argument resonate with you? You're used to storylines in which people are angry at one another and venting and, tossing tables. And, so how does this track with you? All of the texts we heard, leading up to the event? Was there enough there to suggest she wanted to hurt or kill John O'Keefe?
Absolutely not. But let's talk about common sense. So he gets out of the car. Most people do not walk right behind a car. It's kind of unsafe. But if I were getting out of the car, I guess she pulled up. Is she saying she pulled up on the side of the house? Instead, she couldn't pull in the driveway because there were cars in the driveway because there were people in the house. So did she pull up and drop him off? Where did she drop him off? See, I don't know those facts. And does anyone know? Because that's very important.
That's kind of the problem, right?
Very important. So she pulled up in front of the house and she's on the outside. He's on the grass side. He gets out and walks to the house. He's not standing there, right? He gets out, he's walking to the house, and she's not mad at him because she's waiting for him, which I'm going to get to a question. If she's coming from the other direction and she lets him out on the right side, he wouldn't walk behind the car. He would walk where the light is, in front of the car, so she could see him and run him over that way, if you know what I mean. Joking. He would walk to the front and cross in front of her. Doesn't make sense that he would go behind her. Just common sense. And she certainly didn't pull up on the grass and drop him off. So which side of the car did he get out on? And I'd like to know that question. I have another question is, I heard today that they only found one shoe. So what does Hank say the other shoe is?
It was found supposedly several days later on the berm, okay? It wasn't at the same time. It was supposed, but that could have easily happened when the EMT's picking up. Hank Brennan was saying, well, he was hit and, he was hit out of his shoes or something like that. That was the argument. We didn't quite hear that.
No, but then his bones would be broken. You have to have
Right. You're right. You're about to have broken bones.
You got to push somebody over to get out of their shoe.
Yeah. That's let me be. Carrie Sipley loves you. For those of you, oh my goodness, that's an excellent point. She wouldn't be waiting for him if she were pissed at him. Very good. Hey, there you go. All right.
I have a robo vacuum that cleans my house 24/7. It's crazy.
That's okay. That's it. Lord Nerd Amber, she pulled up in front of the house. He wouldn't have to go behind the car or just get out and walk across the yard to the door.
So how did he get behind her?
We don't know. No one. That's what the prosecution says. We don't know how this accident occurred. That's what they've said. They don't know how it occurred. How can they prove the case beyond a reasonable doubt?
I needed to speak to the defense. I have another question for you. You ready? So Hank says today in his closing statement that he's arguing that they were actually friendly in the restaurant, if I understood him right. He said that they're hugging and they're friendly in the restaurant and everything was good in the restaurant. So tell me why Karen says and admits that she wasn't invited in the house. I don't understand what happened. Explain to me. So my understanding is that she pulled up to the house. He was getting out to find out if she was invited, because I got this from the documentary, that she wasn't like invited. Now, if you're out with friends at a bar, and by the way, nothing good happens after midnight, at a bar, and these are cops, it's 12:20 or whatever, and they invite you back to the house. What, they didn't invite both of them? I don't understand that. Why would she even be sitting in the car waiting for him to go in and ask permission that she could come in, and she was waiting in the car and he never came back to tell her?
The inference, I think, was because it was that Higgins wanted to see him. You come in here, and so he was going in. She didn't know why exactly he was going in, but then she left him. I mean, she left him in the car.
She sent him in to get permission to bring her in, and he was supposed to come out and tell her to come in, right, Michael?
Well, that is just one of the many uncertainties in this scenario. Did they have a fight in the car and so she was dropping him and she was never going to go in? Is that possible?
Watch the documentary. No, I think she said, and she wasn't mad about it. She said he was going in to find out if I could come, and he was supposed to come right out and tell me, and if I couldn't come, I would go home.
Well, I mean, I think that's odd. I think that's odd.
Hank said that they were getting along great in the bar. So why would there be an issue with her going in the house?
Yeah, and we know their relationship was volatile and kind of falling apart. I get all of that, and it's the end of a night. They've all been drinking. Maybe she's interested in an Irish exit. Yeah, we'll come and see you, but she doesn't really want to. She's going home, and maybe they just had a little dispute about who was going to stay and who wasn't. My point is that who cares? We don't know because we don't know what happened. And that's just
Oh,
one
okay.
of the little
This
nuggets.
is another thing. So this is what I also said today, which a lot of people kind of agreed with me, which was, my opinion is, my opinion is she has to be found not guilty because they don't have enough evidence to prove her guilty.
That's our opinion too.
I'm not 100% sure she didn't hit him accidentally. I'm not 100% sure she didn't. I think there's proof that you could probably go either way, and that's why you can't find her guilty. But I personally think that a lot of the evidence that bothers people, which has to do with the guy who owns the house, and what bothered me the most in this whole case was the fact that he had a dog a lot bigger than her. When anybody comes within 4 feet of my front door, this dog goes wild. Could you imagine his dog? He is a guard dog. If you have a Doberman, what does he have? A German Shepherd?
A German Shepherd or a German Shepherd and Malinois mix, which may even make it worse because
German Shepherds are guard dogs. That's what they had in Nazi concentration camps. German Shepherds. That's
I had shepherds, right? That's what I had to have them trained because they're innate. They protect. They don't necessarily bite, but they protect, right?
That dog was not sleeping. So now he says he's sleeping. What was the dog doing? The dog was barking. That I can tell you. I know the dog was barking. Nobody sleeps to a barking dog who's right. Like my dog barks when nobody's there. Can you imagine how she barks when someone's at the doorbell? That dog was out of his mind with all the lights and all the noise and all the people.
Okay.
And
How
I'm
about
gonna
this?
tell you what I think. I think I know why.
Alternative argument, Jill.
What?
The alternative argument. The dog was not there anymore because of what happened earlier in the evening. So they had already shipped that dog out with one of the kids who left earlier in the evening. That's why there was no barking.
Do we know who the kid is, and did the kid ever testify?
Which one was it? Was it Caitlin? I can't
I think
remember.
it was Caitlin. I think that was the argument on the first trial.
Somebody that left earlier than.
Somebody left at 2:00 and they shipped the dog out. That was the argument.
That's why the dog never made a sound.
Because in the first trial, when Brian Albert testified, he said he let the dog out to do his business.
Yeah.
Okay. All right. So it was clear the dog was there earlier in the evening. And then all of a sudden the dog was on. First of all, who gets rid of their dog, their household dog, after 7 years? No one. No one. Who gets rid of it? And then rehomes it. So they send Buchanan up to try to get samples of the teeth, putting it under a different name, like it's in the witness effing protection program, right? You know, the dog. And the dog, by the way,
he never gave who he gave the dog to, right? He never said he sold the dog to.
Yeah.
Why not?
Vermont. Somewhere's in Vermont.
Well, what was his reason? What was his reason for not giving the name when he was on the stand?
The Buchanan didn't have a name. Didn't have a name for the dog. He was going, go check this. Here's paperwork. Go check this out. I don't think he ever saw the dog.
I think something nefarious, having nothing to do with Karen Reed or John, was going on in that house, and that's why they wouldn't open that door. I think I've heard that the son was into drugs. I heard that John was on the drug task force or something to do with it, and that if he let him in, something went down about drugs. And if he didn't let him in, let's say she did accidentally hit him, he didn't let them in because if they came in, then he would have to let them see the house and let them, then they would start to be like, well, we have to decide whether he was here or not. And now we have to get fingerprints. And I think if they did a drug search, the parents, whether they knew or not, might have been protecting their son, thinking, we're not letting them in. They're going to search the house and find drugs. And then the phone calls were all about hiding, protecting the son. So they had to get rid of all, this is my opinion, potential opinion, that maybe they were calling their friends or whoever to, get rid of this, make sure my son doesn't this, and all those recordings and all those telephone calls between each other would have been in evidence, and they would have to explain what the hell was going on. And I think that they got rid of all that because they were protecting their boy.
But what caused it? See, the problem I have with the prosecution is that all the medical people testified that his body was not consistent with the hit, and the other medical people testified that you had animal wounds or dog bites, and the prosecution never rebutted it. They didn't bring anybody out to rebut it.
The thing about the dog bites is when you see his skin, and I'm not a coroner, so I can't tell you what's supposed to happen.
Well, if you were in this court and you were a coroner, she wouldn't let you testify.
No, but the scratches look like they're a day or two old, if you know what I mean. They don't look like they're fresh wounds. And if they were fresh wounds, where's the blood on the sweatshirt on the inside?
Well, there wasn't. Apparently, the skin itself wasn't. The skin itself wasn't punctured enough for the blood to come out. That's what the medical examiner said. They were abrasions, but not enough for the blood to come out. So that's where you had. Now, I don't know. I haven't talked to my husband about that. So
both of them said that. That doesn't make sense.
they all said that. Yeah.
Only if it's dried blood. I say those scratches might have been made a day before. Because you know what? My dog has scratched me. And microscopically, there'd be a little bit of blood. And if I had a shirt on and you put it under a microscope, pretty sure you'd see blood. You might not see it with your eye. But, you know, when you make it, some of those were scratches. Like if you pull that, I don't know if you have a shot of it that you can pull up, but you pull it up, there's some like wide scratches that would definitely bring up blood. And they looked a little scabbed, Linda.
Well, that's why it's hard to see with the, it's a 2-dimensional photo. So it looks like, like claw marks.
Well, but a fresh claw, if you've ever been scratched, a fresh claw looks different than the day after. And that looked like a day after. And it takes hours for your body to make scab. Hours. So it didn't look fresh because he died, right? So he died. So there's no blood pumping. So they should.
So what do you think happened? He had an 85% clogging of his coronary artery, his LAD, his widowmaker. Do you think he just he got punched and had a little to do with a Higgy and got punched and he dropped dead because of the stress of that? And then, they said, oh my God, what do we do now? What do you think happened? We're spitballing here because we don't know what happened. See, the problem is I had this case. We don't know what happened.
She knows what happens. And that's why this is a fascinating case, because the whole world is looking in that courtroom and we all know there's one person who knows the truth. And it's her, because she knows if she did it or not. She knows. And if she didn't do it, then we have a lot of, what it could have been.
Well, if she didn't do it, then I don't know that she knows what happened either, because she left.
Right.
So,
but I think it could be drugs. I think that something's going on with the son and the cover up. What do parents do? They cover for their children, especially if you're a cop. It could ruin his whole life if this kid gets caught with drugs in the house.
John was assigned, I think, to the sex task force in Boston. They gave him a desk job after he did the guardianship of the kids. So that's where, instead of being out in the street, so he could have, he was raising the children of his sister. So I think they put him on the sex crimes unit or whatever they would call it in Boston. I'm not exactly sure, but I don't think he was, but who knows whether he knew about drugs and all. Who knows what? We don't know anything. That's the problem.
Wait, you know this. You ready? And I know it's not valid in a court of law in a trial. I know that, but we're talking about the court of public opinion. Did anybody get a lie detector test?
We don't know.
No, we don't know. And don't know. And I don't see any upside to doing that. It's not admissible, so who cares?
Okay, I'll tell you the upside. The upside, if she did it and if she took it and she passed and she put it out there, that's huge. I don't care if you can admit it in court. It would mean something to you, because we know they're mostly right. You have to be really good at that. You really have to know what you're doing to fool a lie detector test. And what was she, a teacher? I mean, she's not in law enforcement. I don't think she's that gifted that she could control her body, whatever. And if she failed it, they hide it, right? If she failed it, you don't show it.
Interesting point that you're saying public opinion, you would do that. And of course, when you're picking the lie detector person, if you're picking the person, it's not really the test. When the cops give you a lie detector test, they don't care about the test. They're caring about the pre-interview, because they try to get people to confess in the pre-interview test. So, but in defense, you're picking anybody, I guess. So, I see what you're saying. You're saying the court of public opinion, put it out there.
Right. If it said not guilty, then someone like you, an expert in the business, would say, well, I don't really trust it because they picked the person who did it and blah, blah, blah. And that's fine. And that's true.
Right.
But if she passed it, I'd still mean something to us.
Interesting in terms of the court of public opinion. Right.
3 years after that first trial, she didn't do a lie detector test. And if she did, she failed it. Otherwise, we would know it.
Interesting.
I guess that's possible. I can't believe they were kept quiet. It's possible. Yeah. I guess.
The Glare says, I can beat any lie detector. I detector test. Ask me something. Yeah.
I believe Will is correct.
But we
Will.
had a case when I was a prosecutor of a man who actually set up his wife and killed her. And he actually passed the lie detector test. He knew what to do. He passed the lie detector test. See, us lawyers who do this for a living, that's why we don't bother with them, because we know that BS.
There's,
but
there's
what
just,
you're
and
saying,
there's just no upside. It's just
the upside is public opinion. It's an upside. Absolutely.
yeah, but then you end up maybe poisoning the jury pool that you're hoping to get a fair jury from. I don't know.
Well, it can only help the jury pool for you, because if they think that you had a not guilty life.
interesting. Yeah. So Linda, the other Linda in his,
The other
Jill
Linda.
is spot on. She loves you, and
Oh,
then
Linda, I
even
love you too. Oh, it's so nice to see you.
patriot,
Oh, you do.
patriotic.
Bobby. Oh my God, you're gonna make me.
Yeah, let me show that again.
Yeah, let me see
Jill
that
is
again. I
spot
didn't
on.
quite
There
read
you
through
go.
that.
I'm sorry. And then I'm going to go patriotic. It's so nice to see Jill on here with her beautiful palm. I loved her Chihuahua Ginger and her wonderful husband Bobby. We still have her book co-authored by her mom.
Thank you. That was really nice. Thank you, Linda. Oh, patriotic. Thank you. I love your
Patriotic.
play.
Patriotic, yeah. Linda and Patriotic, big fans of yours, Jill. I mean, really big fans, and Patriotic, a member here. So let's see if we can. Let me see if I can get a screenshot of those so we can send those to you. Hold on 1 second. We can see if I can get a screenshot.
If I can get a light. See if I can get one of these things. COVID light. So I used to call them.
Yeah. Now we also have Linda has a couple other things she wants you to know about. She thinks that the verdict won't be long. Okay.
And it is now, just for those counting, it's about an hour 45 right now.
Tell me about
you must stay until we get a verdict. Okay. Well, I'm staying. I don't know if Jill can stay till we get a verdict, but I'm staying.
Something's going to happen at 5, and that would be she'll check in, see how they're doing, which is something I suggested was.
Have you ever had a judge as bad or worse as bad? Actually, I said that we all expected the judges to be against us, but I think she may be one of the worst I've seen. Next to who was it? Judge Glanville in the YSL case. He was pretty bad.
Yeah,
she's
definitely bad, and she's exposed to everybody in her,
Why did she allow cameras?
Why did she what?
Why did she allow cameras? Could she have said no? Could she have said
no? No, she did. No, it's hard to say no with cameras. It really is. You really can't these days. Unless you're in New York, which doesn't have the rule, or the Supreme Court.
But we can't see P. Diddy.
Well,
no, it's federal
court, right?
Yeah, never cameras in federal court,
right?
And we're not seeing Weinstein, who's in state court, who's now convicted, because New York
doesn't have cameras. Yeah.
That's why.
Once you allow them, once you allow them, it's hard to not allow them.
New York has no official rule about no cameras.
Could the defendant
no
have
judge has the guts to say yes?
Could the defendant have said, "I don't want a camera on me"?
That's been tried, and that does work out.
Mary Vallow was successful with that.
Yeah, but I've never been. All my clients, I've always been sitting next to them, and I always had the camera full time. The judge would say, "No, we're going to have a camera," unless the judge has only one camera. See, like in Koberger, the judge is going to use only their YouTube camera, right, Michael?
No, their Zoom in-house system. Yeah,
which is brutal.
All these like non-famous trials that are going on are filmed, and you can watch them on TV online.
No, they're not filmed because people don't make applications to come in and watch the courtroom. That's the thing. So they have to make an application. Somebody has to make an application to come in, and then it has to be granted or not granted. I think in Georgia was called a Rule 22 application on the YSL. So you make an application because or else they want to waste resources. Just like today, you didn't see, you saw it's expensive to do. Some of the courts have their own in-house Zoom, but others do not, and they don't run trials. Some of them do run proceedings though, that you could see. It varies from state to state, but generally no one's interested.
Karen, I'll tell you why. There was nothing she could do right or wrong. You're looking at every expression. I mean, I'm an expression person, right? I'm like I would be hemming and hawing. Half the time I'm trying to fall asleep. They're waking me up. I mean, it was so dry, some of the material. And I really, really objected to Hank when he got aggressive to these witnesses. These witnesses, they get paid they get paid some money to come, but they don't get paid to be abused.
No, it's tough duty. I see the fan. And I see the note that Sue from inside the courtroom says they're waiting for the O'Keefe family. Everybody else is in court. So we don't know what that means.
Sounds like they're going to send the jury home
or something. Yeah.
Or there's a question, or she asked, "Do you want to go home?" And also something is happening. Yeah, we call it the fan of injustice right now. because until the jury comes back and does the right thing or not. Yeah, Hank was really aggressive, wasn't he? How would you like to be a witness and be treated like that?
That's what I'm saying. You know what? Thank God it was the man that he was doing it to. Well, actually, there were two. So the one, what did they call him? I told you I had done this TikTok, and people were commenting. I had a lot of comments, and there was one thing that they called. It was the cute guy who was the reconstructionist for the defense.
Wolf, Dr. Wolf.
Dr. Wolf.
No, but they had a nickname for him.
Oh.
Crash Daddy.
Crash Daddy.
Crash Daddy. Because I was talking about him. I'm like, who's Crash Daddy? I mean, he is hot, right? He was so cute. But
Did you see the woman fell over in front of the
fell
courthouse
for him.
chasing
Oh
him?
my God. She tripped over the wire. I died. You see, I got the best part of the trial, even though I haven't been in all
It's not a verdict, by the way, Aiden Carney. It's not a verdict. They're not sure what it's for,
There's no way
but
it's
it's
a
not a verdict. It's not a
Okay.
verdict.
Yeah,
No
that
way.
makes sense.
It would be irresponsible, I hate to say it, to give a verdict that fast. Because you said there's 7 choices, and they really want to come out and feel like they did the right job.
Yeah.
You know, and I think guilty is easier in the sense, you know.
Well, let's find out.
Well, we're going to about find out any second.
It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not discuss this case
let
with
him go
anyone.
home.
Don't do
You're
any
gonna wrap it.
independent
Are they
research
coming
or
tomorrow?
investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the
That's impossible.
side or anything like that. So
I've been a jurist.
it's very important that you remember that. And you cannot, even if you get here before on
Did
this
we
case,
lose
for
her?
the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. We'll see you Monday morning, ready to start up fresh.
Monday.
Okay.
Tomorrow. They should be working on the weekend.
No, Judge Bev does not work on the weekend. Sorry.
Well, you know what? There are juries who do go through until they have a verdict. Saturday.
That is true. We've seen it
We've
happen.
seen that. We've seen that, right. We've
So
seen
I
that.
could leave you ladies and go see if there's anything to
Yeah,
see
go ahead.
outside
We'll
of
talk.
court.
We'll
Let me
talk.
do
Let's see
that.
if you even get an interview.
You guys talk amongst yourselves.
Ask
Okay.
ask Alan if he looked at any of any of my stuff.
See if they're still gagged. It's all about you, Linda. Come on.
I just want to know. Yeah,
I'll
they're
check back in.
preparing
Jill,
the show.
Jill, if I don't get back before you disappear, it's so nice to meet you. Thank
Nice
you for
to meet
coming
you.
on. We
Hopefully you'll invite
appreciate
me
it.
back for another case.
Of course. Take care.
My next
Okay. So I want to know what are the questions you have, because obviously people are loving your questions and loving your questions, because you're like a jury, you're like a person, jury person.
I'm the fresh face. I only came in like in the last few weeks. And
Yeah. What did you think of the closings? What did you think of the closings? Tell me what you thought of each of the closings.
I thought the defense was and I heard you speak about it after, and I agree 100% with everything you said. I thought that he was phenomenal. I think you said, Linda, he was the best you've ever heard.
I bet best closing I've ever heard given, and I've heard a lot of closings. Best one I've ever heard given. Yeah.
You have a great show. So, and by the way, I want to tell you something else that's great. While I'm watching, I'm speaking to you. I've got my TV on, and while you tuned into the court where you heard Judge Bev give that instruction, which I think is important for people to know when they're coming back. Court TV, they didn't have it. They had some guy talking. They should have interrupted and shut him up and put him back in the courtroom. They don't have a good producer.
So there's this whole movement now to have this delay and to talk. I think people want to hear it as it's going on.
I need to know when it's happening.
Yeah, that's why you're watching. That's why I think YouTube is the streaming is where it's going to go. We tried to get a
first time. Listen to you.
We have press credentials. We have press credentials for Center Street, for Atlanta, and we're small. We just started like 6-8 months ago, and Massachusetts doesn't recognize any YouTube streamers if that's all they have as media. What are we talking about?
They will. They
have to.
By the way, on another news, you want to hear this news? I mean, it's another unrelated to the case. Did you know that In Touch, Life and Style, and the other one are closing at the end of June? They're closing forever.
No, the magazines.
I found out today. A friend of mine is an editor, and he wrote me.
Oh, I didn't know that. No, but they
all these years they let me go today, and it's my last.
Oh.
And they're closing the magazines.
Ah.
So sad, Linda. You know, I have to tell you, when I was on television 100 years ago, all I wanted to do was see my picture in the thing. All I wanted, I'd buy them every week, and I'd be at the grocery or whatever, and I'm like, Mommy, look, picture me. I mean, it was like the most exciting thing. And then, you know, leave it to social media to ruin that for every celebrity, right? Now we're not special anymore because everyone's a celebrity and everyone's got Instagram and influencers are bigger than celebrities and all that. But it's kind of sad. It's the death of an era, just like newspapers, you know.
Forget newspapers. Forget newspapers. They're gone. They're gone. And the whole idea of like, my husband said to me this morning, you know, the Air India crash, that'll be off the headlines by today. And sure enough, you know, it's like, okay, you know, Air India, that happened a year ago. Everything is fast. You know, the shelf life of story is like an hour.
It's too fast. By the way, is my coloring weird? I feel like I have a weird coloring. Am I weird? Should I get rid of that light?
No, the light's good. Matter of fact, anything you need more light. You need more light.
Okay. What I see and what you see is different, right? You know that.
Okay, yeah. I know that. Yeah. That's better. That gives you more light. Yeah, more light on your face.
I need feedback.
Yeah.
Okay, sorry about that, everybody.
No, that's okay. That's okay. So what was the high point of Alan Jackson's closing to you? Because I'm going to ask you the same thing about Brennan.
I agree with everything. Like I said, where he opened up with 3 words: not guilty, not guilty. No. He said
collision.
Because he was explaining to the jury that this case is all about her hitting him or not hitting him. So if you believe she didn't touch him, if the car didn't touch him, then there's nothing, we're not talking about anything else. That's all we're talking about. Did she hit him or did she not hit him? So if you don't think she hit him because there's not enough physical evidence to prove it, which there isn't. I mean,
there isn't. There's not enough. Whether you think she did it or not, you know, he borrowed. It's interesting. Alan borrowed from really the California charges, which Johnny Cochran, if you go back and look at his closing in the O.J. Simpson case, talked about it. You may think they did it. It may be possible they did it. It could be probable they did it. Most likely they did it. But it's proof beyond a reasonable doubt. He borrowed from that California charge, which he's used to because that's where he practices in California.
And I heard he's doing this pro bono the second time. Is that true?
That's what he says. That's what he says, and very well could be. I mean, he's certainly gotten a lot of publicity.
A lot about how he feels about his client, because I don't know too many lawyers who go pro bono, even if they did lose the first trial.
Yeah, no, I've done a lot of pro bono work because you believe your client's innocent. You know, even some of the older cases you look at, some of the lawyers who got paid then try to go to the public defenders because they still run an office. So it's kind of hard to, if you're going to be in a 6 or 8 month trial, to eat or support your staff. Unless you're getting some kind of compensation.
A hotel, and he's got to say she's staying in a hotel. How is she affording this?
I can't talk about that, but I did a lot of it pro bono. I really did. I did a lot of it.
I'm talking Karen Reed. How did she afford this? Is she from money? Does she have?
No, she's got a fund. Apparently, a fund that's that people donate to. She's raised a lot of money. She's got fundraisers and she's raised an awful lot of money. We have not done that because we felt that by running a fundraiser that tipped us over the side of, you know, when we wanted to say, well, we believe that it's not guilty. We want people to understand this because we believe it's not guilty, not because we're fundraising for it. Charlie, thank you so much for that donation. Appreciate it. Michael Bryant can get a coffee, you know. Poor Michael Bryant got up at 5 o'clock in the morning and drove from Connecticut. So you said your father was a judge in Connecticut, or your brother?
My sister is a sitting judge, a probate judge. My sister's a probate. Lisa Wexler, and she's a probate judge in Westport, Connecticut.
Okay. For people that don't know, probate is when you're dealing with an estate of a deceased, somebody who's died and all, just so you know. And
all judges have their, you know, thing, and there's things that you like about your job and you don't like your job. What my sister does is so heart-wrenching almost every day, and you don't realize this, and I'm sure you know this because you're a lawyer, or maybe you don't. Most of her time is spent in hospitals, committing people or not committing them. But there's emergency hearings every day by somebody in the area who's in need of, you know, mental health help, and she has to commit them or not commit them, and that's probably the hardest thing she has to tell people they can't go home.
That's beyond.
Yeah, you know, people fight over money. A lot of estates crazy. I told her she needs a talk show. You're not a talk show, like a judge show. You know, they have all these.
Right. Because people don't understand. People don't understand that probate judges see all this. Plus, a lot of times you have families fighting with each other too, right?
Housewives, you have no idea. Right? These people fight. Oh my God! And then you have, heartbreaking things. Well, name changes are always sometimes a nice thing, and sometimes adoptions and taking kids away, and really heart wrenching.
Yeah. You see, we have everyone on here just loves you. So the high point you think was the collision, not guilty.
He was able to take you through. I thought that he was able to take you through the story and give you a lot of common sense, because throughout the trial, there are moments, like I said, that I just wanted to fall asleep. And I got very angry at the prosecutor mostly. Sometimes he would be, what's his name, Alan? Sometimes he would be a little aggressive. But Hank has like no personality. So when he's aggressive, he's just mean. Like I could be aggressive.
Can I stop you? That's a great observation. When he's aggressive, he's mean. That's a great, because there was no, like it went from 1 to 10. There was nothing in between, right?
Be aggressive, but I have a personality, and I like to say I have softness. So like I actually just had a fight right now, if you want to know the truth.
Oh, be careful, because somebody's going to accuse you of murder if you have a fight.
I just had a fight with the restaurant and the manager of the restaurant. I told him to call the police. So my girlfriend came from my father's birthday. He's 97. 97, God bless, and in great health. I mean,
that's great.
Great health.
God bless him. Knock on wood.
My mother, she's great, but not as great. My father's unbelievable. So we go to this restaurant. I won't even name it because I'm pissed. On the beach in Delray, and it's like a motel hotel with a beautiful outside, not a fancy restaurant though, and an indoor-outdoor. So the table they originally give us is like a booth that you put 8 people on the inside. It's ridiculous. The restaurant's empty. They have this nice round table by the window looking at the ocean. So we ask if we can sit there. We do. One of my assistants, she came with her dog because the dog had been alone all day. Whatever. She's got and I asked her for the papers. She has a legal service animal. And I saw those papers, and I know the difference between service animal and emotional support. And she travels on it, whatever. And she has the papers. And they say to her, she can't, and she had them in a stroller, a baby stroller, not even on the floor. And they say that this woman says to her, she can't sit there at this round table in the corner because there's carpeting there, but she could sit over by the bar area that we wouldn't have a view of the ocean because it has wood there, that no one's allowed to sit there with the animal. And I get up, of course, my mouth, and I go and speak to the manager. Well, it didn't work. I go to speak to the manager, and he says to me, I'm sorry, you can't sit there because it's a rule, blah, blah, blah. And I'm like, okay, you have to allow service animals in the restaurant. You know that. And he says, we don't have to anymore.
Yes, I do. What is he talking about?
Hold on, don't worry. He's going to get a letter from the state. I'm already, And I should have ChatGPT'd it right then and there. But he says to me, and I said, no, you absolutely have to. He goes, no, they changed it. I don't have to. I said, you know what? Do me a favor. And now I start to raise my voice, Linda. I said, do me a favor. Call the police. And he was like, ugh. I'm like, call the police. Do me a favor, because I don't want. And then he kind of scared me a little, like he was going to ask me to leave. He's like, well, I can ask you to, but he didn't say leave. He said to sit over there or whatever. And then I'm like, my 96-year-old father, my mother, what am I going to do to them? Make them now have to go an hour for another restaurant? Shut up. Shut up. So I'm like, okay. And we move tables with the dog and my parents who are 100, and the restaurant's fucking empty. So I look it up at the table on ChatGPT, and not only does it say they have to allow service animals anywhere humans are allowed, so that if the human's allowed for the carpet, so is the service animal, which I
Absolutely.
knew because the service animal provides a service to a human if it's a seeing eye dog or has to be diabetic or whatever it is. Now, it doesn't matter if there's carpet or not. Oh, I also said to him, do you allow children in the restaurant? He says, yes. I said, do you allow strollers in the restaurant? He said, yes. I said, well, this baby dog is in a stroller. I don't understand the difference. If the dog is in a stroller here versus in a stroller there. You know what? The guy was a fucking moron. And, but when I'm yelling, I'm still funny. I have a personality. I'm like, I'm yelling at you, but you're still laughing because I'm hysterical. The difference is Hank, not so funny. So when he's mad, he's mean.
Yeah, he was mean, right? I did a rant, to me with the women, do you have a problem with your memory? To Dr. Russell, and to the medical examiner, do you have a problem with your memory? Like women are, you have a problem with your memory? I was like really pissed.
Linda, you have no idea. I would be so fucking, and the judge would be yelling at me because I would be like, don't talk to me like that.
Yeah, you'd say, but you can't.
Scripted things that I would say to this lawyer, like, I don't need to be here right now and be abused by you. I could go home and be abused by Gary.
Right. I mean, I just how about this? How about I'm getting off on the closings, but how about the ham sandwich? Okay. What I wanted to say when he asked Dr. Welcher, he said, "Did you go have a ham sandwich with the defense team?" He said, "Yes, I'm waiting for the car."
But I would have said, "I'm kosher. I don't appreciate it."
That's great. I think that's great. I would have followed up if I were the defense. Here would be my mouth. Excuse me, doctor. Was it with mayonnaise? What kind of mayonnaise? Was it Hellman's? Was it Duke's? Was it Kewpie? Or did it have mustard? Did it have raw? I mean, it was so ridiculous.
So let's talk about this as a legal, as an attorney, right? You're a defense attorney now, but you were a prosecutor. So
yeah. And somebody asked, what's the fastest I ever had a jury come in? I had a jury come in for a murder verdict, finding somebody guilty of murder in 45 minutes. That's my fastest jury ever.
And it took 45 minutes. In other words, it's not, you still have to fill out the paperwork, people.
Right.
First of all, you're all going to sit down, and sometimes, I think you talked about this, most of the time, and I've been a juror, by the way.
You have been? Oh, because we have I think our jury consultant is going to come to join you at 5 p.m. Yes, Richard Gabriel, who is like my jury consultant inspector and was a jury consultant at Rapi with Michelle. He's joining us because I said you're going to be on, so he's going to join us. You're going to be able to ask him questions.
I have questions for him. So I was on, and I'll talk about it when he's on, but I was a juror on a rape carjacking.
A rape carjacking. Oh my God. Oh my. Why don't you need PTSD from that? That is.
It was, and you know what? It was in Fort Tyrone Park. For anybody who doesn't know, that's north of Harlem and north of Washington Heights. It's like past the GW Bridge north. Right? That's Fort Tyrone Park. And it's like Central Park for where they live. It's a beautiful park, I've heard, and has views of the Hudson. And if and it was a lover's lane, and there was a couple making out, and these 4 African-American men got up on the car and carjacked the car, and she was raped.
Oh my God. Oh, the poor woman.
All you know as a juror, right, is you have one of the boys on trial, and because they don't tell you everything until after, which they don't always do. First of all, I had a great judge, which makes such a difference, because as a juror, if you have a great judge, you want to please him. Like, you want to do the right thing by him. Because you want him
or her, and that's the part I told everybody here, that the jurors get attached to their judges. You got to be careful.
Very much attached to him, and he was like the god, for the 2 or 3 days that we were deliberating. But I will tell you what I loved about my judge. When we were over and we gave our verdict, which I'll tell you, and I'll tell you how we found our verdict, how we found the answer. He came in afterwards and he says, "I just want to tell you that you guys were right on the law. You did the right thing." So what happened was, he was charged with the carjacking and the rape. And at the end of it, we didn't believe he did the rape. We didn't believe he could prove that he did the rape. She was raped for sure, but we just weren't sure it was him or one of the others. And we didn't know what happened to the others. We found out afterwards that they all pled. And the reason why this boy didn't plea is because he wrote a confession, and he wanted it thrown out because he said it was a forced confession. So that's why he was on trial. Otherwise, he would have pled out. But we didn't know about the plea. We didn't know where the 3 boys were. So when we were in the jury room and we're trying to decide, is this boy guilty or not guilty, we're all reading this confession. And one of the jurors, and I would like to take credit, it wasn't me, there was a correction on it. Like, let's say he crossed it out and it said black, and he crossed it out and he wrote blue, okay? So I'm just using that as what he did. I don't remember what the words were, but he had some corrections, and then he signed his name, okay? So this is what someone said, if you were forced into a confession, would you correct it? That was it.
So you convicted him.
He knew that if he corrected the confession, then it was a confession. If it was a coerced confession, you would sign it.
Just sign it no matter what, because you think the cops are right. Yeah.
Also, what he corrected was irrelevant. Like, we didn't correct where he admitted or didn't admit. It was something innocuous, like black or blue.
Yeah.
It was something technical or whatever. And that's why we found him guilty. So when the judge came back and he says, you guys were right, he absolutely did it.
Oh, that's interesting.
But now I can tell you he did it. I know he did it. and you got it right. And yes, you shouldn't have found him guilty on the rape because you couldn't prove that.
But that's afterwards. So when you were in the trial, did the judge give you any hint?
I want to ask you, Linda, do judges do that? He said no. He said he says most of the time you won't hear this from a judge. Is that true? Does the judge
most of the time the judge will bring you in when there's a conviction. They'll tell the jury, you know, you got the right job. Most of the time they'll talk to the jury afterwards. Okay.
Oh, they do.
Yeah, they generally do in a serious case like that because they want the jurors to understand. They want them to go home and be able to sleep at night when you have that kind of serious crime. I'm a run-of-the-mill thing, a burglary, and I say that I don't say that lightly. But you know, I'm not talking about where somebody's going to go to jail from 25 to life. They don't do it because they don't care. But on that, where they know that the jurors are very, very concerned about whether they got it right, because I'm sure you were, right? You did your work, which is why I feel like validation.
Well, that's why I feel like I'm in the jury of Karen. Like I understand the gravity, and that's why I said you're not going to get a quick verdict because every single person there, if they're going to convict, they've got to make sure they convict rightfully in their mind and they can sleep at night. And also, if you're going to say not guilty, you want to make sure you're not making a mistake and letting someone guilty go.
Right. It's important to you. What if you don't want to be responsible? I can't imagine being responsible for a wrongful conviction. I don't know how.
Some people have to come to terms with themselves and like, I have a very quick brain. You have a quick brain. That's why you do what you do. I do it. Some people are slower. It takes them a minute. They have to digest it. So I think, and so this is what I was going to say, and I think you had said this for those who are listening. So one of two things will happen, and because I was in a jury room, you'll take a straw vote right away. Because sometimes it's obvious in a case someone's guilty or not. And it doesn't have to be a murder. I'm just saying sometimes it's obvious. Like we know the guy did it. And then everyone's like, he did it, and we're done. Sometimes it's, if it's no, I still think you have to go through it to make sure you're not letting a guilty guy go. So no matter what, I think that they're going to do a straw. If they do a straw, not everyone's going to say they want to give an answer yet. I don't think everyone's going to give an answer. And I think they're going to have to go through some of it, maybe not all of it. And I don't think you'll have a verdict for like at least a day. So today, I think Monday, maybe Tuesday.
Yeah, that's it's interesting because most of the people, I think most of the people in our poll vote today, I said Monday, I said late Monday, because I think they're going to think about it over the weekend. And that jury sheet is so hard. Last time they were 4 days. Last time they went out on Tuesday, and after they had the two hung, remember they came back and they said, "Well, you Brewer and Fowler." They came back on like 2 days later and said they were hung, and she gave them what's called this dynamite Allen charge, which says, "Well, go back in there and try again." And then they came back and said they were hung, and that took 4 days. That was 4 days.
Well, let me ask you a question. With the hung, was it the same number both times?
Or we don't know. We don't know because the judge didn't inquire. That was a problem. We didn't inquire. The judge didn't inquire whether or not the judge didn't inquire whether they were hung on one charge or all. And it turns out
they hung on one juror or 5 jurors.
We don't know. They didn't ask. The judge didn't ask the question. They never asked the question.
Afterwards, didn't the jurists come out and say, "Listen, this asshole"?
There's been 2 stories. Some of the jurors said we all acquitted on 1 and 3. That was an agreement. And then other jurors said it was 6-5. Someone said it was there was 6-5, and one undecided. One said it was 10-3 or 10-2. One said it was 9-3. So who the heck knows?
You're telling me that 12 people couldn't come out with the same answer of how they?
Yeah, no, apparently not.
I mean, that's a problem.
And the problem maybe is because you had all these. You have these sub things here. You know, it's not just count 2. It's these sub charges. It's the lesser included. So maybe they were screwed up on who was for one lesser included or who was against all the lesser included. That if you read this you have to read this. Missy will send it to you. This sheet, this verdict sheet. It is so confusing.
You show it to the people listening to the show. Can you put it up on your screen?
Yeah, we have it up a little bit. We can put it back up. Can we stick it back up even with? We have to even take me out and put it up. The verdict sheet on here.
You know, it's not the Oscars, but it would be interesting for us to print it out and fill it out and see how we all do.
Okay, so let's see if we can go to it, and then if Richard comes on, we'll bring Richard in to talk about the jury. Can we get a little larger, or we may have to go a little smaller on our side. So let's go through this.
Oh, this is great. I love this. Okay, verdict slip.
That's what they call it in Massachusetts. Everyone else calls it a verdict form. You know, from being on a jury.
I don't know because I wasn't the foreman, so I didn't have to do it.
Ah.
Order while operating a vehicle under the. Well, first of all, can we talk about the first thing? under the influence of liquor. She didn't have a sobriety test at the accident, or whatever. How could you prove anybody's drunk?
Yeah, they did. So they took her blood like 8 hours later, and then tried to do what's called a retrograde extrapolation. But it was garbage because they took this
for drunk driving, Linda. Does that hold up for drunk driving? That test?
in some states it can, but not with, like in New Jersey, you would need a double test. You wouldn't just need one test because you have to show whether the person's going up in drinking or down in drinking. You have to show whether the blood's going up. But they did it wrong here because they took serum versus whole blood, and there was all issues with this. So
let me
I
ask
don't
you,
think it would convict her.
Just on that first thing, you're telling me if she was in a car accident unrelated to a murder, in a car accident with the test that they gave her, would they be able to use that against her or no?
They could use it against her, but it depends on whether or not the serum, the defense challenge of validity. It depends on whether it was the serum or the whole blood, and whether or not they accounted for the fact that she has what disease that she had, which it changes how the blood gets taken from your system. That wasn't multiple sclerosis. What does she have?
To me, it's a problem in itself that you can't find her guilty of anything having to do with
It's an issue. It's an issue. The blood test itself is an issue. Okay.
So not guilty of the offense, whatever. Guilty of the offense is charged manslaughter while operating a motor vehicle under the influence. Again, with the under the influence. Is there one without being under the influence? Manslaughter while operating under the influence, and or manslaughter while operating a motor vehicle with the blood alcohol. Okay, so what's the difference? Can you explain the difference between a 0.08 and greater and under the influence of liquor?
It's different penalties. So they're just saying one is under the influence. No matter what you were drinking, you were under the influence, as opposed to you were legally drunk under the influence of 0.08. One's legally drunk and one is just, it's affecting you.
And what would be a sentence for that?
I don't remember, but it was pretty big, right, Michael? Michael Bryan is getting on the thing. He says 1 minute. Okay. I don't remember. I'm going to have to look it up, Jill. I don't remember.
I like to know the difference in things, because I watched this. I'll tell you something else that bothered me, Linda. When I watched the documentary and they arrested her, and the police went to arrest her the first time, and then they came back and arrested her again, very violently. They didn't have to do that. I mean, I watched the documentary and there was video of second-degree murder, and second-degree murder is like, second degree murder is murder. Manslaughter is different. There's manslaughter for all different reasons, meaning someone died.
Right.
Not meaning to die, but they died. But
right. Exactly. All different reasons. Just like here, by the way, the prosecution didn't want any of these. They just wanted the top manslaughter. They didn't want all the rest of the
The fact that the prosecutor in the beginning, carrying on till now, even had second-degree murder on the sheet, to me makes him a piece of shit. Because never, ever, ever did anyone think that she intentionally, first-degree murder means she woke up in the morning, knew she wanted to kill him, planned it all out, and did it, right? That's first degree.
Here's your verdict slip for that. Murder in the second degree. And Massachusetts has this weird thing that if you do a conduct intentionally that could kill somebody, that's murder. Because first degree is usually the killing of a cop.
He talked about this. Hank said this. He talked about the intending act.
Right, the intending act. You had to have an intending act. It doesn't necessarily mean that you had a motive to kill, but you knew that if you were you intended to back up into him, knowing that would likely kill him.
So then I would challenge Hank the genius and say to him, well, you can't have it both ways, sweetheart. You can't say she's a drunk and can't stand up and is wasted, and then say also, but she had the thought of mind to know that if she went forward, she'd do this, and if she went backward, she would kill him. What is it?
Yeah.
If she's wasted drunk, I don't think she could even do that.
I don't think she could drive the car even when she wasn't drunk. I mean, with regards 20 in a straight line to hit somebody, in the snow.
Sound mind, making a sound decision, and at the same time be accused of being an alcoholic, being drunk and killing someone. So to me, you can't have it both ways. And I didn't like that. I didn't like this second degree, because I always thought that was overreaching. And that instead of the truth being, if anything, she hit him and left the scene of a crime and then came back later. Like she hit him accidentally, left, and then she realized, oh shit, to me, common sense is, and again, the physical proof doesn't match it, and she has to be found guilty because it's not perfectly wrapped up in a bow. But I do see a scenario where she felt she hit him, maybe, but left because she was pissed. But then when she couldn't get him on the phone, she started to panic and go, oh my God, maybe I really did hit him. And that's why she called her girlfriend, because she didn't want to go back alone and see a dead body. And went back alone, and then absolutely freaked out and possibly said, oh my God, did I hit him? Like,
do you think if the prosecutor had not gone for the second-degree murder, they would have had a better chance to convict on the manslaughter?
You bet. Because if I'm a jurist, I'm telling you, I don't like second-degree murder. I don't know when you overreach. Don't charge for that second degree. You made a mistake. You did it then. And that was because of the whole blue, right? The whole massacre with the police and, the wall of blue. And it was their homeboy, and they wanted to make sure, But then there's all these things like that make me crazy that I can't, like I said, wrap it up in a bow. Like when the bad guy who they fired, right? What was his name? The guy who they fired.
You mean Proctor, who got fired? Michael Proctor?
Yeah.
Yeah, the one who called her a whack job and said she has a leaky balloon and she basically goes doo-doo in her pants.
That's enough for me as a jurist to find her not guilty.
Right, me too. I mean, it was outrageous how and that's, he didn't even have an autopsy report, Jill. He had no cause of death when he was doing all this stuff.
His negligence is enough for not guilty.
Okay, let me jump in here. Let me jump in here if I can, if you don't mind. First of all, thanks to Jersey Girl for the cold drink fund, because I'm running out. So obviously I got back and they were just leaving the courthouse there. I was able to ask Mr. Alessi, as I did Mr. Yannetti. I said, "Are you guys still gagged?" And he went like, I said, "Does that make sense to you?" And he was like, like he couldn't answer, but he answered. And so for whatever reason, they are following apparently the court's direction not to talk. So
yeah.
I also, and I'll put this up when I get done here with you guys. I also talked to somebody who'd just flown in from Minneapolis, was here hoping there was going to be a verdict today. Now she's all concerned because she has a flight out Monday afternoon and she might miss the verdict. But, these people see this, and Jill, you could relate to this. It's like a TV show for them, right? So they come out here and they want to go to the set. The courthouse, it seems much smaller than it did on TV. And then they go to this place and they go to that place. And it's taken on that kind of mystique for some people that it is, they're fascinated by it. They don't like what's happening. I've never found anybody that is here cheering on the Commonwealth. I'm sorry. I've been looking. It just doesn't happen. But those that are here to support Karen Read and the defense, it's overwhelming. And I'm just collecting how many states I'm hearing from people. Add Wisconsin to the mix.
In Wisconsin. By the way, Missy, we have Richard yet? Because Jill wants to ask Richard Gabriel some questions here. By the way, did you hear anything from Michael when you were out there about the jury? Did the judge ask if the jury wanted to go home? Is that how this happened?
Yeah, unclear. Because you may have heard there's a gag. And then I was trying to talk to Esty for just a second.
Esty is a friend, is Karen Read's best friend.
Yes, and so she's kind of in that inner circle. But I caught her at a time in which a friend of the support group had just talked to her, and she was actually very emotional and wasn't really able to chat with me much because she was so emotional about this woman who has been so supportive and, in her opinion, not getting really a lot of credit for the support she provides. So didn't get any real detail from her. Bad time, as they say. So not officially hearing why they kicked them loose. Did somebody check, or did the jury offer that we're not doing anything today?
Interesting. I think Richard Gabriel's on. We have to tell him. But everyone loves you, Jill. Everyone is like having a great time that you're on a legal show.
You may not have enough room for all of us.
Yeah, we do.
Oh, yeah, we do.
We got you. We've done this. We've been doing this. We're pretty good at it now. Richard Gabriel is my friend, my jury consultant. Richard Gabriel has donated a lot of time when we did the Tennessee case for the Innocence Project they went to the U.S. Supreme Court and came back. And then he did the jury verdict sheet for my Tennessee counsel and I. And as I always say when I introduce him, it had the best question because it asked the people in Maynardville, Tennessee, in case you've heard of it, a big hot spot. What do you think of defense lawyers? And it was all misspelled, but the answer said they're doing the best they can for the person we're going to convict anyway. But it was all misspelled, but it was perfect because it explains exactly what you want to find out from a juror about whether they have bias before they get on. So Richard Gabriel, the best jury consultant in the world, according to me, and his team, which can include Michelle Ward when he's there. Richard, meet Jill Zarin, one of the original gangstas, as I'm going to call it, from the Real Housewives of New York City, which really means New York, because New York City is New York. It's the best. And welcome back, Richard.
Richard, good to see you again.
Good to see you guys too. Exciting.
Yeah. So as a great jury consultant, first of all, we want to know what you think of today, and then Jill has questions for you. You won't believe.
Always like those. So yeah, today, I mean, both of them dug in and did what they did. As we know, I mean, Hank Brennan's a good lawyer. He really is. And
whether you like him or not.
Well,
whether you like him or not.
You know what? A good lawyer to me is someone who can get through to me to make sure I pay attention to everything you're saying, right? If you're a good lawyer, you want to make sure as a juror, I'm listening to you. Right. And I think he made two mistakes. One is he got very aggressive and abusive with some of the witnesses. And that to me as a juror, I find offensive because I see these people as doing their civic duty and coming in. Some of them get paid, some of them don't, but nobody comes in to be abused and belittled and made fun of, or, you know, makes it look like a moron, like what you were saying. Is it Hellman's May or is it this? Like, I want to get to the end, which is the person guilty or not guilty? So don't clog my brain up, which has been here for 30 days, with fighting with someone and nitpicking someone. It's like, I find that annoying, and I don't think that makes a good lawyer. I think you want to have the jurors like you, because if the jurors like you, they trust you. So if you're telling them something, you believe them. But if you piss me off and I think you're a moron and a jerk, I want to find you. If you're the defense lawyer, I want to find your guy guilty because you're annoying me. Just my opinion.
Richard, I love it. Go ahead, Richard. Go.
Well, Jill, you would be a good defense juror. You would be an excellent defense juror in a case like this. And like a lot of people, they do. It depends which way you're leaning anyways. You know, jury selection is about how people already feel about a highly publicized case like this. So, I mean, that's one of the issues that I think Hank actually was dealing with initially, which is, you know, people have heard about this case. They've seen about this case. They come in preloaded with a lot of opinions about this case. And as we know about confirmation bias, people always want to gather evidence to support what they already believe. So that's where the critical part of jury selection is really whether they found people who truly were open-minded or whether people had already made up their minds originally. So, you know, that's sort of where I think the rubber meets the road with where these jurors are at. Obviously, the real thing that's happening right now as we're talking is those jurors are really, the dynamics of deliberation are playing out. How do they feel about each other? How do they feel about, do they get along with each other? Obviously, prosecution needs a unanimous jury on here. So any dissent like they had last time is a big problem for them. If people come preloaded with, again, a lot of problems with the case, then, you know, obviously prosecution is going to have a huge uphill battle here. And as you saw with Alan Jackson in his closing, he hit things very hard. Alan Jackson is a great lawyer, and he made some obviously points that, funny enough, go back to what we experienced in the OJ case, which is when we were finishing up OJ Simpson, we did a focus group which said, should Johnny Cochran in his closing argument,
which trial of OJ? Which trial?
The first trial.
Okay, sorry.
Okay, the first murder trial. We asked jurors in a focus group, do you want Johnny to basically talk about this widespread conspiracy, or do you want it to be more of a localized cover-up of of our lead investigators, Van Adder and Lang and all those guys and stuff, and Furman and stuff? And they said, no, we want, it's really the contaminated examination, the contaminated investigation which Alan Jackson used here. So you can't trust the investigation. You can't trust the evidence. That's really the theme that he brought to this. And that obviously is what he's hoping to create reasonable doubt here. And so I think he did a very good job trying to do this. And as you saw, they said they weren't going to go for this sort of widespread conspiracy. There was motions about that and stuff. And to a certain extent, that's a very smart strategy because it's hard to sell that an entire department's in on it and stuff. So
I agree with you because, especially since it's been 3 years, it's hard to believe that nobody would have broken, told a girlfriend, told a friend, something would have leaked where one of them would have broken because, if there was a conspiracy, you have to think somebody would break, that somebody would, eventually break. 3 years is a long time to hold a secret. So if you start to go down that road, I would say,
I'm sorry, Richard, I got a question for you. And Jill, I don't know. I think maybe from your background, loose lips might be more common than in the potential conspiracy in this case. But I do agree with you, Jill, on one point, and that is Hank Brennan, no matter what he does, if he makes a good point, the assholery effect makes it even less likely you're going to, like the guy or believe the guy. Richard, here's my question for you. Are you surprised? What do you make of still having all 18 jurors at the end of this trial, 6 alts all in place?
Well, again, this thing is such a big case. It's been around for such a long time. People are really motivated. Jurors are really motivated to stick with it. Aside from some extreme.
The alternates because, they stayed for 30 days. They had to get up early in the morning. They had to give up their lives, and they don't even get to give their opinion.
Yeah, so everybody is hoping to participate. Everybody wants to be able to tell the story at the end of this case about how they sat through the entire trial there. Whether that's because they say, I want to be here to convict, or whether they say, I want to be here because I really have an agenda to acquit Karen Read, that's another thing. I mean, we are always looking at the motivation of jurors in terms of sticking with it. Typically jurors want to look for any excuse to get out of jury duty. But in this case, there's a lot of motivation, whether to stick with it, at least just for the story.
Let me just say something to all of you may not know out there. Richard has an experience with Alan Jackson because Richard was my jury consultant and Phil Spector were Alan Jackson for 6 months, was our adversary, and we fought very hard in court and then ended up, having this mutual respect for each other, as Richard knows. But so, Richard, Alan Jackson from the other side. Tell me what you saw differently in the years that's passed that he's now switched to the defense side.
The only difference is that he switched sides. I mean, he's still a very, very aggressive, very, very good attorney. I mean, look, the challenge for a lot of prosecutors, or it's not for prosecutors, is that in a case like this, typically, a lot of prosecutors are dealing with public defenders that they're dealing with on a day-to-day basis. And so as a result, there's a lot of camaraderie. There's plea agreements that happen. And as a result, public defenders tend to be very shy about being very aggressive. So a vast majority of the cases that prosecutors do, they're not dealing with people who come at them with both fists, with guns and knives and ready to really do battle. And so Alan is not shy at all, as we saw in Spector, about that. In fact, there's obviously some real questions about some of the tactics he used pre-trial, about whether he's really doing these PR campaigns to really try and influence the jury pool and sometimes the ethics of that. So there's a lot of things. When he takes it so seriously to say, I'm an advocate for my client, and he goes full bore on that.
I also think of this also, that the juror, even though the judge is supposed to be impartial, common sense tells me that the judge and the prosecutor are kind of on one side, and the defense is on the other. So it kind of evens it out if he did a PR campaign. Especially in this case, I think Bev proves my point, as she's going like this. So he goes, I object. Did you see that one?
Jill cannot get over the signaling conspiracy. I know.
It's not a conspiracy. You have to be blind. She goes like this. He goes, I object. She's like, come back to my office. Let's have coffee. I mean, she interrupted the whole line of questioning. And
So Richard, you said on his own. What Jill's saying, how do you get over? Because we've had that, right? Where you know the judge is so biased, they're biased against you, but they normally are biased in a way that is not so clear. This was a little over the top in my view. But how to take her out of the equation? I've been saying to everybody that that Hank Brennan, despite what you dislike him, is a good lawyer. But I thought he did some snaky, sleazy things in this trial.
The sweatshirt with the holes in it, really? He didn't know? And he just put it into evidence. It wasn't in evidence.
We're talking about the shirt. Yeah, I don't know if you saw the shirt, debacle.
Yeah, I didn't see that piece of it. But the truth is, yes. I mean, look, the truth is that at this point, jurors, whatever they think of the prosecutors or the defense thing, they're, for the most part, they understand both sides are trying to play the game. They understand both sides of that. That's what they're going back there. They're kind of dismissing that, whether they like Alan Jackson or whether they like Hank Brennan or not. It kind of becomes irrelevant at some point, because they really, to a certain extent, go, okay, what's our job? We've been here for 30 days on this case. We have a lot of evidence. They do, and this is, I truly believe, jurors do a really good job of kind of focusing on what happened here. Does the forensic evidence support that he was hit by the car? What do they think of the witness statements about her saying, I hit him, I hit him, I hit him? All those things really are what they talk about.
Richard, what I'm trying to say is that when Hank goes down these, or any prosecutor or defense attorney goes down these paths and makes it personal and gets into trying to catch them in a ridiculous lie, because if they lie about the fact that they didn't know it was Hellman's, then they're lying about this, then I'm not really paying attention to your point. And then when we go back in the jury room, I can't even fight for you because you lost my attention because you were focused on bullshit and got me pissed off that I'm not even listening to you anymore. So they really just hurt themselves.
But Jill, you are keyed into personality, and some jurors, you're right, maybe that may affect them. The personality of the lawyers may be it. They may be keyed in on, I like him or I don't like him, and therefore his case either rises or falls on based on whether I like him or not. Jurors, for the most part, though, understand that both sides are going to be incredibly aggressive, that they're both sides going to be focusing on stuff, and sometimes they kind of go, that's their job, is to try and impugn credibility.
I'm not saying that what I'm saying is it doesn't rise and fall on whether I like him or not. I'm not that immature or blind to that. What I'm saying is that I'm going to miss content because of the way your lawyer behaved. The way the prosecutor behaved means he just made a disservice to himself, because when you act like that, you turn me off, not to hurt your client if it's the prosecutor, if it's the state, but I'm not listening to you making your point, which is important, right? Your point is important. You're trying to tell me something to help me convict your side or not convict your side. Because of your behavior, I'm not listening.
So this is the interesting part, Jill, and Linda knows this because this is what we've dealt with in Spectre all the time. One of our big themes in Spectre was, is it story or is it science? And for the most part, people like you are really keyed into the story element. Who are these people? What are their motivation? Do I like? Do I not like? Does it turn me off? Does it, am I listening? Those are people who are much more keyed in as jurors to really the personalities and the motivation and the characters involved here. There are some people, though, that are much more focused on what's the actual evidence, what's the forensics, what are those types of things. And that's really, that's a jury selection issue here. Because I think in terms of the story elements here, it depends on whether it can aid both sides, whether you think, oh, she's a conniving person who hit him and just trying to get off and stuff like that. That's her story. If it's just this, obviously the story, I think in this case, the personality issues tends to favor the defense because you have the lead investigator that's going after her. And again, the whole tainting of the investigation stuff. If you're conspiracy minded, of course, you're going to favor the defense in this case. So it depends on where a juror focuses, what they get caught up on, whether they did, and ultimately.
Do you know about this jury? I came into this whole case very late in the game. Do you know how many men, how many women, or anything about them at this point, or you don't find out till after?
I don't actually. It's very funny. I look for a lot of information about the jurors. I think early on there's a majority of men on the jury, but I don't remember the exact composition of this.
Interesting.
Yeah.
Yeah, it's an interesting thing, and we see the judge wouldn't let us have a lot of information on the jury, if you recall. She had this gag, and so today when she drew the numbers, we don't know, and we'll find out because we look tonight because people are in the courtroom. It's the stupidest thing because people in the courtroom know how many, men. And Aidan Carney tweeted right away that the juror in the number 1 seat was a black middle-aged male who took no notes. I was explaining to people, Richard, that it doesn't matter whether they take notes because sometimes they have agreements as who's going to take notes and who's not going to take notes.
Can you explain to me the picking of every state is different? Can you tell me how many jurors there are, how many alternates? And I thought that the first, when you pick the jurors 1 through 12 are it, and then there's the alts. You're telling me they mix them all in one pool and now they're pulling out the jury?
Yeah, that's what they did here.
So what happens sometimes, Jill?
Is that always?
No.
Or is it this case? And how she decides that?
Some judges do it differently. One of the reasons in longer cases, sometimes judges do it like this is because everybody thinks they could be a potential juror. So it sort of says all 18, if you're an alternate, you kind of sit back and kind of go, okay, maybe I'm not going to test. You may not pay as much attention. But in a case like this, the judge says you're all there. And then at the very end, everybody thinks they could potentially be a juror, keeps everybody's attention. And then they randomize, okay, these people are then the alternates.
Is it picked out of a hat, or she says it's picked out of a hat?
Well, we saw it. This time we saw it. Last time it was a little more clandestine, but this time there was balls in the old tumbler.
Like
B25, bingo, or whatever, whatever the numbers were, they pulled out, and the 6 they pulled out became the alternates.
So when they came in every day, because in the jury that I sat on, I don't remember what I was, but if I was 5, I sat in the 5th seat every day. How did they sit every day? Do you know, Michael? Because you're there.
How do they sit? Meaning what, in the box?
In the jury box. Are they always in the same seat, or did they move?
They rose except one juror got moved because he was talking to other jurors too much.
Yeah.
The guy was talking to 2 young women apparently, and so they moved him in the middle.
But generally,
have you ever seen that?
And I've not been in this courtroom, but generally, it's human nature. You sit in a chair unless you have some reason to move. People like to go back, and that becomes their spot. So other than what Linda suggested, where they had to move somebody, you can count on them pretty much taking their normal spot every day.
And how do they pick the foreman of the jury?
Judge does that. The judge does that.
Arbitrarily?
Every jurisdiction is very different, but that's how they do it here.
So so don't you think that's a little biased in itself?
Well, it can be. I think in this case, because of what happened the last time, and it just so happened to be a very advocate-like juror that she picked, people started to wonder, oh, she's picking somebody that's going to follow what she wants as the outcome. I haven't heard that yet with the African-American, 40-ish aged guy that has now been chosen for this jury. So it
ended up being, I think it was equal 8, 9, and 9. Now it's 7 men, 5 women. Richard, on this case, who would you think would have been the ideal juror, male or female, or does it matter?
I don't think demographics matters in this case. The truth is that we take a look at gender, especially in terms of how's that going to play out. I think that to a certain extent, men tend to be protective of women. I think men it's harder to typically convict women defendants in general. I mean, it's funny. There's some of the statistics are pretty alarming, actually, when you take a look at especially death penalty cases, because it's significantly higher in a death penalty case that a person, if you're male, you're going to get convicted than if you're female. So there's that tend to be protective thing sometimes with men over women, and that's what we find in a lot of these cases. So maybe that might be a little bit of an advantage in having a majority of men. But again, it's really more about the personalities and whether they're focused on sort of the forensics of the case and really what that shows, or whether people are really caught up in this story of this beleaguered relationship.
Let me ask you another question. Why do you think a juror could think Hank Brennan is a good lawyer? Let's from a jury consultant point of view.
Why would a juror think he's a good lawyer?
Yeah, right.
Well,
does it matter? I don't know what you're trying to get at, Linda. What do you mean? Does it matter?
I want to know because I said early on too that Hank Brennan is technically a very good lawyer. No matter what you think of him, He's a good, I don't like his sleazy activity, but they hired him to get a conviction. You know, you hire, if you're a defense attorney, you hire him because you want to, you know, you're Whitey Bulger, right? So what are the assets that he brought?
Well, I
And
mean,
did they
one
work
of the things
against
that makes
Allen?
him a good lawyer is he's had a very successful career. He's had a lot of convictions when things. He also was Whitey Bulger's lawyer on the
Didn't
defense
Whitey
side, so he knows.
Bulger die in jail?
Yeah. Oh yeah.
He did such a good job.
Yeah, he was going
Well,
to prison no matter what. He was going.
Yeah,
to
it's
He didn't win for Whitey.
look. Alan Jackson's have defendants that have been convicted too. When you're a defense lawyer, you have people that get convicted. That's not the.
He didn't have a great
the
client,
market.
Whitey Bulger, who wants him out on the street. You don't really want to win for his lawyer.
So I mean, I think that there's a lot of jurors don't mind the overly aggressive, even obnoxious thing. You know, for the most part, that intense, you know, kind of approach. First of all, it can keep your attention. They expect the battle in the courtroom in there, and I think there's a thing. I mean, there are times where I've said, "Boy, that seems over the top." We thought that with Alan Jackson at times too.
Right. Remember, we thought that with people loved Allen. I guess it goes back to the whole confirmation bias. You know, people think if they're for you, they love it when you're aggressive. That's what they're expecting. They're expecting because they want to think that if they hire you, that's how you'll represent them. I mean, that's my view.
Yeah, and people these days, people are very passionate these days. We live in very polarized times. So having somebody express some real intense conviction, whichever you may believe on this, is something that is gratifying for people. You know, as you said, Jill, sometimes you just got to keep my attention in a trial. And sometimes if somebody's, just trying to lay back and, you know, be very sort of more high road in the thing, sometimes it's just not as interesting.
Did you see any? Yeah. Did you see any of the Lally, Jill? Because Lally tried the case last time. Talk about not keeping your attention.
Who? Wait, who?
Yeah,
Lally,
the former prosecutor.
who was in the courtroom, did some of the examinations, like 2 minor
I have a
examinations.
question for you.
I mean,
how long is it going to take to get an answer? Yes, that's the question.
I missed the question.
To get a verdict.
What's your guess? Obviously nobody knows, but what's your educated guess?
So the two things that happen here is this. There are two types of deliberations typically with a jury. There's what we call evidence-driven deliberations or verdict-driven deliberations. And sometimes it depends on just what the foreman wants to do. So a foreman will sit down and go, okay, everybody, let's see where we're at. How many yeses, how many no's on this question? That's quicker. That's a faster thing because sometimes if everybody agrees, boy, they're done pretty quickly here. The evidence-driven deliberation, which is done sometimes by a foreman or a foreperson, is where there's like, okay, let's break it down. Let's kind of go through the evidence piece by piece to see where we stand. That can take a long time. The other thing that creates division here, hang on, Jill. The only thing that can take a little bit more time is if there's obviously conflict in the jury room, like there was last time. If people are really divided, then it's going to take a lot longer. Prosecutors need unanimous verdicts. So jury selection for them really is not just about, can I pick good jurors, but can I get jurors to get along? Because I need everybody to work together to come to conviction. Defense lawyers sometimes are like, I don't care if there's some crazy person on this jury, because sometimes that can throw the monkey in the works. And if we get another hung jury, then I might be able to get this case dismissed, or I might be able to get the charges reduced, or whatever it is. It's going to be much harder to try her for a third time.
Which they're talking about, right?
Wow.
Yeah.
Yeah, that's it. That's interesting. They want in jury selection, prosecutors want people to get along so they can all, be friends, so to speak. And defense want conflict-driven jurors here. Interesting. Very interesting.
Yeah, I mean, when I'm watching at the jurors, I'm during the trial, I'm trying to look at how they act with each other on the break. They look like they're all getting along. They look like there's camaraderie. Does it look like there's somebody who's kind of a little bit on the outs and stuff like that? That tells me a little bit about what the jury dynamic is. And that's really important as they start deliberating, is how do these people get along?
So Richard, this jury foreman, you don't know you're going to be a jury foreman, obviously, right? Who teaches you how to be a jury foreman? So you said that
Nobody.
You know what I'm saying is you said there's two kinds of way to start. Well, who's going to tell him that?
Well, in this case, it's important because the judge instructed them not to take a straw poll when they first got into the room, which I thought was odd.
Excuse me?
Yeah, did you ever hear that, Richard?
She said
I
we don't
didn't hear that,
recommend.
no.
Yeah, she said I don't recommend that. And I've never heard that as part of the
Why is
instructions.
that
so
her
that's what-
business? You see, again, with the jury bias.
yeah, normally it's, whatever the jury personality is, that's what you do. But she's guided them.
Well, that's another thing. Like, so first of all, I don't know, I guess straw poll is something you know what that is. You like kind of, it's an intuitive thing. But the evidence base, like the way you worded it, I guess maybe it's intuitive to do that also in a jury room. But I mean, does the judge talk to the foreman for a few minutes and say, this is your responsibility. You're supposed to fill this out. You're supposed to turn it in. Like, how does he know what his job is? I don't know what to do if I was a jury foreperson.
So
I can imagine what might happen if Jill was the jury foreperson. I don't think there's any doubt about what would happen.
So what happens? They had the break. So do they Monday? Since the judges told them yesterday not to take a straw vote, would they come in Monday and do take a straw vote to see where they're at, or what?
So I think it depends a little bit on what the conversations were today. Whether, I mean, what can reasonably happen here is, even if they don't take a straw poll, is I think they can say, okay, let's talk about the issues here. There's obviously major issues in the case that they can start kicking around. Then they sit over the weekend and they think about it, and they kind of know where everybody else is at on the stuff. So I think at that point, either they come back in and again start deliberating on some of the issues here, or they say, okay, if it looks like from this initial conversation that people seem to be in agreement, whether it's on conviction or acquittal and stuff like that, I think you could see an early straw poll, probably not until Monday.
Well, I will tell you that I did an unscientific poll study on my Instagram account. I think I got about 2,000 people answer, and 81% was to acquit.
Yeah.
Have you guys done that on yours? Social media?
Well, I haven't done it on social media, but I think some of the polling prior to the trial was that I think it was less than that, but I still think about 2/3 of the people in the area thought she should be acquitted and stuff.
Do you think that they made a case better for acquittal so if you're saying at the beginning 2/3 thought she should be acquitted, do you think they did a better job during this trial to make more think acquittal or less? Do you know what I mean?
So the interesting thing about preconditioning, and this is something I really do believe, is that I'm a huge fan of juries and of juries, even where, like, and I'll give you a quick example. I worked on the Casey Anthony case, all right? And in the Casey Anthony case, 80% of all of Florida thought she was guilty and thought she should get the death penalty for the most part, all right? Despite that, when we picked the jury on that case, those jurors acquitted her of all the charges. So even despite sometimes really strong public opinion in one way or the other, jurors will take it real seriously, and they will break it down and can come back with a very unpopular opinion.
Do you think it had to do, obviously you helped pick juries. So what do you think you did on that jury that might have helped?
Well, so that was a little bit different case, and I think a lot of credit has to be given to Jose on that. I think a number of things happened in that case. So yes, we managed to weed out. It was a death penalty case. So for the most part, when you're picking death penalty juries, all you're trying to do is save your client's life. That's really what you're trying to do. You're just trying to find people who actually, because a death penalty case is already preloaded with guilt jurors. And so you're just trying to do that. So we, at least I think, managed to find people who were more equivocal, but still willing to give the death penalty, but not like, boom, you're convicted, you automatically get the death penalty. That always creates a little bit more of an open-mindedness there. And into that open-mindedness on those juries. And we had even like a lawyer's daughter on the thing there. So we had some smart jurors in the Casey Anthony case too. And I think the other thing is Jose was very good in that case. He was a great lawyer, and he really poked a lot of holes in the case.
Had a
And I
great
think there's-
forensics counsel.
Yeah.
with fantastic co-counsel with Linda Kenney Baden there, and all the advice that she gave. No, it's true. Linda helped so much with the forensic evidence in that case, and that was a huge deal with the Casey Anthony jurors. They were like, this, you can't tell. They had all this bogus scientific evidence that they put into that case, which the prosecutors used to try and convict Casey. Linda helped to actually debunk a lot of that, and Jose made a big deal out of that. And then I think, again, prosecutors overreached in that case.
I remember her name. I don't really remember the case. Where is she now?
Casey Anthony?
She's in Florida.
She's in Florida.
She's just free and okay. I don't really know much about it. Okay.
Yeah, she's trying to live an anonymous life down in Florida, which is.
Oh, she was near me. She would, because I don't really remember her.
Yeah. So, I mean, this is where, public opinion sometimes is right on this, but jurors, what happens is afterwards is jurors get into that trial, they are sworn into an oath, and they really take that job seriously of analyzing that, analyzing the evidence, thinking about the law and stuff like that. And that's why, I mean, look, a lot of the jurors in the first trial thought she should have been acquitted. And some of it, and yet some of those jurors really said, no, I would convict her on some of these charges there. So it really, I think part of it does have to do with what they were preconditioned, whether they came in with an inclination or one way or the other. Because I think jurors also try to be aware of their own biases, especially in these high profile cases.
I just want to chime in on our poll, which I put out there Wednesday after the evidence ended, and we're 93% not guilty on all charges. So, maybe we're pandering, to an echo chamber, but I think the number from wherever it's being polled is exceptionally beyond majority.
No, I think that's right.
Question. Why did the defense ask to put OUI on the jury slip? It was not on there previously. I don't think I thought they asked not to. I thought everyone didn't want lesser included. So I can't answer that, Michelle. I don't know the answer to your question.
Yeah, that's on that second charge, which to me, remember the first trial, that's what got literally hung, was that second charge, because it's so convoluted with all the lesser includeds. It's a mess. It gives such a weird series of degrees of guilt and action and mental, and both mens rea and actus reus. I don't know if they just, close their eyes and pick one ultimately.
So Richard, tell us. When you had this convoluted jury sheet, well, I can't make sense of it.
I know,
Michael can't make sense of it. We were looking at it with Jill. Your thoughts on whether a jury just ends up compromising that, or they really go to the issue of is there a collision?
So, it really goes two ways. There are people who just kind of go, if they don't believe it, if they don't believe the case, they don't believe the case. I'm there. But the truth is that all jury deliberations, if you've got some people in there who really think she's guilty on stuff, this is where the lesser includeds get negotiated, whether they understand the language on that or not. So oftentimes what ends up happening. For a
second, those lesser included. So the prosecutor, they arrest her and they bring her up on charges of what? Second-degree murder, which I told you I objected to right away because I don't think anybody thought she would have done it on purpose, even if it happened. But they did it anyway. And what was the other charge? They did include manslaughter originally?
Manslaughter with the DUIs original, and then leaving the scene.
So they have those two, and then the judge is allowed to add more?
Well, lesser includeds are almost always added unless there's a good reason not to. So that's why they're in this particular case. So the judge felt they were appropriate.
Because she probably thinks that the prosecutor had a weak case.
Well, it screams compromise. If they get into headlock
Is
territory,
that fair to the defendant? I mean, they came in with second-degree murder. So
it's not illegal. It's quite often an option for juries. And as a defense attorney, you hate it. You'd really rather have an all or nothing, because when things get jammed up, it's easy to say, okay, fine, Fine. I won't go with this, but I'll go with this lesser one. Just fine. It happens. Human nature.
And you were going to find out what the time she would serve if she was convicted of any of those.
Yeah, I'll have to look it up over the weekend. I don't know it offhand about what the penalties are for each of those and all. I was just looking at no collision, and to me the prosecution didn't prove it and just have text data which says there's text data, but it doesn't show collision because it can't show collision. To me, that's just.
And the prosecutor's witness said he couldn't 100% say collision.
Yeah.
And the fact that they didn't rope off the area with tape or anything, or look for any evidence of anything, kind of says that everybody on the scene of the crime also didn't think there was something nefarious.
So here's something that happens sometimes in deliberations, which is unfortunate for the defense. And it may not happen here, but one of the things that does happen, and we've seen it in a lot of trials, is that ultimately juries sometimes don't go by just what the verdict form is. They're like, which version do I more likely believe? It becomes a preponderance standard, not a beyond a reasonable doubt standard. As a matter of fact, when I was working on Phil Spector's second trial, which he got convicted, when we talked to jurors afterwards, jurors went, well, it just seemed more likely that the prosecution's explanation of what happened was the better explanation here. So that's sometimes what ends up happening, because ultimately, Jill, all you guys, it's about the story. This is ultimately what happens in the deliberation room, is they're going to have to put together a group consensus of what they think happened that night. And whatever that story is will lead them either to a conviction or an acquittal. There. And so that's really...
I think based on the evidence, I think based on the evidence, even the prosecutor doesn't know what happened that night.
Yeah, that's my argument.
And if you don't know what happened, that
what the hell happened? That's the reasonable doubt. But it's
so
Michael,
you see
that.
Yeah,
you know,
well,
that you see people actually reduce the burden to come to a conclusion.
So Michael, with that question with you, just to Richard, are they gonna, if everyone said they don't know what happened, will they make up a story, Richard, or what?
Yes,
they will.
Yes,
Oh,
they
boy.
will. I
Wow.
mean, the truth is that, look, we work in the law all the time. We hear about this sort of reasonable doubt. We hear about if they didn't prove it, then they didn't make their case and stuff. The truth is, with this much investment that jurors have in this case, they want to know what happened. That is just a natural human inclination.
And all we do is look at her the whole time and know that she's the only one in the room who knows what happened.
She's the only one.
I don't know that she knows what happened. How does she know?
She knows if she did it or not. Like,
true.
she knows if she did it or
That's
not.
true. But if she did not, Jill, if she did not, then how does she know what happened?
True, but she knows more than we would. And you weren't here for
I'll
this.
give you that.
But
I'll give you that.
I think there was something going on in the house, like with the kid and the drugs and everything, and that's why they didn't want to let him in.
And again, Richard, the key is the jury needs to know that's not their job. Their job is not to be creative writing the story. You know,
that's true.
Well, but Michael, the problem is in a vacuum. You're talking to people here.
Oh, I know.
You're not
I
talking
get
to
it.
lawyers and stuff. And so, yes, that's not their job, but yes, for them to resolve conflicts in the jury room, to answer questions that they may have, they sometimes do create a story. I hear it all the time when we're doing mock trials and focus groups, when we're doing post-trial interviews. Jurors all the time are saying things like, here's what I think happened. And that's because uncertainty is very uncomfortable, especially when you have this length of time and this kind of commitment, and a man is dead as a result of it.
Yeah, no, I get it. And it's up to the attorneys to try and pound that into them. But in the end, in that room, who knows? Hey,
I don't know.
Madeira Beach
let me give a
caregiver.
call. Yeah, let me give a call to Madeira Beach. Is in Moscow, Russia. She's a hospice nurse, and she is one of our big followers, and she loves Michael. I'm tired and cranky. Are there a lot of rules to go over at the beginning of deliberations that takes a lot of time? Otherwise, couldn't the foreman start out by saying, raise your hand if you think there's a collision. I'm throwing that to you, Richard.
Yes, absolutely. A foreman has pretty wide range of what they can do in here. And even though the judges said you shouldn't convict on the issues itself, a foreperson absolutely could go around and go, okay, who thinks there was a collision? Who thinks that whether she knew it or not? And he could go issue by issue. Who thinks she actually said, I hit him, I hit him, I hit him.
Yeah, that's a great question Madeira Beach has come up with, because it's not how would you vote. It's a very specific issue that will ultimately get them to a decision. But that's how things get resolved, is that kind of discussion, right? Because some people might have a reason for voting one way or the other, and they haven't thought it through. Well, why? Well, I'm not sure there's a collision. Well, then how do you get there, right? So that's a great question.
Yeah.
All right. Any other questions you have for Richard, Jill? Because this is the man. You heard him. He's
nice to meet you. No, I'm a frustrated lawyer. I should have been a lawyer.
her whole family are lawyers, by the way. But just like you, Richard's mother was a lawyer. It's still alive. I shouldn't say. Well, her whole family are lawyers too. So she said she's a frustrated lawyer on this case. But Jill's point is she would still vote because she thinks that we don't know what happened. That she'd vote not guilty, even though she thinks there may have been a collision.
I'm not 100% sure she didn't hit him. I'm not.
No, I don't know either. I have no idea.
I'm not 100% sure. Like, I'm not on the absolutely she didn't do it theory. I'm on the they didn't prove their case theory.
Yeah, exactly.
But to me, it's all about they have to prove it. And that's what I loved about Alan's defense, is that instead of trying to have this conspiracy of, if the car didn't hit him, this is what happened. He went in the house and he did this and he did that. Stop trying to prove all that stuff. It's too much for the jury. Did the car hit him or not? That's it.
Yeah, but that was a major change.
It was a major change, but he introduced it also. I mean, he created the thread there that jurors could pull on if they wanted to go with, here's what I think did happen, or here's an alternate theory. And from a defense perspective, you're always looking for a jury to kind of go, yeah, there's some other explanation for what happened.
What he's doing is he's focusing, like he said in the first 3 words of his summation, which is collision, 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 rather than, he went in the house and the glass came from the kitchen and he didn't have a shoe, he left it in the house and the dog bit him, and this and that. That's keep it on the car. And then if you believe the car didn't hit him, this is what happened. There is he did die, right? We all know he died. We all know he died. We don't know how he died. And in fact, the coroner's not 100% sure how he died. And
the coroner's 100% sure how he died, the fracture of the skull, but doesn't know what the circumstances.
The fall caused the fracture in the skull, right? What caused the fall, right? Was he dragged out of the house? Was he hit by a car? Did he drop dead of a heart attack? But the time of death wasn't 100%, and there's a lot of questions. Too many questions, not enough answers, and evidence that doesn't match up. The tail light, it was intact when it got to the garage, but then mysteriously it wasn't intact. They have a glass on the floor, but it doesn't match the glass that is in the car. Did it match his nose? I don't even know. So there's all these too many questions.
I think if Jill were on the jury, Richard, you have your defense juror, even if she may have thought there may have been a hit. So I think we have the answer to that question. How would you vote if you're on the jury? I assume you'd vote not guilty because you don't think the prosecution proved it, right?
That's what Alan wants. Alan wants them to say, you have to, and that's what he said in his summation. They have to prove that she did it. I don't have to prove she didn't. Do you think that the fact that she didn't get on the stand to testify hurt her?
No, and I'll tell you why. And these guys know it very, very clearly. When you are a defense lawyer, you don't want your defendant to be the focus of the case.
That's it.
You want the prosecution to be the focus of the case.
My next question: Do you think she should have spoken and done these interviews and documentaries, or not?
No.
Do you think she asked a lawyer or told a lawyer she was going to do them and didn't give a shit and did it anyway?
Yeah, I think she was more careful than some, but you obviously saw Hank Brennan used some of those words in the interviews and stuff. So it's always problematic.
But if she didn't do the documentary, I don't think she would have gotten so many people interested. And I don't think she would have been able to raise all that money that she did for her defense and this whole pro Karen Reed thing. I think that probably came from the documentary. I'm assuming some of it.
Well, it didn't hurt. I mean, she had a massive following before that was released, so it definitely probably grew the following and cemented those that believed. Because I like to think I was objective when I watched it. I don't think it came down overwhelmingly for or against her.
I agree with you. I do agree with you. I don't think it was one way or the other. My next question is, so whose book is coming out first? Her book, the lawyer's book, or the jury's book? And
I bet on jurors. Yeah.
Jurors' books. And how
That's
many
what
do
I
you
bet.
think there'll be?
Oh my gosh. I would say more than one. That's all.
What's the most that's ever come from a jury that you know of as far as books and people talking about the case? OJ, did his jurors write it?
Yeah, his jurors, and OJ had the most books, period, just because everybody wrote a book about that damn
Oh, I
trial.
didn't realize that. Really? Okay.
Oh yeah. Well, it's not not the jurors themselves. There were only, I think, 2 or 3 jurors in OJ that wrote books, and partly because the Madam Foreperson had 3 jurors that contributed to that one book. But obviously, every lawyer affiliated with that case wrote a book about the case.
So did Judith Regan.
Yeah, well, everybody wrote a book.
No, a friend of mine. No. She had a whole interview. No, she had a whole show that she filmed with OJ, and the book was I did it, or I said I did it. Anyway,
If I did it.
If I did it.
If I did it.
He says she's a friend of mine. He said he did it, and she had it all, and she had the interview, and Fox made her kill it, and the books got burned because the family sued or threatened to sue the Goldman family, so they had to burn the books or something like that. Anyway, crazy. That was crazy. He did it, but anyway, another story, another day. He said he did it. He's not saying he did it. He said he did it.
Well, I always said, and he did his last interview ever with me, and I said he's the nicest killer I ever met. So
nobody says they're bad guys.
So, Richard, any predictions on how long this jury will be out? Read the tea leaves.
I don't think that, obviously, I don't think they're going to be back today. I think I would say it's hard to read tea leaves. I'd say I would say either Tuesday or Wednesday is probably a good estimate right now.
Interesting.
That allows them to go through the evidence and to solidify whatever the factions are. Obviously, the thing that determines it is whether 2 things. One is either if they're just incredibly detailed, because I have seen juries that really want to go over every little piece. They want to hear all the testimony. They want to see all the evidence again. And that obviously prolongs this thing. Or if there's divisions, and that can take longer too.
Do you think
if they're a quicker case, if they come back Monday, does that mean a guilty or not guilty generally?
I would think more of an acquittal.
Not guilty. Yeah. Not guilty is a lot easier to say. The guilty, you have to go through it all and all and all and all. Do you think they should have been sequestered?
It's the horse is out of the barn on this. It's like there's so much been out there even prior to this trial, that sequestering the jury.
Do you think they should have been serving this weekend and deliberating tomorrow and Sunday to get this over with?
Not necessarily. I mean, the truth is they've invested a lot of time on this thing. I think, and so getting it over with really shouldn't be an option for the jury. It needs to take as long as it takes.
No, I know. To me, it's like we started at 2:00 today. We just started, and now I've got to wait till Monday. Like,
sometimes jurors
work on this.
Jill's hardcore. I want sequestration. I want weekends. Come on, let's get this. Let's go.
I want focus. This is my life. I mean, that's what I want.
No, I mean, I don't think that they should sequester them. I don't think that they should force them to deliberate. Sometimes jurors ask that themselves because they actually are getting somewhere on things. But I don't think, I just don't think that, it's fine to be able to go, hey, we're going to spend a few hours. We'll think about it over the weekend and come back and talk on Monday.
Well, poor Karen Reed, right? Poor Karen.
Depends on whether they acquit her or not, I think.
It's almost like one way. If I was her, it's like, I want to know if I'm going or I'm not going. It's this in-between thing that's got to be very hard for her every night. She doesn't know where she's sleeping. Like today, she woke up and said, am I coming home tonight? Like if she was guilty, it's 4:00. They're going to, can you tell me, are they going to handcuff her and take her away? or do they give her bail until sentencing?
We've talked about that. I'm guessing custody. That's my guess. Depending
That's my
on
guess,
whatever the conviction might be. If it's on the lesser charge, maybe not. But I think more likely than not, they'll revoke bail and take.
You know, I feel for her. I feel for anyone. You know what I mean? Like that's a tough. It's tough.
Yeah, no, the whole thing is tough. But Richard, you are the man. You explain everything to us. We're going to have to get in another time as to Hank Brennan. And I thought it was interesting. One of the things that we didn't talk about, because I know we have to go in about 4 minutes, was the issue of the fact that Hank Brennan had used Dr. Loposada, had hired her twice, and the Commonwealth had hired her in the Turk case where they got a conviction 2 weeks ago. So they both had an investment in her. And I was wondering whether you think that Hank Brennan's cross-examination then was less on her because of that. Just your final thoughts on that issue.
Who was she? Can you just tell me who she was again?
Dr. Loposada, she was defense medical examiner, defense forensic pathologist.
If he was easier on her, I would imagine. Look, it's all relationships. We all have relationships in here. So if he was a little softer on her, and because he's used her in the past, and he may want to use her in the future, he's a defense lawyer now and things. So he may need her in the future and stuff. So, and obviously there's strategic calls too about whether, do you think, do I need to go after her that hard? So there's a lot of sort of on the ground decisions on that, but the relationship clearly could have made a difference.
I mean, if they were concerned, they could have had Lally cross-examine her, but obviously they felt it was more important, even with that baggage, that Brennan cross-examine her. So,
yeah.
Richard, thank you for your time.
Richard, great job. You stood up to Jill's withering examination as well. So, glad you could join us.
I've been working with lawyers for 40 years, so I should have a thick skin by now.
Jill, thank you for joining us. We really appreciate it.
So much, guys.
It's been a fun. I have to say, it's been the most fun 2-hour panel I've ever had in covering this case, because it not only was it entertaining, but it really showed some real world stuff. And I think hopefully all the viewers that are watching got some real world knowledge. So we're gonna cut you both loose.
All right.
Thanks, guys.
You guys have a great weekend, and let me know if you want when this whole thing wraps up.
We'll talk Monday, perhaps. Jill.
Take care, everybody. Thanks a lot.
Take care.
Richard, love you, buddy.
Oh, that was fun.
Richard, he didn't know what he was getting into. But that was really good. Those were really good questions to ask. That people want to know. They were great questions.
That's for sure. And it's very interesting to get the perspective, even though she admits, she's not as knee deep, waist deep, neck deep in this as some people might be, which is probably more representative of a jury member, right? If the jury members were honest in their voir dire process.
Right.
So not every single detail is known or exactly right, but the questions are still the core questions, right?
They were great questions. And Richard, you see how great he is. He knows he's been doing this for 40 years.
Wait, I have to fix this. Can I fix this? There we go.
There you go.
That's better. Obviously he's a pro and he's been in the trenches with you and otherwise. And so,
So anyhow, before we say goodbye, let's just talk. Can you all hit like, subscribe, share? Right, and all for everyone donating their time on this show tonight, especially subscribe. And if you're joining us from X, which some of you have been, come over to our YouTube page where you will hit like, subscribe, and share. And we'll be, I guess, back at this Monday, huh?
Linda, it's the YouTube channel is just down the hallway. Go past the bathroom. Just go, and then you can come back to X if that's where you're going to go. It's not a big deal. It's very simple to do. So please do that.
I really like Richard. I'm actually going to take a screenshot of that.
Harley 62.
Yeah, because I really like him too. Okay.
Yeah, he's smart, and obviously he knows juries and the importance and the vacillation. I mean, jurors they're like an organism. Everyone is a little different. So we'll see what happens with this one. Did we get a total time? Did they do about 2 hours roughly, maybe less than 2 hours?
I don't know. I think
they came back into court.
This is another one. Richard is the jury daddy. Oh my goodness, great!
Right.
See, I told you he's great. I did want to hear more about why he thought because what I've been saying, Hank Brennan is a good lawyer. You know, and I know it's an unpopular opinion, although I didn't like some of the ethics at the end with regard to it. But
yeah,
45, 1 hour and 45 minutes.
Hour and 45. Yeah. So that's enough to get in there, you know, vent a little bit, maybe paw through some of the evidence, you know. And I think that it sounds to me like as a group, they probably said, okay, let's just dig in on Monday. Anybody want to stay here late on a Friday night? No. You know, and then let's just call it. And it has been a long week for them, even though they had yesterday off. Are they really, you know, is it really a day off when you know what's pending? Not so much.
No, it's you know, and they're probably tired, and I think that was is really, you know, is really great. I mean, Richard was a big hit on the show along with Jill. You can see all the comments that he's really lovely. He's wonderful to work with, as you know, and I think he gave us some good information about what the jurors do. I mean, you know,
for sure.
I was surprised they're going to go in there and make up the story anyhow. Yeah,
that is discouraging. But you know, I live in a Pollyanna world. You know, I like to think people will actually, you know, follow the rules, not just come up with whatever they think they need to get to a conclusion. A little naive, but I keep clinging to that. So we'll see what this jury does.
So are you going back to, before we go, are you going back to, you're
I'm
coming back on Monday? Okay. So Monday,
I guess. I'll come back Monday.
All right. So Monday we'll be on, and a lot of kicking around time. I'll be on then with you too. And we'll be running some of the videos, I mean, that you ran today, that you picked up all the interviews. We'll be running them as we wait. And we did have Stephen Plord on standby. It was supposed to give him 10 minutes notice, but I made the call to bring him on Monday because I think that it was 6 o'clock. It was time, and I didn't want to, you know, hopefully he'll be on when we have a show. We'll bring him and Neil on and some other people on Monday.
We should, we'll have a production meeting at some point, but you know, do we have to be on at the crack of dawn if they're just getting together?
I think they're going to have a question right off the bat. I think
they could.
Right. When juries come back after the weekend, they have a question usually.
And sometimes they gather, you know, officially before they go in to deliberate. You know, the court kind of recognizes they're here. Roll call. Have you done anything? Have you looked at anything? Have you talked to anybody? And then sends them off to deliberate. So whatever is happening, we will have it.
Yeah, we'll absolutely have it. So we will let you know with the thumbnail. Obviously, go hit like, subscribe, share, and then notify. And you'll get notice that we're on with the Crack of Dawn. Probably, Michael, we will be on the Crack of Dawn because you're going to be there.
I'll be driving at the pre-crack of dawn. Yeah.
The pre-crack of dawn. I want to say, and go to the videos that Michael posted today. Michael, anything you want to say? Because you did post a lot of videos. I think you should
just kind of a slice of the day. You know, you'll see in the different videos people's reactions as they got ready for closing arguments, post-closing arguments, post no verdict. I think it's interesting just to hear what the real folks have to say. Of course, the Aiden Carney interview is in there, as well as Cheech, some of the regulars, and folks who have flown from halfway across the country just to see what this is all about. So that's the goal, just to kind of showcase what's really going on here. So, it's another siren to play me off. Okay, I'm Michael Bryant. Try to do the right thing.
And have a happy Father's Day for all of you that are in the chat. I'm Linda Kenney Baden. Like, subscribe, share, notify. See you Monday.
On the